10's list. Sugar factory has been completely shut down. There have been 4 instances where fires have been set inside the factory because we are unable to make payments. May I request your lordship to kindly take up that matter?
You mean the other court?
Yes. Serial number 124.
I will take it up. Yes, next. Serial number.
124.
Yeah,
My lords, Court Hall 10, my lords. ED has attached properties worth 141 crores. Subsequently, after the attachment, I have earned income for which I have to pay income tax by tomorrow. I am asking for this court to give a direction to the ED from the amount seized to pay tax to the government, my lords. If this matter can be listed tomorrow, it's a fresh matter, my lords.
ಇದು ಆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬಂದಿಲ್ವಾ? ನಾಳೆ ಇದಾರಮ್ಮ ಸಿಟ್ಟಿಂಗು? ಇದು ನಾಳೆ ಇದಾರಲ್ಲ, ನಾಳೆ ಕೊಡ್ಬೋದಲ್ಲ?
Please, obliged.
We have for the auction purchaser, the auctioners, we have paid 1.5 crores of check, Your Honor, but that has been untraceable, and the auctioneer is planning to auction it again on Friday, Your Honor. So we request for Tuesday posting it.
Tomorrow?
No, Tuesday, Your Honor.
Tuesday?
Tuesday.
Tuesday.
Thank you.
My lord, I am for the respondent, my lord. Review petition, my lord, in the petition in WP 10982/2018 and connected 50155/2025. Veerappan, my lord, Forest Department. Review petition in state government has filed the review petition, my lord. I have filed the statement also, my lord. Tomorrow, my lord.
ಆಯ್ತು ಕೊಡಿ, ಯಾವತ್ತು ಬೇಕು?
Tomorrow.
Tomorrow
Monday.
ಯಾವತ್ತು ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದೆ ನೋಡ್ಕೊಡಿ.
So one matter was where I have sought for compensation, where the highways have utilized lots without there being acquisition. Your lordships have directed to secure a report.
Fresh matter or?
It's a fresh matter. Your lordships directed to secure report. Report has come, lords.
Group matter, date given already. It's a date given matter, but the same is not been listed.
This court or other court?
Present court.
Okay.
Monday may be given.
Total 10, serial number 81, we made an application to imprint the pollution control board as a respondent. We kindly permitted to serve the panel advocate.
Yeah. Portfolio missed. Yaru, who is the panel?
Serial number 81.
Yaru.
Pollution control board.
Who is the advocate?
I am the panel advocate.
Yaru, our receive ಏನದ್ರು?
I will ask and serve.
ಗುರುರಾಜ್ ಜೋಶಿ ಬರ್ತಾ ಇಲ್ಲ ಕೋರ್ಟಿಗೆ. ಮಹೇಶ್ ಚೌಧರಿ ಬರ್ಕೊಳ್ಳಿ. Mr. Mahesh Chaudhary is directed to accept notice for respondent number.
Proposed respondent. Proposed respondent.
Serial number 81 ನಾ?
ಹೌದು.
ಆಯ್ತು.
ಸ್ವಾಮಿ
ಇದ್ರೆ ನೋಡಿ.
ಸ್ವಾಮಿ ಲಿಸ್ಟ್ ನಂಬರ್ 1 serial number 26.
ನಿಮಿಷ ತಿಳ್ಕೋಬೇಕು ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಂಗ್ ನಡೀತದೆ ಅಂತ.
Writ petition 2017 matter, my lord. On date may be BDM.
ಕೊಡಿ.
Portal number 10, serial number 7, fresh matters. Kindly post it.
Tomorrow. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇವತ್ತಿಂದಲ್ಲ ನಾಳೆಗಂತ ಯಾವತ್ತಿಗೆ? ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆ ಬರುತ್ತೆ. ಇವತ್ತಿಗೆ ಬಂದಿರೋದು ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
Land acquisition matter 2021, my lord. KADB informed that they are returning some developed area. On that basis, it may be disposed of, my lord.
Yes, one date put. Monday ಬರುತ್ತೆ. ಆಸ್ತಮಾ ಒಳ್ಳೆ ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ? ಎಲ್ಲಿ?
Daily he need to go for the hospital and he used to regularly check up in the native place. Now he has been extended.
ಬೇರೆ ಕಡೆ ಇಲ್ವಾ ಆಸ್ತಮಾ ಟ್ರೀಟ್ಮೆಂಟ್?
Daily check up alle.
ಆಯ್ತು, ಮಂಡೇ yes. No, not tomorrow.
Not
tomorrow.
Submitted.
What are the allegations against you?
Only theft case, not only one case is pending, not rest of the cases.
ಎಷ್ಟು ಕೇಸ್ ಮಾಡಿ? ಎಷ್ಟು ಕೇಸ್?
No cases at all, my lord.
ಎಷ್ಟು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿತ್ತು? ನಿಮ್ದೆಲ್ಲ ಅಕ್ವಿಟ್ ಆಗ್ತೀರಾ? ಎಷ್ಟು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿ?
One case has been acquitted, my lord. One case is pending, that is.
Only 2 cases.
2 cases, my lord. Rest of the 107 of.
ಆಯ್ತು, ಮಂಡೇ ಬರುತ್ತೆ. ಮಂಡೇ ಎಷ್ಟು?
Serial number 43, my lord. Portal number 10 is posted for preliminary hearing.
It will come if it is for preliminary. It's not a fresh matter. It will come for preliminary hearing only.
Yeah.
discuss court hall number 10.
You want it to be taken? You want it to be taken?
Yes.
What is the urgency?
This is a tender related matter where my petition was disqualified. And we want actually interim relief so that they don't go for fresh tenders immediately.
Financial bids are already opened.
So the tender is cancelled.
Huh?
The tender is already cancelled.
Uh,
They are going for fresh tenders.
uh.
But we want an interim order.
So it will come on Monday. It will come before the same court on Monday.
Serial number 43.
43 Monday. No.
On matter for
Court hall number 10.
for this reason.
Huh?
Preliminary notification 2008, not 2010, final notification. 2025, they have passed the order. Now they are taking position, notice was issued. Now they are taking position and making interim order
Monday.
Monday.
So
The
my lord,
other matter is that,
submit,
other matter is space sites, your lordship has passed the order.
Good Monday. Day sites will come up on Friday or Thursday.
Today, the matter is posted today, the other matter. I request the honorable court to connect matter, but it was not posted.
It's all memo.
Monday.
Lord, submitted the memo to, this is the matter tomorrow, if not on Monday, my lord.
Which one?
The memo has been submitted for 10.
Fresh matter.
No, old matter, my lord. Because the urgency is we need to change the father's name because the documentation is not happening in that. We need to change the father's name, so the documentation is not happening. It's an old matter that is
Come up on Monday.
Monday, my lord.
Monday. A quotal 8 then. No, 10.
National highway acquisition.
Sir, wait.
Highway acquisition matter, Your Lordship.
Ah.
It's covered by judgment.
Told yes. Correct, adjournment.
Yes, sir.
There is a procedure in this court. You should follow the procedure. You should ask somebody, what is the procedure in this court? Anta? Oh, you can't simply come in like a bull. Yes.
Quotal number 12 matter, adjournments phase wise. Page number 6.
Quotal number 12 ಯಾಕೆ move ಮಾಡ್ತೀರಾ? Quotal number 12, yes.
Page number 6, serial number 17 to 21. Page number 7, page number 8, serial number 22 to 24. Page number 9, serial number 25 to 27. Page,
Serial number 26.
Now you understood? Objection?
Any date fix, my lords, ship have. Heard the matter, my lords.
No, sir. No, sir. ಅಂದ್ರೆ ಇಲ್ಲಿದೆಯಲ್ಲ ಇಲ್ಲಿ.
Instructions declined. So like two weeks of.
Mister, you have taken time on 25/6/26, again on 2/7/27, again on 16/7/27, sorry, 26. Today again you want time, 4 times consistently. Yes, 2,000 rupees. Learned counsel for the petitioner again seeks time. This court has, it is seen from the order sheet that the petitioner has consistently taken time. And therefore, the request for adjournment is not justified. Nonetheless, as a last chance list on so subject to payment of cost of rupees 2,000 payable to the Advocates Clerks Association.
Any short date may be fixed.
List on date.
10th August. 10th August. Page number 10, serial number 28.
28. My lord, this matter.
I don't remember.
Mr. Prakash, Rajan Shivatsan, we had argued.
We had argued this matter.
Till that modified award stage. So we have now filed.
I'm for the petitioner, my lord. Senior is online. I'm for the petitioner, my lord.
No, if
So
I
this is
already.
a matter where, my lord, we have now filed. a writ petition.
Oh, that case.
So, my
I'm
lord,
for the
may I
petitioner
request
in the
you
first
to-
matter, my lord.
Along with
We
this
had argued
matter,
it
provide the
extensively
FR
last
number.
week.
Petition.
Now they have filed
Huh?
a district petition challenging.
Some
the
fresh.
award.
Whatever it is.
Yes.
That also has to be answered if they filed a writ petition.
Please, please.
My lord, 7th.
ಯಾವತ್ತು ಬಂದಿದೆಯಾ ಇವತ್ತು?
ಇವತ್ತು.
You filed a fresh petition.
Fresh petition. That is FR number 23,924.
So list along with ಅಂತ ಮಾಡ್ಬೇಕಾ? List along with the WP number so and so.
I'll just give
Can
the
it
number.
be on 7th of May?
ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ. Yes.
Serial number
Can it be on 7th of August, my lord?
Serial number?
17. I'm sorry, 7th.
29.
29. I appear for the petition, my lord. The commissioner's report has been filed. I'll seek instructions. 10 days time may be given and a date may be fixed, Your Honor.
The report, the learned counsel for the petitioner seeks time to secure instructions in the light of the report submitted by the commissioner. When do you want?
7th.
List on ಯಾವತ್ತು?
7th.
Any date after 10 days.
One date ಕೊಡ್ರಿ. Pages.
12th August. Page number 12, serial number 35. Page number 13, serial number 36 to 40.
36
Page number 14, serial number 41 to 45.
Number?
39.
36.
36, what?
I appear for the petitioner, my lords.
Petitioner. The learned counsel for the petitioner seeks time, list on so and so.
Serial number 39.
39, list on so and so.
17th August.
Interim prayer release ನೋಡಮ್ಮ extend ಮಾಡಿ. Yes.
My lords, serial number 42, my lords, for petitioner, my lords. 6 time, my lords.
Learned counsel for the petitioner seeks time, list on
Interim
so
order
and
is
so.
there, my lords.
Serial number
42.
Interim order granted or release extended till the next date of hearing.
August.
Page
15, serial number 46 to 50. Page number 16, serial number 51 to 56.
My lord, serial number 53, my lord, for the petitioner. Seeks for a week's time, my lord. Senior.
What about this cost of 2,000?
Cost, it was imposed on the respond number 1 and 2, not.
Whoever has to do it.
I've paid the cost.
The learned counsel for the respondent 1 and 2 has submits that he has paid the cost. He has furnished a
Please, my lord.
acknowledge. He has furnished a receipt. The same is taken on record. Is called. Yes, next. List on so and so.
Right, my lord.
Learned counsel for the petition seeks time. List on so and so. Yes.
12th August. Page number 17, serial number 57 to 61. Page number 18, serial number 62 to 67.
Petition serial 57 minutes.
Ah.
There was a direction by this court, one direction, as to whether they're interested in acquisition or not. They have not filed any.
ಕೇಳ್ಬೇಕಲ್ಲ ಅವ್ರನ್ನ ಗೋಪಾಲ್ ಬಿಳ್ಳನ್.
ಅವ್ರಿಗೂ information ಕೊಡ್ತಾ ಇಲ್ಲ. I have also applied for right to information act ಅಲ್ಲಿ. ಅದು ಕೊಡ್ತಾ ಇಲ್ಲ. I have filed an appeal. 10 days time will be granted.
This for acquisition for nice is it? But ಏನೋ division bench ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ.
No repercussions ಅದು ನೋಡ್ಬಿಟ್ಟು ಮುಂದೆ ಒಂದು 10 ದಿವಸ 15 ದಿವಸ.
The learned counsel for the petitioner seeks time, list on so and so.
My lord's kind permission.
Yes.
Matter for being spoken to, my lord, sir.
ತಗೊಳ್ಳಿದೇನು?
Court officer. In fact, 2 days back, the matter was listed before this honorable court, where my lord was pleased to grant interim order. But earlier, 2 writ petitions were listed, which is of the same line.
Interim order was granted?
Yes, interim order was granted day before yesterday. Not wherein the subject matter involved in my writ petition is also recorded in the interim order at para 4, my lord, wherein in the verge of actioning Karnataka.
ಯಾವ್ದು?
Serial number 25.
ಹಾಕ್ಬಿಟ್ಟು. ಯಾವುದು? ಮಾಡ್ಸಿ. ಅವ್ರದೇ ತಗೊಂಡ್ ಮಾಡ್ಸಿ. ನೆಕ್ಸ್ಟ್ ಕರೀರಿ.
25. Page number 19, serial number 68 to 70. Page number 20, serial number 71 to 73.
Yes.
This number 1 for order, serial number 1. Sangmesh RB.
Sangamish. Memo for retirement filed by advocate for petition. Yeah. The memo for retirement filed by Mr. Parvati, Mrs. Parvati Nair and CM Raghunath is accepted. What about 1.1? That also?
1.1 I have filed, my lord, sir.
ಅಲ್ಲ 1. ನೀವು 1ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಿರೋದು 1.1 ಅಲ್ಲಿ ಬೋಪಣ್ಣ PC ಶ್ರೀವತ್ಸ ಅಸೋಸಿಯೇಟ್ಸ್ ರೆಡಿನಾ? All of you ready?
Any date, your lordship, it may take a little lengthy hearing, lord, sir.
ಅಲ್ಲ ನೀವು
Date,
ರೆಡಿ
your
ಅಂದ್ರೆ
lordship.
I'll take it up in the afternoon.
Not today, my lords. Not today, my lords. Any day after 4 or 5 days.
List on so and so.
Very well.
Learn concept of the petitioner seeks time, list on so and so.
13th August.
Huh?
13th.
ಕೊಡಿ ಯಾವತ್ತು ಬೇಕು
13th August.
Obliged.
Serial number 2. Jagadish Gowda.
In terms of
ಮೇಡಮ್
the
ಇದು
order dated,
1.2 ನಲ್ಲೂ ಅಷ್ಟೇ NOC ಅದು ಆಫೀಸ್ ಡೈರೆಕ್ಟರ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ ಶ್ರೀವತ್ಸ ಅಸೋಸಿಯೇಟ್ಸ್ ಪಾರ್ವತಿ R Nair and CM Raghunath. Yes.
Serial number 2. Jagadish Gowda.
in terms of the order dated 10/7, my lords, we have approached BDA along with the requisition and the draft cancellation sale deed. Adu once 2 plots got regularized, my lords. In addition to that, she was also allotted with an additional site. Therefore, your lordship suggested yadaru one surrender madi. We have therefore, in terms of the said order, we approached BDF seeking for cancellation.
My lords, we have filed our memo for retirement for R3, my lord.
R3 ಏನಾಯ್ತು ಅಂದ್ರೆ, my lords, R3 was the complainant. Your lordship last time ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ನಿಮ್ ಕ್ರೆಡೆನ್ಶಿಯಲ್ಸ್ ಎಲ್ಲ ನೋಡ್ತೀನಿ, ನೀವು ಇವ್ರೊಬ್ರ ಮೇಲೆ ಮಾತ್ರ ಏನಕ್ಕೆ ಈ ತರ ಮಾಡ್ತಿದ್ದೀರಾ?
We filed the memo of retirement, my lords, and we have given all the files to the client as well. So maybe taken on record, my lords.
No, you
Personal vengeance ಗೆ he started
keep your client present before the court.
My lords, but we filed the memo of retirement.
Keep your client present before the court. You have his contact number. You please tell him to come before the court. Yavat? Yes, madam. They are willing to return a site.
Please, my lord.
ಅದಕ್ಕೇನು?
ಅದಕ್ಕೆ ನಾವು acknowledgement ಎಲ್ಲ ತಗೊಂಡಿದ್ದೀವಿ, ಅವ್ರ ಕೋಆಪರೇಷನ್.
When will you decide?
ಒಂದು ಡ್ರಾಫ್ಟ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಸೇಲ್ ಡೀಡ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಬಿಡಿ.
When will you decide?
I will seek instructions ಮೇಲೆ ಕೊಟ್ಟಿಯಾರ ಇಲ್ವಾ?
The learned counsel for the petitioner submits that in compliance with the direction of this court dated 10/7/2026, the petitioner has appeared before the Bangalore Development Authority and also indicated her interest to cancel the sale deed dated
9/5/2022.
9/5/2022. He submits that she has also handed over a copy of
9/5/2002.
2002. He submits that the petitioner has also handed over a draft of the cancellation, deed of cancellation to the authority and that the authority is yet to take a decision. Hence list on yavathu bekildi.
My lords, our name may be deleted, my
No,
lords. We'll
madam.
inform
You
the
please
client.
keep him present, only then we'll delete. Otherwise, we'll not delete.
ಎಲ್ಲ ಕೊಡ್ತೀನಿ.
Will not permit you to retire. Because on the last date, I remember this case. You are this man's son's friend or this lady's son's friend.
Man son's
No, my lords.
Man or lady, no.
lady ಸಂಪೂರ್ಣಮ್ಮ son's friend.
Sampurnama's son's friend.
ಅವ್ರ ಅಲ್ಲೇ ಟೆನೆಂಟ್ ಆಗಿ ಉಳ್ಕೊಂಡು ಇವೆಲ್ಲ ಮಾಡಿರೋದು.
Tenant ಆಗಿ ಇದ್ಕೊಂಡೇನೋ ಅವ್ರ ಮೇಲೇನೆ ಕತ್ತಿ
My
ಮಸ್ತಿದ್ದೀರಾ?
lords, last time senior had made the submission that the R3 was a activist
Let him
who's
be an activist.
who's not
We'll ask him.
related to any of the petitioners, my
No,
lords.
that is
Was the
right.
instruction we
Madam, if
received.
he is an honest person, if he is doing some good to the society, we'll respect him. But if he is a mischievous person, we'll accordingly punish him. So keep him present. Now that he has appeared before the court, he has filed the application to come on record.
Application it is.
ನೀವೇ ಬಂದಿದ್ರಲ್ಲ.
My lords, but my instruction was that we filed the retirement memo.
You have taken the risk of entering the lion's den. So whether you get caught, whether you are eaten up, it is left to you. Once you enter the den, you have to fight it. Fight the lion.
Obliged, my lords.
Yes. ಯಾವತ್ತು?
ಶಾರ್ಟ್ ಡೇಟ್ ಇರಲಿ.
Take whatever date. Yes, madam.
days ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಇರಲಿ.
Next week,
Learn
ma'am.
counsel for the respondent number 2 seeks time to secure instructions. List on so and so.
13th August.
Mr. B.R. Vishwanath,
Number 3, B.R. Vishwanath. Serial number 3.
non-filing of affidavit by advocate for R2.
My lords, this is the
Who is
disposed of.
supposed to file the affidavit?
My lords, the BDA authority has to file the affidavit. My lords. My lords, this matter may kindly be clubbed with my lords WP number 6652 of 26, my lords. Adrallu tavu order madidara. Stay sites.
Counsel for the respondent submits that this petition may be taken up along with WP number
6652 of 26, my lords.
26. Hence, list this petition along with WP number so and so. Who is supposed to file the affidavit?
My lords, BDA.
What is that affidavit?
My lords, regarding stray sites, my lords. So stray sites ಎಲ್ಲೆಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಂತ ಒಂದು ಡೀಟೇಲ್ ಆಗಿ ಅಫಿಡವಿಟ್ ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ರಿ ತಾವು. ಅದ್ರದ್ದು my lords, even in WP number 6652, my lords, similar order is passed.
That was in HBR layout.
My lords,
that was in HBR layout.
That's in 66. Common direction was given in 6652. Directing to consolidated.
But facts are different in that and this.
My lords, ಇದು dispose ಆಗಿದೆ my lords.
ಯಾವುದು?
This present writ petition.
This petition is disposed
yes, please, my lords. 3 months time has been granted to the authority to allot a site.
Is this along with WP number so and so?
Please.
Serial number 4.
Sarvana. Mr. S. Sarvana.
Respond on this.
R3.
Seeks for weeks time to take steps.
Pay the process today, Mr.
Will comply with today itself.
Do it today. And counsel for the petition undertakes to pay process and deposit other requisites to issue notice to the unserved respondent number 3. If process is paid, office director to issue notice to the respondent number 3. If process is not paid, the petition shall stand dismissed as against respondent number 3.
Serial number 5. Sarvana S.
I pay for the respondent. Lord, there is some direction on the last occasion.
Memo regarding submission of report.
Lord, subsequently, my lords, on the last occasion, it's regarding the identification of the boundaries and identification of sites. Lordships have directed the BDA to identify and mark the boundaries and show it to them. My lords, we have identified the measurement has taken place. ಒಬ್ಬರಿಗೆ ಒಂದು alternate site ಕೊಡಬೇಕಾಗಿ ಬರುತ್ತೆ. our instructions ಇದೆ ಅವರಿಗೆ owner of site number 90A ಗೆ he has also agreed. We will identify the site. We'll try to do it in the very same layout, my lords, or in the next subsequent layout.
You will.
We don't have a copy of the report.
No, no report is submitted. Lordships have
They have identified some. What is your site number?
Site number is 90A and 90B.
Ivrda.
ಇನ್ನೊಂದು ರಿಟ್ ಪೆಟಿಷನ್ ಇದೆ 90C. 3 sites ಅನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ಕೆ ಹೇಳಿ. ಅದರಲ್ಲಿ ಒಂದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಒಬ್ಬರಿಗೆ ಆಲ್ಟರ್ನೇಟ್ ಸೈಟ್ ಕೊಡಬೇಕಾಗುತ್ತೆ.
So 90C ಕೊಡಕ್ಕೆ ರೆಡಿ ಇದ್ದೀರಾ?
90A ದವರು ತಗೊಳಕ್ಕೆ ರೆಡಿ ಇದ್ದಾರೆ ಅಂತ ನನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ. I don't know whether he has got instructions.
I will take instructions.
We will identify the site, my lords. We'll try to do it in the same layout or in the subsequent.
The learned counsel for the respondent submits that the boundaries of site number 90/A and take whatever date you want.
Net months. They were 5 sites are totally being allotted in the months. A, B, C, D, E. D and E is in 2009 months. A, B, C, which is our.
That's being clarified. That's being clarified. ಒಬ್ಬರಿಗೆ ಒಂದು alternate site ಕೊಡಬೇಕು.
D
is not subject matter of auction. Subject matter of auction is 90A, B, C and D. ಈಗ ನಾವು A, B and C are D, all the 4 sites are identified. ಅದರಲ್ಲಿ 90A ದವರಿಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸೈಟ್ ನ 2009 ಅಲ್ಲಿ ಬೇರೆ ಅವರಿಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವರು ಮನೆ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಅವರಿಗೆ ಒಬ್ಬ 90A ದವರಿಗೆ ಒಂದು ಅಕಾಮಡೇಟ್ ಮಾಡಬೇಕು.
If you get a better site, why not?
Let them give their proposal.
Preferably the same facing, east facing, the east facing ಕೊಡಿ, west facing.
ಅದು ಅದೇ
ಈಸ್ಟ್ ಫೇಸಿಂಗ್ ಬೇಕು, ವೆಸ್ಟ್ ಬೇಕು ಅಂತ. ಸೊ ತಗೊಂಡೋಗಿ ಈಸ್ಟ್ ಅವ್ರಿಗೆ ಸೌತ್ ಕೊಡಬೇಡಿ. This next.
The proposal they might give us a whatever they're proposing, they might give us a
Please tell them in advance so that they will accept it.
The engineer is in contact with their owner, my lord. My engineer is only instructed.
Give him a site which he can take. Don't give him a site which he will refuse.
No, ಆ ಲೇಔಟ್ ಅಲ್ಲಿ 19 ವರ್ಷದ ಹಿಂದಿನ ಲೇಔಟ್ ಅದು. We are searching for the ನಿನ್ನೆನೆ ಡೆಪ್ಯೂಟಿ ಸೆಕ್ರೆಟರಿಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿ ಟ್ರೈ ಮಾಡ್ತಾರೆ. ಅಲ್ಲಿ ಟ್ರೈ ಅದಾಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಲೇಔಟ್ ಅಲ್ಲೋ ಇನ್ಯಾವುದ್ರಲ್ಲೋ ಕೊಡ್ತಾರೆ.
ನೀವು ಅದೇ ತಪ್ಪು ಮಾಡ್ತಿದ್ದೀರಾ.
ಹಳೆ ಲೇಔಟ್ ಅಲ್ಲದೆ ಇದ್ರೆ
ಅಲ್ಲಲ್ಲ ಸರ್ ಅನ್ನಿ
ಸಾರಿ
ಸರ್ ಅನ್ನಿ ಇದು ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ಕೋಬೇಕನ್ನ
ಸ್ವಲ್ಪ ದಿವಸ ಬೇಕಾಗುತ್ತೆ.
ಅಲ್ಲಲ್ಲ ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇದು ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದಿನಾ ಬೈತೀನಿ. ಅಗೇನ್ ಯು ಡೂ ದ ಸೇಮ್ ಮಿಸ್ಟೇಕ್. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಕರೀರಿ. ಕೊಡಿ ಯಾವತ್ತು ಬೇಕು ಅದು. ವಾಟ್ ಎವರ್ ಡೇಟ್ ದೇ ವಾಂಟ್.
Any date after 15th, my lord, subject to law.
13th August. 15th Sunday. Serial number 6, Arun BM.
ಅದರಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಫಿಡವಿಟ್ ಕೊಡಕ್ಕೆ
ಏನಂತ ಅಫಿಡವಿಟ್? There are no stray sites or intermediate sites or unutilized land that was acquired for HSR layout. Was directed to file an affidavit that there are no stray sites. Who has filed the affidavit?
The commissioner the affidavit to.
Commissioner that they should not dispose of any sites in HSR anta that they have filed. Till
ಅಲ್ಲ ಬಟ್ ಇಲ್ಲೂ ಅಂತ ಸೈಟ್ಸ್ ಇಲ್ವಾ ಅಂತ
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಆತರ ಹೇಳಿದಾರ? Shall not dispose of or auction any strays or instruments found with the site found within unutilized portion of the land required for the purpose of HSR resolution. He is given undertaking. I think we can take this.
Yes.
Barkoli, an affidavit of the Commissioner of Bangalore Development Authority is filed, wherein he has specifically undertaken that until the disposal of the writ petition, this writ petition, the authority shall not dispose of or auction any stray site or intermediate site formed within any unutilized portion of the land acquired for the purpose of HSR layout. Full stop. In view of the above, so the same is taken on record. Full stop. In argument ಮಾಡುತ್ತೀರಿ ಏನು?
Any day.
ಹೇಳಿ ಯಾವತ್ತು ಬೇಕು ಅಂತ ಹೇಳಿ.
My lords, I have one suggestion to the honorable court. There are adjacent layouts, Koramangala and BTM and other layouts. Substantial sites are available.
ಕೊಡಿ details ಇದ್ರೆ ಕೊಡಿ. If you have any details, we'll ask him.
Park ಮಾಡಲ್ಲ ಈಗಾಗಲೇ
ಅಲ್ಲ, if you have details of any stray sites, you give the details, we'll put it to them. If it is available, we'll ask him to allot it.
Call in 10 days.
List on date. List on date code.
13th August, please.
Mr. Devi Prasad Shetty.
But it is for compliance. Subsequent report of the matter on 10/12/2025. ಅದೇ ಅವರು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟು ಲ್ಯಾಂಡ್ ವಾಸ್ ನಾಟ್ ಅಕ್ವೈರ್ಡ್, therefore they will pay the compensation. Not a survey was also done, then they said not
yes,
the compensation has to be determined. Till now not they have not.
AG has to submit. AG has complained.
AG.
Government has state has to clarify.
The writ petition is disposed of, directing the response 1 to 4 to determine the compensation payable to the petitioners in accordance with the 2013 Act. List on 25 to 2026 for complaints.
ಅದಾದ್ಮೇಲೆ 112 ಆರ್ಡರ್ ನೋಡಿ ಸರ್.
112/2025.
The learned additional government advocate in response to the order dated 23/10/2025 submits that Karnataka Rural Infrastructure Development has formed a road in the land of the petitioner and queried as to how KRDL could form a road without acquiring the land. The learned additional government advocate submits that the land was formed without acquisition. In that view,
that's okay, Mr. When will you get instruction?
Directed to obtain instruction from the concern.
The learned AGS seeks time to secure instructions whether the order dated 10/12/2025 is complied or not. List on date code.
Survey also was done on 12/3.
This next HM Muralidhar.
Serial number 8.
Yeah, R2, yeah. List after service of notice to R2.
My lords.
Number 9, Sidramaya
R2,
VV.
My
R2
lords,
Sarvabakalla.
I may be permitted to take out hand summons, my lords. It is society.
It is open for the petitioner to take out hand summons to the respondent number 2, requiring its appearance before the court on date could be of
Yeah, that's short date.
10th August. Hella.
Man.
7th to the 14th. 13th August. Yes, next.
Serial number 9, Sidramaya VV.
To the respondent number 2 and 3, my lords.
Sudarshan Suresh. Please, my lord. Where were you yesterday?
There was one matter which was passed over in
You
court.
should keep somebody present here, mister.
Please, my lord.
In other matters, you jump and you are not here when your matter is
Apologies,
called.
my lords. Apologies, my lords.
Oh.
There, in the other matter, AG was appearing in the trades. Apologies.
Let there be anybody.
Apologies,
You should be
apologies.
present in the court.
Apologies, my lords. Apologies.
The petitioner is seeking writ of mandamus to apply multiplication factor of 2 for the land situated at Hejjala village, Bidadi Hobli, as the land is situated outside the city limit. At annexure H page number 70 may kindly peruse my lord. In 7.3 may kindly be taken up first month. 9.3.
7.3 into quarter. 9.3.
ಇಲ್ಲ ಕೇಳಲಿಂಗಂ.
Acquisition is for what purpose?
My lord, for extension of national highway.
275. NH 275.
NH?
275, my lords. Bangalore, Mysore.
9.3 WP 24529. My lord, page number 70 may kindly peruse.
70.
Yes. My lord, for the very same survey number 86. 70, I think my lord has got it. Survey number 86, column number 2. Multiplication factor of 2 is applied for the very same survey number 86. Petitioners is also survey number 86. Page number.
All the petitioners?
In two cases, same survey number. Other 2 cases adjacent.
Which are the
lands.
other two cases?
Other cases adjacent lands, I will give the list, my lord.
So which are the 2 cases which lie within
Yes,
survey
please, my
number
lord.
86?
One is 24749 of 25.
2474925, 86.
Yes.
Then?
1 minute, my lord. Sorry, I will give number. 24529 of 25, same survey number.
24529. So that
And
is
another is 24586.
Then?
These are all the same survey numbers. Other 2 are WP 24749 of 25, same village. Next is 24277 of 25 is also same village. 277 bar 25.
24277, same
Yes.
village.
Next is 24514 of 25, same village. But the same notification. Next is
589.
24589 is adjacent lands.
Adjacent andre how adjacent?
My lord, these are all survey number 79, 80, 81, 82 bar 1.
Of which village?
Of the same
Hejjala village.
Hejjala village.
So all of them are from the same village.
Same village, Hejjala and
Why you can't give?
My lords, I'm just placing on record of the notification issued by the state government providing for the multiplication factor.
I have also produced before the.
Please, my lords, this is my instructions are that all the multiplication factors have been applied in terms of this particular notification.
What does this notification
Please,
say?
my lords, it talks about the serial number 2 of the first schedule. The government of hereby notifies that 1.5 shall be the factor by which the market value is to be multiplied in respect of areas outside the limits of urban areas exceeding up to 5 kilometers. And 2 shall be the factor in respect of project relates and all the other areas by which the market value is to be
Let's see, what does the act say? What does schedule say? Could you
please, section 26, the land acquisition. So this is a notification which is issued by the state government, my lords.
Page number 51 in.
He is saying something. Please wait for him to complete his submission, Sidramaya.
Page number.
What, section 26, what?
Please.
Act.
Carrying the act, my lords. Apologies.
I thought you knew it by heart. That is why you didn't bring the book.
Page number 24.
Determination of market value of the land by collector. The collector shall adopt the following criteria in assessing and determining the market value of land, namely the market value of any specified in the Indian Stamp Act 1899, two of the 1899 for the registration of the sale deeds or the agreements to sell, as this case may be, in area where the land is situated. The average sale price for similar type of land situated in the nearest village or the nearest vicinity area. Consented amount of compensation as agreed upon under subsection 2 of section 2 in cases acquisition of land for private companies or the public-private partnership projects, whichever is higher. Provided the determination of the market value shall be on the date on which the notification has been issued under section 11. Section 11, it talks about the preliminary notification, my lord.
Yes.
But here the notification is issued.
Please read clause 2.
Please, my lords. The market value calculated as per subsection 1 shall be multiplied by a factor to be specified in the first schedule.
So where's the discretion given to you to reduce the multiplicand?
There is no discretion because my.
How did you say it is 1.5?
This is the notification which has been issued by the state government of Karnataka. I appear for the project director and the special land acquisition officer.
How did you give then multiplicand 2 as to one of the land losers?
The reason is they have obtained the report from the PWD. I have produced the same at page number 75 in 9.3 and 77.
No, you please come to this first schedule. AGA. First schedule.
Page number 51.
Factor by which the market value is to be multiplied in case of rural areas. 1 to 2 based on the distance of the project from urban area as may be notified by the appropriate government. Now, in one case you are given 2. And how can you deny the same thing to the petitioner?
Parity has to be maintained.
So we'll direct them.
But even otherwise, this is an appealable order, my lords, under section 3G7.
Yes.
Even if an award has been passed, the SLA does not have the power to modify.
Correct, but this discrimination can be only looked into by the High Court.
Please, my lords.
So
please,
not any other court.
That particular grounds could be urged in the appellate this thing before the deputy commissioner.
See, in the face of a notification,
please, my lords,
can the district court,
please, my lords,
give a finding,
please, my lords,
that this notification is bad? Can the district court give a finding?
I board on that.
Then, in all these petitions, the petitioners have sought for calculating / recomputing the compensation determined by applying the proper multiplicand as 2 and instead of 1.5 and award interest at 9% per annum from the date of final notification for the first year and at 15% per annum as provided under section 80 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, Resettlement Act 2013. The petitioners contend that their lands were acquired by the respondent number 1 for the purposes of the National Highways Authority of India to widen the Bangalore-Mysore section (NH 275). Full stop. All the petitioners have consented to the acquisition. However, while determining the compensation, the respondent number 3 has applied the multiplicand as 1.5 on the market value determined. The petitioners are therefore aggrieved by the fixation of the multiplicand. Full stop. The learned counsel for the petitioners in all these writ petitions submit that in respect of land in survey number 86 of Hejjala village, which was acquired for the very same purpose, the respondent number 3 has applied the multiplicand as 2 and not 1.5, and therefore the petitioners have been discriminated, full stop. He therefore contends that the property of the petition, he contends that the properties of the petitioners are similarly situate as the property of the person who was granted compensation by treating the multiplicand as 2. He therefore prays that the petitioners also be extended the same benefit. Per contra, the learned counsel for the respondent number 2 and 3 submits that the multiplicand of 1.5 is applied based on the notification issued by the state government issued under section 26 of the Act 2013. He contends that the state government has stated that the multiplicand of 1.5 shall be applied when the property lies outside the urban areas within 5 kilometers, and the multiplicand shall be 2 in respect of those areas which lie beyond 5 kilometers. Full stop. He therefore submits that the applicant, that the compensation is determined in respect of the petitioners by applying the appropriate multiplier. However, when confronted that in respect of the land loser in survey number 86 of Hejjala, which was also acquired for the very same purpose, the applicant, the multiplicand that was applied was 2, the learned counsel for the respondents 2 and 3 was unable to.
In terms of the notification.
Was unable to.
That will be taken.
Was unable to justify. However, he contended that whatever that is applied in so far as the petitioners are concerned is in line with the notification. Issued by the state government dated 3/5/2014. Next para. The learned AGA submitted that the multiplicand is applied in view of the discretion granted to the state government under section 26 of the Act 2013. He contends that since the market value of properties lying within 5 kilometers from the project area would be higher, for the multiplicand is 1.5, and in respect of those properties which lie beyond 5 kilometers, the multiplicand is 2. Full stop. He therefore submits that this discretion is just and proper, and taking into account the different market values of the properties lying near the project site. He therefore contends that there is no reason why the petition should be extended the benefit of the higher multiplicand. Full stop. I consider submissions made by the learned counsel for the petitioners and the learned AGA for the respondent number 4 and the learned counsel for the respondent number 2 and 3. Full stop. Next para. The properties belonging to the petitioners in WP number.
That I have an abstract I will give.
Could it? Property belonging to the petitioners in WP number. 24529 of 2025 and 24586 of 2025 lie within survey number 86 of Hejjala. Full stop.
Yes, correct, madam.
The other properties also lie in Hejjala.
No, madam. 24589 of 25 is in Hejjala.
The property involved in WP number 24589 of 2025
is
situated in Hejjala, while the properties in
24749,
24749,
24722 of 25, 24277 bar 25,
24277 of 25,
24514 of 25,
245 of 25,
and 24586 of 25. Are Sheshagiri Halli village.
Are situated Sheshagiri Halli.
Yes, I have given detailed abstract.
Stop. Since the properties are acquired for a linear project, namely to widen the Bangalore-Mysore highway, it is obvious that these properties lie on the existing main road from Bangalore to Mysore. Full stop. Therefore, the properties of the petition, all the properties, therefore, the multiplicand that has to be applied while determining the compensation should be even to all the properties. Full stop. The petitioners have placed on record an award notice issued to a land loser in survey number 86 of Hejjala, which shows that the multiplicand applied is 2 instead of 1.5. Full stop. Therefore, the respondent number 3 cannot discriminate between persons similarly placed, and the respondent number 3 is bound to apply the same multiplier as was applied in the case of the land loser in survey number 86, bracketally Velliyappa, son of Chokkalingam, bracket close. Therefore, these petitions are allowed. The impugned allowed, and the respondent number 3 is directed to apply the multiplying factor as 2 while determining the compensation payable to the petitioners. Apply multiplying factor as 2 on the market value determined, and award interest at 9% per annum from the date of final notification for the first year and 15% per annum thereafter, as provided under section 80 of the Act 2013. Full stop. ಏನಿದು ಲಿಮಿಟೇಷನ್ ಬೇರೆ ಬೇಕಾದು?
For determination of market value, liberty may be given.
Full stop. It is open for the petitioner to avail the benefit of section 64 of the Act 2013, and the time consumed during arbitration and this writ petition shall be excluded while considering the limitation prescribed under
Section 80 is not applicable in respect of acquisitions made under the National Highways Act, and otherwise also this with regarding that if the award compensation is determined, that's an appealable order under section 3G5 of the National Highways Act.
That is right. Other than contention, I
may just be permitted to place reliance on section
the learned counsel for the respondent number 2 and 3 submits that the petitioner is entitled to file an appeal under section
3G5 of the National Highways Act
5 of the National Highways Act, and therefore this writ petition is not maintainable.
In section 80 of the Land Acquisition Act, the 2013 Act is not applicable for an acquisition made in respect of National Highways, because the acquisition is made under the National Highways Act, not under this 2013
So
Act.
what is the rate of interest provided there?
Lord permits, may I just assist on this question?
National Highways Act.
No, if my Lord permits, may I just assist on this question with the permission? Learned friend's consent.
Please.
My Lord, section 105 of the 2013 Act makes the substantive provisions of the 2013 Act inapplicable to enactments provided in Schedule 4.
Yes.
Schedule 4 includes National Highways Act.
That is considered, madam. That is considered.
No, my Lord, in fact, if my Lord passes an order saying section 80 is applicable, it's going to have a far-reaching impact, because we've argued in every case that section 72 and section 80 is not applicable. Section 72 of the 2013 Act deals with.
Let us see, what does the National Highways Act speak about interest?
National Highways Act in section 3H5, my Lord, says 9% interest.
9% interest?
3H subsection 5 says, that 3H subsection 5 says, Virginia.
The arbitrator may award interest at
Amount
9%
determined
per annum
under
on
section
such
3G by the arbitrator in excess of the amount determined by the competent authority. The arbitrator may award interest at 9% per annum on such excess amount from the date of taking possession under section 3D till the date of the actual deposit thereof.
So the fact is, my Lord, under section 2 subsection 4 of the arbitration.
What she says is right, Siddaramaiah.
My Lord, I have produced the citation reported passed by this honorable court along with a memo. My Lord, it is covered by decision, my Lord, for the very same National Highway. Along with the memo I have furnished, I have the copy, my Lord, I will furnish. Justice Sunil Dutt Yadav has passed an order.
Following Tarsim Singh.
My lord, Tarsam Singh applies in a completely different
No,
context.
that is right, but
Only
you
the
can draw a parallel between that and this.
WP number 1939 of 2026. This is KADB.
KIDB, my
Yes,
lord,
yes.
this is not
Oh,
with respect to
this is,
national
this,
levy.
yes, yes, I understand. This is
9% anta ಮಾಡಿ, 9% from the date of taking possession till the date of deposit.
Yes, yes, thank you. Allahabad High Court has taken a view that 50% is entered. Let them pay interest whatever they provided under there.
But Allahabad High Court has taken a view.
Yes, taken a
ಎಲ್ಲಿದೆ?
view.
Oh, that's a factor that has to be urged before the arbitrator, my lords.
Huh?
In light of the effective remedy that has been appealable remedy.
Why do you want to have loose ends? If you want to close it, you close it in full. Why
Because
keep?
the SLA does not have the power to
Oh,
modify
but
the
if
awards.
Allahabad High Court has taken a
Because the
decision.
SLA does not have the power to modify the awards or to reach this thing. So that's the question that has to be urged before the appellate authority of the statutory arbitrator.
I just clarify one proposition, my lord. Section 80 is with respect to the SLA's award. Section 72 is with respect to the arbitral award. Now, in fact, this question about whether 15% is applicable or not is both under challenge in the Honorable Supreme Court and in the division bench of this Honorable Court as to whether or not 15% is applicable. But
We'll say that this is subject to the outcome of the.
my lord, but the only issue is that Section 80 is definitely not applicable.
That is okay. When you say that some issue is pending before the division bench.
Section 72 is pending, my lord, but as far as Section 80 is concerned, the issue is this. Section 105 expressly excludes.
That is okay. That is
and then the removal of difficulties order makes only the first, second, and third schedules applicable. First schedule provides for 26, 29 factor and solution. The 12% additional market value is under the government order that is passed by the central government.
But what about section 72? You said that there's some division bench matter.
There are some arbitral awards that have been passed. Awardees have a 15% interest. We've gotten it stayed before the division bench.
Then we'll say that it's subject to. It is needless to mention.
My lord passes an order.
I'm not saying, I'm only saying 9%, but I'll say that this interest will be subject to the outcome of the proceedings before the division bench, whatever case that you say. The rate of interest applied is subject to the outcome of the judgment of the division bench of this court in WP writ appeal number so and so. Yes, next.
Serial number 10, Omkar Murthy Ji.
So Omkar Murthy.
I filed a memo for withdrawal of petition.
Memo for withdrawal is filed by the learned counsel for the petitioner. In view of the above, in view of the memo, the petition is dismissed as withdrawn.
Swami, I am the fourth respondent. Respondent 1, 2, 3 are conniving with each other. They've sold the property in 2005 itself.
Can I stop him from withdrawing?
ಇಲ್ಲ ಸ್ವಾಮಿ ಕಾಪಿ ಕೇಳ್ತಾ ಇದೀನಿ ಕೊಡ ಅಂತ ಹೇಳ್ತಾರೆ ಏನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಿದೆ.
Yes.
Serial number 11, Sidramaya.
PB Sidramaya.
25 guntas of the land of the petitioner is acquired for formation of road.
Is it told? Formation of?
Road. Formation of road. Thereafter, several landowners have filed writ petitions and a stay order was provided. Subsequently, negotiations was held to form the road in the alternative way. Page number 46 may kindly.
Road in the alternate land.
Same land, alternate place. Instead of utilizing 25 guntas in the land of the petitioner, 10 guntas in the land of the petitioner, 9 guntas in the brother of the petitioner. So page number 46 annexure L.
46,
Yes. So this is the latest report of the Mauser report furnished by the Revenue Department. Typed copy I have produced at page number 50. My lord, one
straightened the road. Road na straight ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಅದು annexure L I will show this sketch, my lord. Page number 46. ಇದರಲ್ಲಿ annexure A, B, C, F, H, I is the land of the petitioners and his brother.
A, B, C, E.
A, B, C, last F.
F.
And madhye H and I. To A is the land of the petitioner and his brother. Notification is issued to acquire the land at point A, B, C, D, and K This 25 guntas purely belongs to petitioner. Now the road is formed as E, J, in between J and K, but there is one line. This dark portion road has been formed in between the land of the petitioner and his brother. 19 guntas is utilized, a road has been formed. This 25 guntas remains with the petitioner. So subsequently, the RTC entry stands for the remaining land with the name of the petitioner only. Recently, the Tahsildar Assistant Commissioner has changed the land entry in the RTC entry by deleting name of the petitioner from this 25 guntas. We have given the representation. The detailed measure has been drawn by the Tahsildar. That is the sketch prepared by the Tahsildar recently at annexure L, page number 46.
Yes.
Detailed report is also furnished. I have produced the typed copy at page number 50.
Yes.
ಅದರಲ್ಲಿ ಸೊ ಐ ವಿಲ್ ರೀಡ್ ಮೈ ಸಿಮ್ ರೀಸರ್ವೆ ನಂಬರ್ 59/8ರಲ್ಲಿ 2 ಎಕರೆ 16 ಗುಂಟೆ ಇತ್ತು ನಮ್ದು ಟೋಟಲ್. 1 ಗುಂಟೆ ಖರಾಬು, ಬಾಕಿ 2 ಎಕರೆ 15 ಗುಂಟೆ.
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ?
ಪೇಜ್ ನಂಬರ್ 50 ಪ್ಯಾರಾ 2. ಖರಾಬು 1. ಸೊ ಎಡಿಎಲ್ಆರ್ ಪೋಡಿಯಾಗಿ 59/8, 59/8 ಮತ್ತು 19 ಎಂದು ಇಸ್ಸಾ ಸೈಜು ನೀಡಿದ್ದು 59/19ರಲ್ಲಿ 1 ಎಕರೆ 8 ಗುಂಟೆ, ಖರಾಬು ಅರ್ಧ ಗುಂಟೆ, 1 ಎಕರೆ 7.5 ಗುಂಟೆ KR ಶಿವಮೂರ್ತಿ ಬಿನ್ ರಾಮಲಿಂಗಯ್ಯ ಹೆಸರಿಗೆ ಪೋಡಿಯಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ 3ನೇ ಪ್ಯಾರಾ, ಇದು ನಮ್ಮ ಲ್ಯಾಂಡ್. ಸರ್ವೆ ನಂಬರ್ 59/8ರಲ್ಲಿ 2 ಎಕರೆ 16 ಗುಂಟೆ KR ಶಿವಮೂರ್ತಿ ಹಾಗೂ ಅವರ ತಂದೆ ರಾಮಲಿಂಗಯ್ಯನವರು ತಲಾ ಅರ್ಧ ಭಾಗದಂತೆ ಅನುಭವ ಮಾಡಿಕೊಂಡಿದ್ದು, 76ರಲ್ಲಿ ಅದರ್ಲಿಗೆರೆ ಗ್ರಾಮಕ್ಕೆ ರಸ್ತೆಗಾಗಿ 25 ಗುಂಟೆ ಭೂಸ್ವಾಧೀನವಾಗಿದ್ದು, 25/1/78 ಅವಾರ್ಡ್ ಆದೇಶದ ಅನುಭವದಾರ ರಾಮಲಿಂಗಯ್ಯ ಮತ್ತು ಶಿವಮೂರ್ತಿ ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ. ಸನ್ ಇಸ್ವಿ 1976ರಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ನಕ್ಷೆಯಲ್ಲಿ 59/8ರ ಪೂರ್ವ ಭಾಗದಲ್ಲಿ 25 ಗುಂಟೆ ಸುಧಾರಣೆ ಬಗ್ಗೆ ನಕ್ಷೆ ತಯಾರಿಸಿರುತ್ತಾರೆ. ಭೂಸ್ವಾಧೀನವಾದಂತೆ ರಸ್ತೆ ನಿರ್ಮಾಣ ಮಾಡುವಾಗ ಜಮೀನು ಮಾಲೀಕರಿಂದ ಅಡಚಣೆಯಾಗಿ ನ್ಯಾಯಾಲಯದಿಂದ ತಡೆಯಾಜ್ಞೆ ತಂದಿದ್ದು, ರಸ್ತೆ ನಿರ್ಮಾಣಕ್ಕೆ ತೊಂದರೆಯಾಗಿದ್ದು, ಈ ಬಗ್ಗೆ ಸಿದ್ಧಗಂಗಾ ಶ್ರೀಗಳ ನೇತೃತ್ವದಲ್ಲಿ ಅಂದಿನ ತಹಸೀಲ್ದಾರ್ ಅವರು ಹಾಗೂ ಇತರ ಅಧಿಕಾರಿಗಳೊಂದಿಗೆ ಪಂಚಾಯಿತಿ ಮುಖಂಡರು, ವಿಧಾನಸಭಾ ಸದಸ್ಯರ ಮಧ್ಯಸ್ಥಿಕೆಯಲ್ಲಿ ತೀರ್ಮಾನವಾದಂತೆ 59/8ರಲ್ಲಿ ರಾಮಲಿಂಗಯ್ಯ ಹಾಗೂ ಶಿವಮೂರ್ತಿಯರ ಅನುಭವಗಳ ಮಧ್ಯಭಾಗದ ರಸ್ತೆ ನಿರ್ಮಾಣ ಮಾಡಿಕೊಂಡಿರೋದು ಅರ್ಜಿದಾರರು ನೀಡಿದ ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ. 1980ರಿಂದ ಅದೇ ರೀತಿ KR ಶಿವಮೂರ್ತಿ ಅನುಭವದಲ್ಲಿದ್ದು, 2000ನೇ ಇಸ್ವಿಯಲ್ಲಿ 59/8ರಲ್ಲಿ 59/8, 19 ಎಂದು ಇಸ್ಸಾ ಪೋಡಿಯಾಗಿದ್ದು, ನಂತರದಲ್ಲಿ 59/19ರ 1 ಎಕರೆ 8 ಗುಂಟೆ ಖರಾಬು ಅರ್ಧ, ಬಾಕಿ 1 ಎಕರೆ 7.5 ಗುಂಟೆ KS ಬಸವರಾಜ್ ಅವರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆಯಾಗಿದ್ದು ಪಿಟಿಷನರು. KR ಬಸವರಾಜ್ ಅವರು 59/19ರಲ್ಲಿ ಮನೆ ನಿರ್ಮಾಣ ಮಾಡಿಕೊಂಡು ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿದ್ದು, ಮನೆಯನ್ನು ಕಟ್ಟಲು ಪಡೆದಿರುವ ಪ್ಲಾನ್ನಲ್ಲಿ ಪಶ್ಚಿಮ ಭಾಗದಲ್ಲಿ ರಸ್ತೆ ಚಾಲ್ತಿಯಲ್ಲಿರುವುದು ಅರ್ಜಿದಾರರು ನೀಡಿದ ಕಟ್ಟಡದ ಪ್ಲಾನ್ ಮೂಲಕ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಮೊದಲು ಪೂರ್ವ ಭಾಗದಲ್ಲಿ ಆಗಿದ್ದು, ಪಶ್ಚಿಮ ಭಾಗದಲ್ಲಿ ರಸ್ತೆ ಮಾಡಿರು. 2008ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಭೂಸ್ವಾಧೀನವಾದ 25 ಗುಂಟೆ ಜಮೀನನ್ನು RTCಯಲ್ಲಿ ಇಂಡೀಕರಿಸಿ ಸರ್ವೆ ನಂಬರ್ 59/19ರಲ್ಲಿ ಇಸ್ಸಾ ಪೋಡಿ ಮಾಡಿ 59/19, 22 ಎಂದು ದಸ್ತಾವೇಜು ನೀಡಿದ್ದು, ಅದರಂತೆ 59/19ರಲ್ಲಿ 22.5 ಗುಂಟೆ ಹಾಗೂ 59/19ರಲ್ಲಿ ಸರ್ಕಾರಿ ರಸ್ತೆಗೆ ಬಿ ಖರಾಬಲ್ಲಿ 25 ಗುಂಟೆ ದಾಖಲಿಸಿದ್ದು ಪೋಡಿ ದಾಖಲೆಗಳಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನಮ್ಮ ಯುಟಿಲೈಸೇಷನ್ ಲ್ಯಾಂಡ್ ಅವ್ರ ಹತ್ರನೇ ಉಳ್ಕಂತು 25 ಗುಂಟೆಯನ್ನು ಸರ್ಕಾರ ಅಂತ ಮಾಡಿಕೊಂಡ್ರು. ಸೊ ಅದರಂತೆ KS ಬಸವರಾಜರು ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 59/19ರಲ್ಲಿ ಹಳೆಯ ನಂಬರ್ 59/8ರಲ್ಲಿ RTC ಅಂತೆ 21.5 ಗುಂಟೆ ಇದ್ದು, ಇದನ್ನು ಹಾಲಿ ಬಳಕೆಯಲ್ಲಿರುವ ರಸ್ತೆ 10 ಗುಂಟೆ ಇದ್ದು, ಉಳಿದ 37 ಗುಂಟೆ RTC ತಿದ್ದುಪಡಿ ಮಾಡಿಕೊಂತ ಮನವಿ ಸಲ್ಲಿಸಿತ್ತು. ನೋಟಿಸ್ ಆಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅಬ್ಜೆಕ್ಷನ್ಗಿಂತ ಟೈಮ್ ತಗೊಂಡ್ರು.
Yes, madam. The land HCGP seeks time to file objections to the writ petition. List on date.
14th August.
Yes, Mr. Vachan.
Yes, please.
Yes, next.
Petitioners in this matter, it's a disposed of matter. I filed an application.
It is disposed of.
It's a disposed of matter.
What is the direction?
Seeking for a copy.
No, what is this direction that you sought for?
But we have not been served copy.
No copy has been served.
What is the, what is this?
Your Lordship, I have served and filed. I have the authentication also filed. Anyway,
Petition
I
is
have
allowed.
sent copies to them. I only asked for certain documents were placed by way of
But
before this court by the
Their
state.
plan was not under doubt.
Issue with the it's not genuine. What is the direction now we sought for?
Lordship, on 12/8/25, a memo was placed before this court with certain sketches and maps that was placed. I did not get copy that was served by the respondent state. I applied for certified copies. In certified copies, an objection was raised. These are handwritten copies and sketches are not originals. Therefore, I cannot give. I'm only asking them to produce me a copy of that what they placed before this court. I'll also serve them with the copies. I served them at the time of filing as well. I'll serve an additional copy.
Blood,
So
just
have
for the
they placed-
information.
no, have they produced this before this court?
Yes, it was produced before this court.
You will directly register to issue copies.
That's all I'm asking, not asking.
ಅಷ್ಟೇ ಕೇಳ್ತಿರೋದು. ಬರ್ಕೊಳ್ಳಿ, this application is filed by the petitioners seeking for authenticated copies of the survey report, spot mahazar and survey sketch dated 23/1/2024.
Registry is direct.
Enclosed along with the memo dated 12/8/2025 filed by the state
Filed
government.
with the respondent state is
By
what
the-
the
by
memo
the
says.
council for the state, by the state, full stop. It is stated in the affidavit accompanying the application that an application was for certified copy was filed to secure the above documents, but the same was refused by the registry of this court on the ground that they're all photocopies and not the original records. You can apply under RT Act, isn't it? Take under RT Act.
Your Lordship, RTA with the problem is then again after 30 days, the corresponding matter is pending before the trial court.
Stop. No, you
But
apply
actually
in-
what has happened is that there is a SLP pending in the Supreme Court. Your Lordships remember the 482 was allowed and the complaint was quashed. Against that,
remember
No,
any,
the
there
SLP
is.
is not connected to this matter.
I don't
it
know, I
is.
don't remember. Anyway, you apply for copies under the RT Act.
There the
They
Supreme
can
Court has
always give me
directed
two
investigation.
copies. This was produced before this court. I just want to
Yes, sir.
produce it before the trial court.
You are not served with a copy by the
I
state.
was not served on that particular day. Your
Also
Lordship. If not, I
stated
wouldn't
that
have been
copies of
need
the
to
above
file it.
documents were not furnished by the state, by the government pleader. And hence the petitioner is at a disadvantage and therefore prays that the respondent number 5 be directed to furnish the authenticated copies of the survey report, spot measure and survey sketch. Next, if the respondent state has filed documents before the court, the petitioner is undoubtedly entitled to a copy. However, if the copy of the same is not furnished by the learned HCGP, it is open for the petitioner to either obtain the copies under the RT Act. It is open for the petitioner to obtain copies under the Right to Information Act. Full stop. In that view of the matter, IA 1 of 2026 stands disposed of on the above terms. Yes.
Your Lordship, my only request is only the state can be directed to give me one more
Madam,
copy.
if it is there, we'll permit you, take it now itself. File ಬಂದಿದ್ಯಾ? File ಕೊಡಿ ಅವ್ರಿಗೆ. Take photographs.
No, Your Lordship, I need to produce it before the trial court. The
Madam, you
matters
take
are pending.
photographs, take a scan it. Now handheld scanning, mobile itself
Problem
you can
is
scan.
unless it is an authenticated copy, I cannot mark it in evidence before the
You
trial.
please file an affidavit to that effect if you want to challenge it before the Supreme Court seeking for dispensation. Mr. Rajesh Male will help you how to seek for dispensation.
I'll take a photocopies of this code, sir.
What is? She's yes, next. Huh?
National Highway matter, Mala. I have produced the Allahabad High Court judgment in last page of the. In all the
Shruti Chaganti copy ಕೊಡಿ ಅವ್ರಿಗೆ. ಅವ್ರು ಕೊಡಿ ಅವ್ರಿಗೆ. She will.
along with petition I have furnished.
She'll give a different angle.
In all the petitions I have produced in the last page.
Have a look at it. If Allahabad High Court has taken a view, you are bound. You are.
I've not read the judgment, my lord. but
You please read it, madam. Now that you have assisted the court, you are assist the court further.
No, but the thing, the para 16 on the face of it says that applying the principles enunciated in Tarsan Singh. My respectful submission is Tarsan Singh deals with the period
Now,
between.
anyway, now one High Court has taken a decision. Applying Kusum in Gods, we have to follow the
No,
judgment.
that is not binding on this on
Why?
the court, my lord. It has only personalized.
No,
the
you are a respondent in that. National Highways is a respondent.
Let me just check whether.
So
this
what
appeal
applies to?
pending. Because my only submission is this. wherever section 80 or in fact, in one contempt matter, section 80 was made applicable to us, which has been stayed before the Honorable Supreme Court. And this judgment, insofar as it interprets star something, is certainly, my lord would please to take.
I will
another
borrow
look.
your own idiom. What applies to the goose applies to the gander also. So what applies in Allahabad will apply in Karnataka also.
But my only submission is it's not binding on this court.
Why?
The court could well take
Why?
a different view.
You are a respondent. You are a respondent in Allahabad High Court. What happens there will apply. You will have to apply here.
The question is whether
Extending,
it arose for consideration and whether it was considered.
applying the.
My lord, whether it arose for the consideration of the court and whether it was considered, and we just look into it, be permitted to.
Please also have a look at the judgment.
And even the Supreme Court has also taken the very same view. I have produced at page number 195.
ತೋರಿಸಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಅದರಲ್ಲಿ ಎಲ್ಲ ಇದೆ, ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಹಾಕಿದ್ದೀವಿ Supreme Court.
The judgment is not still signed the judgment. You please produce it. I'll look into it.
I have produced along with petitions, my lord. Writ petitions along with petitions. I have produced all the citations.
Yes, madam. Please go through that and just submit.
Because the only thing is this issue will have, my lord's order would have far-reaching implications. That's the only.
No, it would.
My lord.
Yes, it has to.
My lord.
No, really. If Allahabad has taken a view, there's no reason why we shouldn't take it.
I'll look into it, make my submission. If you.
Serial number 13, Mahesh Arupi.
Mahesh Arupin.
Impleading applicants, my lord, are the LRs of the original owner. Along with petitioner.
Impleading applicants are the original owners.
LRs of the original owner.
So you want to save your petition. Petition was initially filed by the purchaser.
Filed by agreement holders, my lord, from the original owner.
ಏನಂತ ಕೇಳ್ತಿದ್ದೀರಾ?
My lord, the subject matter of the writ petition is that, my lord, lands of the one Ramrao lot was acquired for formation of railway road, my lord. Thereafter, my lord, then CITT passed a resolution to reconvey the land, my lord, to the extent of 40,000 and odd, my lord, in favor of the original owner. Out of that total extent, my lord, now initially, my lord, the extent that was reconveyed was 14,000 and odd. Remaining 3,000 is required to be reconveyed, my lord. Before that, my lord, the original owner died, my lord. Thereafter, his wife, my lord, pursued the matter. It was not done, my lord. Then, my lord, the wife and children of the original owner entered into an agreement with the petitioner's blood to share 50% of the land blood that is going to be reconveyed by the BDM blood. Now, blood, the LRs of the original owner also blood wants to come on record along with the
Let's kindly ನಮಗೆ
Okay,
copy survival
125 is filed by the petitioner to implead the vendors of the petitioner as parties to the writ petition. Since there is no conflict of interest between the petitioners and the proposed petitioners, IA 1 of 25 deserves to be allowed. Accordingly, IA 1 of 25 is allowed and the proposed petitioners are permitted to come on record. Counsel for the petitioners directed to amend the writ petition. Yes.
Serial number 14, Rajesh Jain.
Paying for petitioners.
My lord, sorry, but
IA 1 of 24 is allowed.
I seem to have misplaced my file, my lord. I'll collect another copy from my learned friend.
And counsel for the respondent 1 and 2 seeks time list on sounds. Date, whatever date you want.
14th August.
Grateful.
Serial number 15.
But I appear for the petitioner's counsel.
I appear for the impleading applicants.
What
my lord.
was challenged, my lord, before your lordships was, my lord, the refusal of a certain plan approval. And more importantly, an endorsement that came to be made that there is a 1948 land acquisition proceeding, therefore they can't proceed with my application. Now, my lord, what happened is that the property is a very large area, my lord, over 2 acres. On one small portion of land, the impleading applicant claims a right and has lodged a suit seeking, my lord, cancellation of 2 gift deeds that were executed by the impleading applicant in favor of the individual parties for the petitions before your lordships. Now, that, my lord, suit is pending. There are appeals before the Honorable Supreme Court and apparently some interim orders are passed. My learned friend's grievance appears to be while seeking impleadment that, look, when all that is pending, you should have disclosed all that whatsoever it is. My lord, I don't want to get into that controversy because that is seized up by the Honorable the civil court as well as the Honorable Supreme Court. And frankly, that is not the concern before your lordships. The main concern before your lordships is this endorsement issued by the BDA, which my respectful submission is incorrect, and therefore that is really what I want to point out now. To that effect, I made a submission last date. Permit me to tender it and serve a copy on my last date.
No, but so far as application for impleading is concerned,
Yes.
can that be allowed?
I'm just answering that. May I just tender this memo to you?
Told.
I have not given my learned friend a copy on the last day. Please permit me to point out what I'm saying. Insofar as impleading, I'm putting an end to the controversy before your lordship. That's what my submission. Let the suits continue, let the SLP continue, whatever. That I'm not on that. Yes. Please permit me to show your lordship, my lord, paragraph 3 of that memo.
Yes.
They claim a total extent of 5,943 square feet out of two survey number. I mean, I'm not in one survey number and 2,300 square feet in the second survey number. That is subject matter of the writ petition. Apart from these lands, writ petition and impute endorsement rejecting concerns a larger extent of land, in all measuring 2 acres, 39 guntas out of 4 survey numbers. They are not making any claim on that even in the suits. But in para 4, I point out that whatever else is pending, no difficulty. Now, while I deny my lord without going into the controversy on my lord impleading, please permit me to show your lordship paragraph 6. I am not pressing prayer B, which, if granted, can affect their right, which is for a single site. It is called something called a single site approval for the entire land. I am not pressing that. I am not pressing my application that I made originally for grant of approval.
Yeah, what is the relief sought for in the petition?
I have extracted it in the memo, but I can also show your lordship from the writ petition.
Page 28.
Page 28 of the writ petition. The first is, my lord, to quash the endorsement. That endorsement bears a reference to a 1948 land acquisition.
No, let us see Annexure A for a
Yes, my lord, I may point.
Page 33.
Please come to page 33, my lord, if your lordship, if I can draw your lordship. But this application was placed by the developer. The portion that, my lord, really that I'm agreed is at page 35.
I'll read the subject.
Lord, yes.
Thank you, madam.
I have my English.
Vishaya, Bangalore, Uttara Talukku, so and so, my lord, this relates to my application.
Oh, please read it.
Lord, I'm sorry, I'm a little slow in reading.
No, you can read it slowly only.
Lord, yes. ಮೇಲ್ಕೊಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದಂತೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ
ಅಲ್ಲಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ಓದಿ.
ಎಸ್ ವಿಷಯ. ಎಸ್ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕಾ ಕಸಬಾ ಹುಬ್ಳಿ ಲಾಲ್ಬಾಗ್ ಸಿದ್ದಾಪುರ ಗ್ರಾಮದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 27/1, 28/4, 28/5, 28/6 ರಲ್ಲಿನ 2 acres 39.5 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಪ್ರಾದೇಶಿಕ ಏಕ ನಿವೇಶನ ವಸತಿ ವಿನ್ಯಾಸ ಪತ್ರ, that is one single plan approval they call it, single site plan approval they call it for residential purpose. That is what is rejected.
Shruti Chaganti is from Andhra.
May I read, my lord? I can read it.
She can read Kannada fluently. You are from Karnataka.
I am also from Karnataka only, but I studied.
And unfortunately, you say you can't.
CBSE problem, not.
No, CBSE, now you have become a lawyer from the last 25 years.
But unfortunately, last few years.
No, we learn English so quickly, but we don't learn our mother tongue.
Absolutely.
We hesitate. I don't know why.
No, it's not. In fact, I must point out to your lordship, my learned friend has been taking Kannada lessons, both reading and writing. I want to take encouragement from her and start that.
You should.
But I really want to appreciate that. Anyway, coming back to this, the difficulty is this. The reason why this is rejected is that they say there is a 1948 acquisition that is still open.
Yes.
My submission is the reason that the impleading applicant wants to come is that they say you could not have applied for this. There was a previous rejection before BBMP and all of that. I am saying I'm not pressing the application, but I'm still challenging the endorsement insofar as the 1948.
To say that, I don't
made
think
that statement in my memo. That's the statement made by me in my memo. Please come to paragraph 6.
So this writ petition will be restricted only to
to prayer A. I specifically said
prayer A only insofar as the acquisition part is concerned.
Only insofar as that endorsement. I'm very good.
May I just be heard, my lord? My two requests, two submissions on this is, one is that my learned senior has filed a memo acknowledging and admitting that there are interstate disputes with respect to lands in survey number 28/5 and 28/6. Therefore, my impleading application may kindly be allowed because I've placed on record how they have suppressed facts in the writ petition. My impleading application may be allowed by virtue of the memo, which admits and acknowledges the interstate disputes. I may be permitted to come on record.
No, that's okay.
Then, with respect to prayer number 1, it may be restricted only to survey number 28/4 because there are totally 4 survey numbers over there. BDA itself says that with respect to 27/1 and 28/5, ಲೆಜರ್ ವಹಿಯಂತೆ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 27/1 ರ ಜಮೀನಿನ ಬಗ್ಗೆ ವಿಡ್ರಾನ್ ಎಂದು ನಮೂದಿಸಲಾಗಿರುತ್ತದೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 28/5 ಮತ್ತು 28/6 ರ ಜಮೀನಿನ ಬಗ್ಗೆ ವಿಡ್ರಾನ್ ಎಂದು ಅಲ್ಲಿನ 18 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನು ಕನಕನಪಾಳ್ಯ ಬಿ ಬ್ಲಾಕ್ ಬಡಾವಣೆ.
Objection in so far as 28/5 and 28/6
is concerned. So prayer number 1 may also be restricted to only
28/1 and 28/4 you don't.
Excluding my claim to 28, but so even prayer number 1 may kindly be restricted to that extent.
No, you say that you're only interested in 5943 and 2315.
Both one land is in 28/5, one land is in 28/6.
Restricted only to this much.
My respect to the acquisition proceeding in respect of which they've taken compensation.
Yes.
There's no prayer in respect of that. The challenge is to the
You're
endorsement.
not bothered about that.
No, the difficulty is this. The endorsement is with respect to rejection of single site sanction for 4 survey numbers on account of the fact that 1 survey number is under acquisition. If they want to restrict their prayer to acquisition, then per BDA, acquisition is only in 28/4.
Yes.
So therefore, their prayer in prayer number 1 may be restricted to 28/4. They're giving up prayer number 2, and but my only most respectful request to the court is my impleading application may be allowed.
Yes.
Because I have placed on record exactly how they've suppressed material facts before this court. 3 times, my lord, 3 times they applied to BBMP for amalgamation of Kata. 3 times it's rejected.
Yes.
They go on record before the Honorable Supreme Court and say so,
Oh, this
without
is that
disclosing
brothers
any
case,
of that.
is it?
Yes, my lord.
Oh, the 2 brothers.
Yes, my
Been
lord.
fighting perpetually.
Considered a GLCPC in the case.
I decided some matter.
The only factual clarification I would make, my lord, is that no matters are pending before the Honorable Supreme Court. All of them have been disposed of. The Honorable Supreme Court has directed that the interim order with respect to my properties, the properties I'm claiming a right over, was made absolute until the disposal of the suits.
No, suppose
The suits are pending.
No, please wait. Suppose if he says that he restricts this writ petition only regarding the challenge to the endorsement issued by the BDA, saying that 28/4 is acquired. So therefore,
I would be
they are out of
obviously,
the court.
yes, ma'am. But that because by virtue of the fact that they've admitted my claim, admitted that I'm making a claim, my impleading application may please be allowed and I may be brought on record and the memo
Could be
accepted
brought
to
on
that
record.
effect. My lord, my submission is, in the absence of that impleading application, such a memo would never have been filed.
Yes.
The memo is filed, they say impleading applicants again and again in the memo. They don't say proposed impleading applicants.
Yes.
They, to that extent, I have come before this honorable court to say I'm a necessary party to the proceedings by virtue of the fact that I have a live claim in respect of 28/5, 28/6. It is only after perusing my application that they have made this memo.
Can I get one sentence of answer, my lord? Please see para 5 of my memo. I have specifically answered this. Can I just show you lots of paragraph? Petitioners deny contents of impleading applicant and dispute the allegations. However, solely with a view to resolve the issues that have arisen. Petitioners submit they do not wish to press the application seeking sanction of single layout residential plan. Petitioners will file a fresh application before first respondent seeking suitable sanction in respect of scheduled properties by excluding the portion over the said properties over which the impleading applicants have made a claim, that is extent of so and so and 28/5 and 28/6. For the time being, this is without prejudice to the contention that they have no right over such property.
My lord, without my application.
So once
Yes,
he
yes,
makes
sir.
a statement, then there's no need for you to.
My lord, my only submission is that it is in fact premised upon paragraph 5 that I'm praying that this honorable court be pleased to allow my impleading application.
Yes. Barkul. IA 1 of 2026 is filed. Huh? 25 is filed to come on record as one of the as respondent number 4 and 5 in this writ petition. It is stated in the application that the applicants are the owners of land in survey number 28/5 and 28/6. Full stop. The petitioner number 2 had approached the proposed respondents for a joint development of the property owned by the petitioner number 1 in survey number 28/4 and 27/1.
28/5 and 28/6.
No.
The joint development is with respect to the other survey numbers also,
No,
but
it's-
my rights were with respect to.
Petitioner number 1 had approached the proposed respondents or petitioner number 2 na?
Petitioner number two.
Petitioner number 2, petitioner number 2 had approached the proposed respondents for a joint development of their property along with the property of the petitioner number 1.
No, of petitioner number 2 only.
Of
Their-
petitioner number 2, of petitioner number 2. Full stop. Petitioner, the proposed petition, respondents claim that the petitioner number 2 had induced their consent to transfer the properties in survey number 28/5 and 28/6 with a gift deeds, in return of which petition number 2 had assured to pay rupees 25 lakhs upfront, and upon completion of the project they would be given 10,000 square feet of built up area. Full stop. It is claimed that on 4/8/2017, petitioner number 2 transferred a sum of rupees 25 lakhs to the account of the proposed respondent number 5. And in return, the proposed respondent number 5 executed 2 gift deeds in favor of the proposed respondent number 4, who in turn executed 2 gift deeds in favor of the petitioner in respect of the properties bearing survey number 28/5 and 28/6. Full stop. The proposed respondents contend that they received a summons in OS number 5286 of 2017 filed by the petitioner number 2 against the proposed respondent number 5 for recovery of a sum of rupees 25 lakhs paid to her on 4/8/2017, contending that it was a loan. Full stop. Petitioners, the proposed respondents contend that they were therefore constrained to file OS number 132 of 2018 for cancellation of the gift deeds mentioned above. Full stop. The proposed respondents further contend that the petition number 2 has proposed a joint development of the properties with the petition number 1, and that a plan submitted by the petition number 1 was rejected by the respondent number.
It's no, BBMP is not a respondent, my lord. That's in fact my
Was
grievance.
rejected by the
BBMP.
Brihat Bangalore Mahanagar Palike. Full stop. It is therefore contended that since the dispute regarding survey number 28/5 and 28/6 is pending before the courts, any order that may be passed in this writ petition granting the plan in favor of the petition number 1 would injure the rights of the proposed respondents, and therefore they intend to come on record. Next para. This application is opposed by the petitioners. This memo is filed by the learned counsel for the petitioners in response to this application, wherein it is contended that double and comma para 3 copy mobile. Para 3 and para 5. Full stop. Therefore, the petitioners have restricted the relief sought for in the writ petition only insofar as it relates to the endorsement issued by the Brihat Bengaluru Mahanagar Palike,
BDA.
BDA, be issued by the respondent number
1
and 2. Insofar as it relates to the acquisition of land in survey number
28/4
and 28/4 of Lalbagh, Siddhapura village. Full stop. Consequently, the plan submitted by the petitioner in respect of the other properties, including the properties of the proposed respondents, is not pressed. Full stop. Therefore, there is no need to permit the applicants to come on record, as the writ petition is now reduced to a very short question as to whether the land in survey number 28/4 was acquired, and that therefore the plan sought for by the petitioner could be granted or not. Full stop. Therefore, comma, IA 1 of 25 stands disposed of on the above terms. Yes.
Claimed by the
Property?
the properties of the implementing applicants, sir. The
Property, claimed.
Agreed.
My lord, my memo of retirement may kindly be accepted.
A memo of retirement is filed by the learned counsel for the response 1 and 2. Since the ಬೇರೆ ಯಾರು ಹಾಕಿದ್ದಾರೆ ವಚನ?
ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಯಾರು
ಮತ್ತೆ ಹಾಕಿದ್ಮೇಲೆ ಹಾಕಿ ರಿಟರ್ನ್ ಮಾಡಿದಿರಲ್ಲ.
ಎಷ್ಟು ಸತಿ ರಿಮೈಂಡ್ ಮಾಡಿದ್ರು ಹಾಕ್ತಾ ಇಲ್ಲ. Reminded, given the
ಹಾಕಿದ್ಮೇಲೆ will permit you to
in
the memo for retirement filed by the learned counsel for the response 1 and 2 will be considered later. Yes, next.
Grateful.
16, Deep Kumar IS.
I've read the objection to the implementing application answer, my lord. Observe the copy to the other side. And if the state its objection, PDA.
Yeah, either Mr. You ask Nandakumar, please restrict the relief. No, you please mention that in the writ petition. Please make a mention.
Endorsement, please. Let prayer be.
In view of the above order, the learned counsel of the petitioner is directed to make appropriate endorsements.
Deleting prayer B.
Deleting prayer B.
Great.
And also restricting prayer A only insofar as the acquisition of land in survey number 28/4.
Endorsement is there, not your lordship. Adar ಬಗ್ಗೆ ತಾವು ಹೇಳ್ತಾ ಇದ್ರೆ then it becomes unnecessary. I have to read the whole thing. That's
No. Please make an endorsement.
Please, I have no difficulty.
Next.
Great.
Serial number 16.
Because when we are taking up
Just
for
make
this,
instead of, my lord, in the prayer A, would your lordships permit me, my lord, I'll just file an amended schedule or whatever. That may be simple. Prayer B, I will delete.
do one thing, you amend it, you can file an amended petition. Dilip Kumar. In impleading error?
Yes, my lords, I am for the impleading applicant. The notice, my lords, which is under challenge, has been given at my behest, my lords.
Notice?
My lords, the notice which is
Annexure FA, my lords, page number 13, my lords. There is a complaint of impersonation, my lords.
Page number 13.
How so? There is a complaint of impersonation, my lords. My lords, which is based on the FIR that has been registered.
Ganesh Prasad, MD. So you are the real Ganesh Prasad?
No, my lords, I am the original owner of the property. I have purchased it from, my lords, the
Ganesh.
original Ganesh Prasad.
E Ganesh Prasad, who the petitioner
And this honorable court, my lords, has dismissed.
One Ganesh Prasad is the owner of the property, is not been disputed. Site number 71 in the NTA layout. It was registered in his name in the year 1995.
Yes.
But in 2024, a sale deed has been registered in the name of the petitioner, executed by the Ganesh Prasad. But he has handed over all the original documents to these petitioners. These petitioners has taken loan and they are paying EMI, and possession has been delivered to the petitioners here. But the impleading applicant claims that the property has been registered in the year 2025 in the name of her mother, Leela, and kept pending from 2002. According to them, Your Honor, one Leela has purchased the property in the year 2002.
From Ganesh Prasad?
From Ganesh Prasad, but was not registered. It was kept pending. Leela died, my lord. Her husband also died. In 2025, the very same deed has been registered in the year 2025 by paying penalty but not by the Leela, by the daughter. The property has been registered in the name of the dead person in the year 2025. Based on that, they are claiming that no, the Kata has to be cancelled. Now, my lord, the Kata has been registered in the name of these petitioners based on the registered sale deed.
Your sale, when was your sale deed?
2024.
24.
Yes, my lord. Their sale deed is in the year 2025. Now, my contention is when there is a registered sale deed is there, and based on the registered sale deed, the Kata has been entered. These BDA cannot decide the title. It has to be decided with the civil court.
Yes.
So they cannot even issue a notice saying that I will go and conduct an inquiry with regard to the allegation of that what the.
Where is your sale deed?
Malords, I'm producing, Malords, my list of documents.
Lord is good.
My sale deed, Malords, is in page 1. Starts from page 1, Malords. This is the lease cum sale deed executed in my mother's favor. May I just take, Malords, through the lease cum sale deed, Malords? Page number 1 to 12, Malords, is the lease cum sale deed. This is executed as early as, Malords, in the year 1994 itself, Malords.
Ganesh Prasad lease cum sale is Ganesh Prasad.
In favor of Ganesh Prasad. Subsequent, my lords, I find page 13, my lords, the Aadhaar card, my lords, of the original Ganesh Prasad. And this Aadhaar card, my lords, is this is the only copy available, issued in the year 2013, my lords. Next, my lords, may find page 14, my lords, is the absolute sale deed executed by Ganesh Prasad in my mother's favor. And this is, my lords, this deed of absolute sale made and executed on 21st August 2002. This was kept pending registration, my lords. For 20 years, my lords, nothing transpires. My lords may take page 30, my lords. This is the sale deed which they are claiming title from, my lords. Page 30. MD Ganesh Prasad, my lords, will find, my lords, the name of the person, MD Ganesh Prasad, page 30. My lords may find his address, my lords, MN Doreswamy, residing at number so and so, Naganallur, Tamil Nadu. My lords, the original Ganesh Prasad, even as per the Aadhaar card, is a resident of Karnataka. He's been residing at Vailikaval, Bangalore, and Rajajinagar, my lords, ever since my lords. Next, my lords, we will see the Aadhaar card, my lords, 9263 4028 6408, and the mobile number, the PAN card, my lords. The sale deed is executed in favor of the petitioners. It's a self-drafted sale deed, my lords, and that my lords will find at page number 47, my lords. It is a self-drafted sale deed. Page number 49, my lords, page 47, my lords, will find it's a self-drafted sale deed. Page number 49, my lords, may find the Aadhaar card, my lords, of the purported Ganesh Prasad.
Yes.
In the fake sale deed, he has, my lords, showcased that he is a resident of Tamil Nadu. But in this Aadhaar card, which is created, my lords, only 2 months prior to the registration of the sale deed, his address is of Gayatri Nagar. Mobile number 99164 Next page, my lords, may take, my lords, page 49, 50, my lords, may take. This is the Aadhaar card of the petitioner. The mobile number of, my lords, the petitioner, and the mobile number of the purported Ganesh Prasad, my lords, are the same mobile numbers. Therefore, my lords, I lodged the complaint before the jurisdictional police station. FR came to be registered.
No, you have the handwriting, the thumb impression of Ganesh Prasad and the thumb impression on Ganesh Prasad found on the sale deed of the petitioner.
My lords, this Ganesh Prasad, no, this Ganesh Prasad is a fraudulent person. He is an impersonator, and that, my lords, an investigation.
How can the BDA decide?
My lords, all I'm saying is,
how
my
can
lords,
the BDA decide?
My lords,
will permit you to come on record.
Please, my lords.
But how can the BDA decide?
Please, my only submission is, my lords, that this honorable court directed for the Ganesh Prasad to be made a party. And the court notice was issued to the Ganesh Prasad, my lords. Apparently, the Ganesh Prasad is served, and he has refused to receive this notice.
So, you bring him.
My lord, who is this Ganesh? He is the person who is purported to be in Tamil Nadu.
You bring him. If you know his whereabouts, you got the sale deed in 2024.
Original Ganesh Prasad, my lords, is available as on date in Bangalore.
You bring him.
Please, my lord, I may be wrong. Please, I'll bring him.
Let him file an affidavit. Let him come. Let him say that this is not his signature.
Very well.
What has to be done?
I will bring him tomorrow, my lords. He is available.
Yes.
Please.
The media cannot decide these.
Let him come. Let us see.
And the petition, my lords, challenging the FIR has come to be dismissed. I have produced a copy also. Petition, my lords, challenging the registration of FIR has come to be dismissed. And
That
further
doesn't have
investigation.
anything to do with this.
Please, my lords, I will bring the original Ganesh Prasad. He will be,
Counsel for the,
my application will be.
we'll not allow the application. You bring him first. Let us.
Very well, my lords.
Counsel for the proposed, impleading applicant seeks time. List on? This
Any-
tomorrow.
Very well.
Tomorrow. Yes.
Obliged. Or may I request, my lords, Tuesday, my lords, tomorrow,
Tuesday agala. Tuesday is not BDA day.
Monday, my lords. Obliged.
Tomorrow is next.
Obliged.
So for preliminary matters, serial number 17, Vaira Reddy.
Veera Reddy.
The main matter is a bunch of matters listed on
What is this acquisition for PRR?
PRR.
PRR, madam. Status quo.
72/26.
It is that to accept notice
Matter
for
is 8
respondent
hours,
number.
But total
AGA for respondent number 1. Mr. Krishna for respondent number 2. ನೀವು ಅದೆಲ್ಲ ಅಪೇರ್ ಆಗ್ತಿದ್ರಲ್ಲ PRR.
there, my lord, the remaining matters are disconnected, my lord.
ಅದಕ್ಕೆ I will list after disposal of WP ಅಂತ ಮಾಡ್ತಿದ್ದೀನಿ. List status quo in respect of the property belonging to the petitioner till the disposal of this writ petition. List after disposal of WP number so and so. Yes, next.
Serial number 18, Kumbhi Prabhu Gaud, Baswantrai Gaud.
Kumbigi Prabhu Gaud.
Yes, Marks.
Yes.
Petitioner Marks family land of 10 guntas was acquired Marks and award was passed. Petitioners for the family land of Mark 10 guntas was acquired and award was passed. And Mark under the old act, Mark the some of the Mark the adjacent owners came before this honorable court challenging the award. Mark this honorable court Mark the order to Mark the redetermine the award and pass the award in the Mark the new act. Mark that could be seen from Mark page number 38. He is also not similarly situated person. I request my lord to his award should be redetermined and passed in the my lord's new act. Is my sub.
Award was passed under the old act.
Yes, my lord.
When was the acquisition?
Acquisition was not in the year 2012, my lords. Award was passed on 5/11/2013, my lords. 5/11/2013. Lord, I have produced that document also.
This order passed by this court is also in respect of the same acquisition.
Same acquisition.
Barcode. HGP for R1. R1 and R2. Southwestern Railways are DSGA. DSGA for respondent number 3.
Serial number 19,
Date
Bajwan Swami M.
Copy serve ಮಾಡಿ ಬನ್ನಿ ಇನ್ನ ಈಗ ತಾನೇ just now you are born just now. ಅಲ್ಲಿ ಡಿಗ್ರಿ ಕೇಳ್ತಿದ್ದೀರ ನೀವು.
For the petitioner in this lordship, the case is
Prajwal.
Yes, Prajwal. The case.
Yes, Mr. Prajwal.
Dispensation of annexure F and C in this case.
Dispensed. Next. IA
The case
146 is allowed. This is regarding PRR.
The case is regarding the unnotified land in survey number 11/1.
Case is regarding
unnotified land.
Unnotified land.
Yes. Unacquired land in this case. The petitioner's land comes under northeastern part of the survey number 11/1 of Ramchandra village in this case, Your Honor. As
So you want an NOC?
Yes,
You want an NOC that it is not acquired?
Yes, Your Honor.
Yes.
As per annexure F. As per annexure
Why
F.
you have made these private parties as respondents?
They have the BDA has made the mistake in this case, Your Honor, Lordship, and they have admitted in annexure F, Lordship. But they have made the sites and CA site in this Lordship, and one of the site is 474.
So these private respondents have been allotted sites.
Are started constructing the property in this Lordship.
What is there to show it is not acquired?
Not acquired in Lordship. Annexure F they have admitted that they'll correct the layout plan and and everything in the lordship. And annexure B and A-
Please read annexure F.
Yes, lordship. Annexure F, lordship, page number 56, lordship. Number 56 in point number 1, lordship. Antima adhisoochane ದಾಖಲಾಗಿರುವ ಚೆಕ್ಬಂದಿಯಂತೆ ಅಂದಿನ page 56, lordship.
ಹೆಂಗ್ ಓದೋದು ಇದನ್ನ?
Typed copy, lordship. I'll produce the certified copy.
How to read this? It's not even legible.
Sir, Lord, yes.
ಅಂತಿಮ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಟೈಪ್ ಕಾಪಿ ಹಾಕಿದೆಲ್ಲ page 60.
Page 60.
ಅಂತಿಮ
ಅಧಿಸೂಚನೆ ದಾಖಲಾಗಿರುವ ಚೆಕ್ಬಂದಿಯಂತೆ ಅಂದಿನ ಭೂಮಾಪಕರು ನಕ್ಷೆ ತಯಾರಿಸಿರುವ ತಪ್ಪಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಅಂತಿಮ ಅಧಿಸೂಚನೆ ಚೆಕ್ ಬಂದಿಯಂತೆ ಪೂರ್ವ, ಪಶ್ಚಿಮ, ದಕ್ಷಿಣದಲ್ಲಿ ಕಡೆಯಲ್ಲಿ ಸರಿಯಾಗಿದೆ. ಉತ್ತರದ ಕಡೆಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 11/1 ಎಂದು ಇರುತ್ತದೆ. ಅಂದಿನ ಭೂಮಾಪಕರು ನಕ್ಷೆಯ ತಯಾರಿಸಿರುವಂತೆ ಉತ್ತರದ ಕಡೆಯಲ್ಲಿ ತಯಾರಿಸಿರುವುದು ತಪ್ಪಾಗಿರುತ್ತದೆ. They have admitted that they have
yes, I can understand. Please read further.
ತಪ್ಪಾಗಿರುತ್ತದೆ. ನಕ್ಷೆಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 11/1ರ ದಕ್ಷಿಣ ಕಡೆಯಲ್ಲಿ ತಯಾರಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಅದರಿಂದ ಅಂದಿನ ಭೂಮಾಪಕರು ತಯಾರಿಸಿರುವ ನಕ್ಷೆಯನ್ನು ಹಿಂದುಪಡೆಯುವುದು ಸೂಚವಾಗಿರುತ್ತದೆ ಬೇಕಾಗಿರುತ್ತದೆ. ಸದರಿ ನಕ್ಷೆಯನ್ನು ಪುಟ ನಂಬರ್ 42ರಲ್ಲಿರಂತೆ ತಪ್ಪಾಗಿದ್ದು ರದ್ದುಪಡಿಸಬೇಕಾಗಿರುತ್ತದೆ. This is the notification.
Please take out notice.
Yes.
EG is directed to accept notice for R1.
Lordship.
Mr. B.S. Karthikeyan is directed to accept notice for respondent number 2, 3, 4, 5. Issue emergent notice to respondent number 6, 7, 8, 9, 10. Yes.
Lordship. 20.
Lordship. My lordship, interim maybe.
What interim prayer?
Not to alienate and construct further to
not to alienate ಬೇಕಾದ್ರೆ ಕೊಡೋಣ, but construction without ಯಾವತ್ತು ಇವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿರೋದು ಯಾವಾಗ? Private respondents
2025 ಆಗಿದೆ.
Then what were you doing all these days?
We were processing in BDA.
What were you doing all? Then please continue to process in BDA only.
Yes, Lord.
List on ಯಾವತ್ತು ಬೇಕು? When do you want it?
Next week.
Next week process ಇವತ್ತೇ ಕೊಡಿ. List on next Friday.
Interference notice.
No. Next Friday. ಎಲ್ಲೇ BDA ಕೊಡಿ ಯಾವತ್ತದು? 12th August. Yes.
Construction ಮುಗ್ದೋಗ್ಬಿಡುತ್ತೆ ಸುಮ್ಮನೆ, ಅದಕ್ಕೋಸ್ಕರನೇ.
No.
Not to alienate. Not to alienate.
First serve ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ. We do not know what your case is. Mr. Dhanush M. Yeah.
Serial number 20. Dhanush.
Serial number 20. Dhanush.
I'm sorry.
My lord, this is for the issuance of an endorsement that my land has not been acquired, my lord. So survey number 21 in Komgatta village, portion of land was acquired. I am a owner of
B.S. Karthikeyan is directed to accept notice for response 1 and 2. Serve a copy.
Serial number 21. Serial number 21 SM Babu.
Respondent number 6.
Illi Mr. SM Babu illi.
586 in the second one.
Copy illi. Yeah, copy ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
Page number 35.
correct. Petition copy. Where is the petition? If 8196 ಅಲ್ಲಿ petition copy ಇಲ್ಲಿದೆ. No, 8196 dispose ಆಗೋಗಿದೆ.
ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
Dispose ಆಗಿರೋ petition ಅಲ್ಲಿ.
I made an application.
Basically clarification to restrain the order only to the extent which he is called in question.
Then you're not pressing this.
I'm not.
ಬರ್ಕೊಳ್ಳಿ.
Yesterday itself I made.
ನೀವು ಅದನ್ನ ಹೇಳಿಲ್ಲ, ನೀವು ಏನೇನೋ ಹೇಳಿದ್ರಿ ನೀವು. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ ಅಂತ ಹೇಳಿ ಡಿಸ್ಪೋಸ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳಿಲ್ಲ ನೀವು. IA 1/24 is filed by the respondent number 5.
6.
5 ಅಂತ ಇದೆಯಾ ಫೈಲ್? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಅಂತ ಇಲ್ಲಿ ಕರೆಕ್ಷನ್ ಮಾಡಿದಿರ ಇಲ್ಲಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6
ಶಿವಣ್ಣ
ಕೊಡ್ರಿ ಇಲ್ಲ ಯಾವುದು?
ಇಲ್ಲ 6 5 ಅಲ್ಲ 6.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 to restrict the order dated 31/2008 passed in this writ petition only in respect of the land bearing server number 157 and 158. Full stop. The learned counsel for the respondent number 6 does not press this application. Hence, IA 1/24 is rejected. Yes. Next.
APF for the petitioner is serial number 21.2, my lord. 21.2 ಅಲ್ಲಿ ನಾನಿದ್ದೀನಿ.
Yes, Mr. Kamath. In view of the RP order, whether this petition can also be allowed.
ಇಲ್ಲ ಸ್ವಾಮಿ 13 ಯಾವ್ದು ಸ್ವಾಮಿ
13/273 of 2020.
No, it cannot be because there is no reason for in respect this land tribunal matter which came to be allowed now in their favor, that has nothing to do with this. There is a fraud played by the parties before the trial court. It's a court's finding. There are 3 applications. What they have challenged now is there were 3 applications. One I got impleted because section 30.
I remember the facts.
Also.
Now the court took a exception.
Also.
For the petitioners not disclosing the pendency of the proceedings before the land tribunal. No dispute. No dispute.
Also.
But the fact that the tribunal has already granted the occupancy rights.
As on after 8 years. But prior to that, I got impleted in that case. That will have a far-reaching effect on me. Because I want to get impleted in that case.
ಅಲ್ಲೇ ಹೋಗಿ ಮೂವ್ ಮಾಡ್ಕೊಂಡ್ರೆ ರಿಕಾಲಿಂಗ್ ಕೇಳ್ಕೊಳ್ಳಿ.
No, if there is an adverse order, then
because 193 or 195 is as on the date of the representation made by you. If the court has found that you have misrepresented and you have taken the compensation without disclosing the pendency of the proceedings with the tribunal, you go and make a mention before the trial court and seek for recalling this order. I think that is better. ನೀವು ಅಲ್ಲೇ ಹೋಗಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ.
One more IS.
Sister, this order is on that particular day. On that particular day, you did the mistake. You go before the same.
Aspect, I would like to make it very clear. In section 18 land tenancy lands in question, which are subject to the acquisition during pendency of the proceedings. Then an 18 application was after service of notice under 12(2). We made a request for referring the matter to the civil. It is the tenancy. In that application, it is not need for us to say anything, all these aspects of the matter. We only said, award amount is inappropriate, kindly refer the matter to the civil. Then once the matter reached to the civil court, it is for the benefit of acquisition to make all the parties and ask the court send the notices and other things.
Yes.
Now, my lord, question is now therefore your lordship slightly granted liberty for him while challenging the later order of the land tribunal. He can raise all these contents
Yes.
to the review. That was
Okay,
the
na?
order your lordship passed.
I think you should go back
And
before
even
the
such
court.
a liberty also this could be disposed of, allowing the petition part in the order.
You go before the same court and give all the details about the disposal before the land tribunal.
Yes.
I appear in the next matter, my lord, it is similar matter. The order could be common or it's different. Same.
So both these petitions can go back to the trial court. Let you make an application before the trial court, before the reference court. Barkoli.
They redeposit, one submission, my lord, they redepositing and the prosecution or the orders passed. I have not received the amount, actually others have received, whatever it is. Now the redepositing and this prosecution has to be set aside. These all the request.
Now, if you're not taken the money, then there's no need to redeposit.
No, that's
Whoever
why.
has
That's
taken
why.
the money,
That's why. That's why I have made a submission on my behalf. Somebody else has taken it. Anyway, that's between me and the other respondents. What I am saying is the prosecution and against me, number 8. 8 is dead now. LRs. Well, that I am challenging in this. That's all. Other things are same.
ನೀವು ಅಲ್ಲೋ try ಇದರಲ್ಲಿ prosecution initiate ಮಾಡಿದ್ರೆ you go and establish that you are not the one. You go and
Anyway,
establish somebody else has taken it.
Now your lordship is setting aside that order. Then it could be again.
I'm not setting aside this order. I'm not setting aside this order. I'm only saying, so far as Mr. Srinivas' client is concerned, I'm only saying you go back before the reference court and give whatever submissions that you want to make and seek for recalling this order in view of the order passed by the land tribunal now.
Same applies to me also, my lord. I am one of the claimants.
You also go before the court.
Very well. Be heard here.
No.
Whether that
No,
could be
no.
gone into by this honorable.
No. The proceedings before the court has taken an exception in the way you have represented to the court and collected the compensation. You did not disclose before the court about the pendency of proceedings before the tribunal.
Let me make a note this below. A reference application is filed by the tenant.
Yes.
Landlord did not file any application for reference. At our instance, reference court enhanced the compensation. Our compensation which was enhanced was a subject matter before this honorable court.
You go and tell all these things to the reference court only. Barkoli.
But this order
common order to be passed, or you want a common order to be passed?
Prosecution of the state, my lord.
Huh?
Independently, this order regarding prosecution could be set aside or stayed.
No. I will not set aside anything. You go back before the trial court. Barkoli.
Let
Now I will hear you separately, Mr. Sharma. If you want a separate order, I will hear you separately.
I am similar.
Permit me to
There is no
dispose of.
common. ಒಂದೇ ತರ ಮಾಡಿದ್ರೆ ಸಾಕು. I am not saying independently. Your lordship will dispose of similarly.
Yes.
In fact, even in an 18 deference proceeding, we are also referred to the pendency of the section 30 proceeding. The matter is before the very same court. Question of perjury does not arise in our content.
Yes. Now when 3031.
There are two proceedings are pending before the civil court. One is under section 18 and another under section.
How will the judge know whether there is 3031 reference or not?
We refer to in our proceedings. We make a statement also. There's a 30 proceedings is pending, compensation at our instance, and we permitted the other side, if they are repeated, we have no objection to withdraw the compensation.
The way in which it is done is much to be desired.
Kindly see page number 138 for a while. Page number 138. And the evidence, both are there on record. We never conceded, we never said, we never misled. LAC 26 of 2014 pending on hearing, that is 30 reference. Once when 30 reference is told, the court would have taken cognizance of that also, because it was before the same court.
Correct, Mister. This is some kind of a conspiracy between you and KADB.
Yes.
KADB appeared before.
Yes, my lord.
Conspiracy does not arise. May kindly go to page 142.
ನಿಮ್ದೇನಿಲ್ಲ ಆಯ್ತು ನಿಮ್ದು. You can go. ಅವ್ರು ಐఏ ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ.
My lord, annexation
My
came
name may
and-
be deleted from that.
ಏನಕ್ಕೆ?
I am no longer appearing in that case.
No, but he has withdrawn the application.
On submission, ಅದರಲ್ಲಿ ಇನ್ಫ್ರಕ್ಷನ್ಸ್ ಅಂತ ಆಗಬೇಕು, ಡಿಸ್ಮಿಸ್ ಅಂತ ಆಗಿದೆ.
Not pressed ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಿ.
ಡಿಸ್ಮಿಸ್ ಅಂತ ಆಗಿದೆ.
Varkol, the petitioners have called in question the correctness of an order dated so and so, passed by so and so in LAC number 5/2016. Held.
That page 142 annexation came, only for my satisfaction, may kindly.
This is 142, na?
Yes. It is a statement given by Shivraju Sarna State India. Then my lord, your lordship may kindly go to page 143 paragraph 4. ನಾನು ಪ್ರಮಾಣೀಕರಿಸಿ ಹೇಳುವುದು ಎದುರುದಾರರು ವೈಯಕ್ತಿಕ ಅವಾರ್ಡನ್ನು ಹೊರಡಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ತಿಳುವಳಿಕೆ ಇರುವುದಿಲ್ಲ. ನಾವುಗಳು ಎದುರರ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. ನಮ್ಮ ಜಮೀನು ಮತ್ತು ಇತರೆಯವರಿಗೆ ಸೇರಿದ ಪೂರ್ಣ ಪರಿಹಾರದ ಮೊತ್ತವನ್ನು ಎದುರುದಾರರು ಮೈಸೂರು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ LAC 26/14 ಠೇವಣಿ ಮಾಡಿರುವ ಅಂಶವು ನ್ಯಾಯಾಲಯದಿಂದ ನೋಟಿಸ್ ಬಂದ ನಂತರ ನಮಗೆ ತಿಳಿದಿರುತ್ತದೆ. 26 we refer to about pendency of such.
Correct, but why did you not bring this to the notice of this court when an order was passed?
Yes.
That there is a 3031, so therefore I can't receive it. ಅದು ನೀವು ಇಲ್ಲಿ ಹೇಳ್ಬೇಕಿತ್ತಲ್ವಾ ನೀವು?
This court has not passed an order.
This court,
Order is
no.
passed by the LAC court.
No, that is right. KDB counsel came before this court and said that this issue, you made a submission that this issue is covered by some judgment. KDB advocate said yes. Court said, okay, release the compensation. So you did not say that there's a 3031 reference. So therefore, the judgment passed in which you referred has no bearing on the facts of the case in that writ petition which KDB filed. You never said that.
Yes.
You indulge in a conspiracy with KDB and to obtain the compensation.
Yes.
So that the court has taken exception. And thereafter you went before the court, took the compensation. This Barkul. I think that is not correct.
One aspect I would like to make under the legal proposition. Section 47 of the Karnataka Land Reforms Act determines what the compensation is entitled by the landlord is concerned. It is not a case of claiming apportionment under Section 30 of the Act. Anyhow, my lord, your lordship is now sending it back to the trial court, the LAC court. Your lordship may kindly pass the order and let the reconsider.
No, I will not pass the order. I will not set aside. No, I will not set aside this order. Barkul, ಏನಾಯ್ತು? In terms of which, it allowed IA number.
Lordship, I think giving liberty for them to make an application for recalling that.
Yes.
In the light of the latest development.
Page number 45.
In terms of which it allowed IA number 21,
22,
20 and 23.
19 to 20.
19 to 22. In terms of which it disposed of IA number 90 to 22 and directed the petitioners herein. ಯಾರು? ನಿಮ್ದೇ ಯಾವ ಅಪ್ಲಿಕೇಶನ್?
Which has happened finally, it has nothing to do. Now your lordship cannot relegate I number 19 and 22.
I am not saying.
So far as I number 21 is concerned, it has to be held back.
So far as IA number 21. In terms of which it allowed IA number 21.
19 is we coming on record, my lord.
In terms of which it allowed IA number 21 and directed the petitioners herein to redeposit
21 and 23.
ಬಂದೆ ತಾಳಿ ಸರ್ 21 23 ಅವ್ರದ್ದು ಇರಬೇಕು
ಅಲ್ಲ ನಂದು
ನಿಮ್ದು
ಸೇಮ್ ಅಪ್ಲಿಕೇಶನ್
ನಿಮ್ದು ಯಾವುದು
21 and 23 5 and 6 ಗೆ
ಅದು ವೈಕನಾಥ್ ಶರ್ಮಾ ಹಾಕಿರೋದು
ಅಲ್ಲ ಈ ಪಿಟಿಷನ್ ಅಲ್ಲ this 13/273 ಅಲ್ಲಿ
21 and 23
yes
in terms of which the petitioners herein were directed to redeposit the compensation received and a direction was issued to the Chief Ministerial Officer of the court to initiate proceedings under section 191, 193 of IPC, read with section 340 of CRPC.
In
Full stop.
case it is not redeposited, the conditional order, my lord, in case it is not redeposited, or their failure to deposit at the, on their failure to deposit, sir.
On the failure of the petitioners to redeposit the compensation. Next para. Though the petitioners have filed an elaborate writ petition, the necessary facts for consideration of this writ petition are that the land in survey number 159 of Kurgalli village, Ilwala Hobli, measuring 7 acre 38 guntas, was the subject matter of form number 7 filed by the petitioners before the land tribunal. Full stop. The respondent
Petitioner and respondent number 7 to 11.
Respondents number 7 to 11. Full stop. It appears that during the pendency of the proceedings before the land tribunal, the land in question was acquired under the provisions of the KD Act. Full stop. The notified khatedars were the petitioners and the respondents 7 to 11. A general award was passed, followed by a supplementary award dated 2/3/2013, and the compensation was determined at a sum of rupees 1,82,000 per acre. Full
Yes.
Which was later enhanced to rupees 75,38,648 in LAC 46 of 2014 before the 5th additional senior civil judge Mysore. Full stop. The petitioners 1 to 3, 4 to 6 and respondents 7 to 11 filed applications under section 18 of the Land Acquisition Act seeking reference for enhancement of the compensation.
Respondent 4 to 7, they are not made any application.
7 to 11.
7 to 11 only. Landlords have not made any
No,
application.
landlords petitioners 1 to 3, 4 to 6 and respondents 7 to 11. For enhancement of the compensation. Full stop. Thereafter, the same was referred to the civil court and registered as LAC 5/2016. The petitioners and the respondents 7 to 11 filed claim petitions and adduced evidence in support of their case. The reference court was pleased to pass an award on 21/4/2018, enhancing the compensation to rupees 15 lakhs per acre with statutory benefits. Full stop. The Industrial Area Development Board challenged the aforesaid order passed by the reference court in WP number 47045 of 2018. Full stop. During the pendency of the writ petition, a statement was made by the learned counsel for the petitioners that the issues raised in WP number 47045 of 2018 were squarely covered.
195.
195. Squarely covered by the order of by an earlier order of the court in WP number
55485.
In WP number
55485
of 2017 and connected writ petitions that were disposed of on 20/11/2018. This was not disputed by the learned counsel for the KIADB. Full stop. A submission was made by the learned counsel for the petitioners, by the petitioners herein, that the board had permitted withdrawal of 50% of the compensation determined, which was also not denied by the counsel for the KIADB, and who agreed to deposit 50% of the compensation payable under the judgment and award passed in LAC 5/2016. Full stop. Accordingly, the judgment and award passed in LAC 5/2016 was set aside, and a direction was issued to the KIADB to deposit 50% of the compensation determined in the award in LAC 5/2016 that was quashed. Full stop. It appears that the KIADB deposited the compensation as directed by this court, which was withdrawn by the petitioners herein. Full stop. Thereafter, the respondent number, yaar hakid application na? 19 to 21.
We are 3 and 4. 3 and 4.
Respond number 3 and 4. Respond number 3 and 4.
3 to 6.
3 to 6. 3 to 6 filed applications in LAC 5/2016 to come on record.
26. 5.
Their contention was, their claim to come on record was that proceedings before the land tribunal had not attained finality, and that therefore the petitioners herein were not entitled to receive the compensation. Full stop. Likewise, two applications were filed, bracket IA number 21 and 22. To direct the petitioners herein to
21 and 23. Sorry.
23 to direct the petitioners herein and respondent number 7 to 11 to redeposit the compensation. Full stop. The reference court, after perusing the contentions raised and in view of the undisputed fact that proceedings before the land tribunal had not attained finality, passed an order permitting the respondents 3 to 6 to come on record, and also allowed the applications filed by them and directed the petitioners and respondents 7 to 11 to redeposit the compensation, failing which the chief ministerial officer of the court was directed to initiate proceedings for prosecution for offence under section 193, 191, 193, read with section 340 of IPC and section 340 of CRPC. Being agreed by the aforesaid order of the petitioners are before this court.
So far as the land is concerned, which the first have been made, we have protected it by bringing the objections as a final because the demand was done at the instance of only one tenant, not at the instance of this applicant. So therefore,
that is not the issue. The issue was
now here the challenge point the objections we have contended. There are two landlords here. One tenant, one landlord have called in question. The land which is acquired belongs to the other landlord who was not challenged the order of the occupancy right. 8196 was challenged by only one of the landlords. MC Nagaraja have never challenged it. But by remanding, it has remanded it in its entirety.
That challenge that order passed in the writ petition.
Once again, clarify
writ petition clarification kelkoli.
It was restricted only to 157 and 158. 159 was never challenged before the sample court. But however, it was remanded. Now, my lord, these people are coming to play picture Only after the 26 notification, NAC 26 have been registered and they gone and they are there. Till then, they have not appeared there also before the land
Sir,
tribunal.
then you have to challenge the order passed by this court remanding the matter in entirety.
Then our clarification
Sariyo
is
tappo, sarino tappo, all three survey numbers are before the tribunal.
Yes, ma'am.
ಅಲ್ಲ, ಅದನ್ನ ನಾವು ಹೇಳಿದ್ವಿ.
That may not, that may not be correct, my lord. I have come before this court, my petition also remanded back.
Yeah.
He is my brother, one brother. If I get land, if I get tenancy rights.
No, my lord, I don't get. That is not the direction.
He is not representing landlord.
He is not.
He is a family member of
The learned counsel for the petitioner submitted that the respondents 3, 4, 5 and 6 are interested only in the land bearing survey number 159 of Kurgalli village and not survey number 157 and 158. He contends that the occupancy rights were granted in favor of the petitioners in respect of survey number 157, 158 and 159. Muruna. And that it is only the owner of land in survey number 159, 157, 158, which was challenged before this court. But instead of remitting the case only in respect of survey number 157 and 158, this court had remitted the case in respect of all the three survey numbers.
It has never stated like that. Allowed and remanded. ಅಷ್ಟೇ ಹೇಳಿದ್ದು.
Entire order is passed and send it back to them.
And that the order passed by the order, ಅದೇ clarification ಕೇಳ್ಕೋಬೇಕಲ್ವಾ ನೀವಲ್ಲಿ?
ಅದನ್ನೇ ನಾನು 15 ಹೇಳಿದ್ದು. ಅಷ್ಟೊಂದು land tribunal order ಬಂತಲ್ಲ ಅಂತ ಹೇಳಿ.
And this court had quashed the order passed by the land tribunal and sent it back to the tribunal for reconsideration. He therefore contends that the respondents 3, 4, 5 and 6 have in fact lost their right in respect of the land in survey number 159 as they did not question the order passed by the land tribunal, and the claim of the petitioners insofar as claim of the petitioners to receive compensation insofar as survey number 159 is justified, and that they did not, and that therefore they are not liable to redeposit the compensation. Full stop. Per contra, the learned counsel for the
One submission. I am sorry for the interruption. I want to make one additional submission because IA 20 and 23 is not against me. It's only against Shivaraju and claimant number 2 and 5 only. So the order against me to redeposit is not correct. Even the drawing was only by those two persons. So that
I'll come to you, sir. I'll pass a separate order in your case. Please wait. Yes.
Very well.
Full stop. Per contra, ಅದಕ್ಕೆ ಮುಂಚೆ, he also submitted that the tribunal has now passed an order granting occupancy rights in respect of survey number 159, in which the respondents 3, 4, 5 and 6 are interested, and hence the question of redepositing the compensation would not arise. Full stop. Per contra, the learned counsel for the respondents 3, 4, 5 and 6 would submit that the trial court, the reference court, after noticing that the petitioners had not disclosed the fact of pendency of the proceedings before the tribunal, and while getting a disposal of WP number 40 ಎಷ್ಟದು
47054.
And in not disclosing the
ಆ ರೀತಿಯಲ್ಲಿ ಇವ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಕಂಟೆನ್ಷನ್ ಇತ್ತು. ಅದ್ರಲ್ಲಿ ಏನಿತ್ತು ಅಂದ್ರೆ SLO ಮಾತ್ರ ಪಾರ್ಟಿ ಇತ್ತು LAC 5 ಅಲ್ಲಿ. ಬೋರ್ಡ್ವೇ ಪಾರ್ಟಿ ಇರಬೇಕು ಅನ್ನೋ ಒಂದು ಕಂಟೆನ್ಷನ್ ತಗೊಂಡು KDO ಬಂದಿತ್ತು. ಬೋರ್ಡ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ CEO. ಅವರಿಲ್ಲ ಅನ್ನೋ ಒಂದು ಕಂಟೆನ್ಷನ್ ಗೋಸ್ಕರ ಬಂದಿದ್ದು.
ಅಲ್ಲ ಕರೆಕ್ಟ್
ಹೇಳಿ ಡಿಮ್ಯಾಂಡ್ ಆಗಿತ್ತು ಅಷ್ಟೇ.
ಏನಾಯ್ತು?
ಇವ್ರಿಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ. He is misleading about it.
And in not disclosing the pendency of proceedings under section 30 and 31 before the reference court. Full stop. He therefore contends that the reference court, taking into account the above circumstances, has felt it appropriate to direct the petitioners to redeposit the compensation, failing which necessary action would be taken. He contends that the fact of pendency of the proceedings before the land tribunal at the relevant point of time when WP number
47045
was disposed of is not disputed, and therefore disputed. He therefore submits that that no fault can be found with the order passed by the reference court. Full stop. I have considered submissions of the learned senior counsel for the petitioners and the learned counsel for the contesting respondents 3, 4, 5, and 6. Next paragraph. The petitioners seem to have received 50% of the compensation determined by the reference court in LAC 5/2016 based on the order passed by this court in WP number 47045 of 2018. Full stop. A perusal of this writ petition, the order passed in this writ petition, would indicate that the judgment and award passed by the reference court in LAC 5/2016 was questioned. Full stop. A submission was made by the learned counsel for the petitioners herein that the issue raised in WP number 47045 of 2018 is squarely covered on all fours by the judgment passed in WP number
55485, page 195.
WP number 55485 of 2017 and other connected matters, which were disposed of with a order dated 2011-2018. In addition, it was contended by the learned counsel for the petitioners in that writ petition in WP number 47045 of 2018 that the board had consented to release 50% of the compensation determined by the reference court in other cases. Full stop. These submissions made by the learned counsel for the petitioners was not disputed by the counsel for the board for the KADB. Full stop. Therefore, this court in good faith disposed of WP number 47045 of 2018 and set aside the judgment and award passed in LAC 5/2016 and also directed the KADB to deposit 50% of the compensation as determined in LAC 5/2016. Full stop. It is not in dispute that the proceedings relating to grant of occupancy rights in respect of survey number 157, 158, and 159 were under consideration before the land tribunal, to which the petitioners were parties. Petitioners and the respondents 3, 4, 5, and 6 were parties. Full stop. The petitioners, it also appears that a proceeding under section a reference under section 30 and 31 was pending in LAC number
26 of 2014.
26 of
2014 that was pending, where the petitioners 1 to 3, 4 to 6, and respondents 7 to 11 were parties. Yes. Full stop. The petitioners, therefore, without disclosing the pendency of the proceedings before the land tribunal and without clearly disclosing the pendency of LAC 26 of 2014, which was a reference under section 30 and 31, claimed 50% of the compensation that was deposited by the KADB before the reference court. Full stop. It is only after realizing that the petitioners had walked away with the compensation that an application was filed by the respondents 3, 4, 5, and 6 to come on record in LAC 5/2016, which were allowed and an application filed by the respondents 3, 4, 5 and 6 for a direction to redeposit the compensation was also considered favorably. Full stop. It is now contended by the learned counsel for the petitioners that the proceedings before the tribunal has come to an end and occupancy rights in respect of the land in survey number 157, 158 and 159 is granted in favor of the petitioners, and therefore the order passed by the reference court directing the petitioners to redeposit the compensation has lost significance and is unenforceable. If the petitioners have been granted occupancy rights, they are bound to approach the reference court and make appropriate application bringing to the notice of the court the order passed by the land tribunal, and that they are not liable to redeposit the compensation in view of their redemption of their tenancy rights. Full stop. As the impugned order is passed at a relevant point of time when when the proceedings before the land tribunal was still pending, this court does not see any illegality in the order passed by the reference court. It is therefore this writ petition deserves to be disposed of, directing the petitioners to approach the reference court and file appropriate application bringing to the notice of the court the order passed by the land tribunal. And full stop. The reference court may now take into account the subsequent events and assess whether its order dated so and so has to be implemented or can be exempted from being enforced. The writ petition therefore stands disposed of on the above terms, upholding the order passed by the reference court and also granting liberty to the petitioners as stated above. Yes. Nimdenelli.
Nandu, your lordship want me to say, my lord?
Till this exercise is completed, interim order is there, that could be continued.
Till the aforesaid exercise is completed, the petitioners are exempted from depositing the compensation. Yes. As ordered by the trial court in terms of the impugned order. Yes.
Can I take leave, my lord? My role is over.
You can take leave, we can't take leave. Yes. Yes, Mr. Sharma. Nimdenelli.
My only submission is, your lordship,
You can also go.
Before the final order, operative portion of the order, the lordship kindly note my submission. It could be common order, need not be separate. What I am submitting is, I am contending that the applications filed are against only, please receive my petition in that IA 20 and 23, because these two persons are the persons who received the check. The application is only against those two. That could be examined by the trial court. That's what I am IA 20 ನೋಡಿ page 134. ನನ್ನ writ petition ಅಲ್ಲಿ 134 page 4.
134 132 ನ
134 ಅಲ್ಲಿ 132 ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ. 134 ಅಲ್ಲಿ ನೋಡಿ IA ನಂಬರ್ 20 ಅದು. ಅದರಲ್ಲಿ ನೋಡಿ ಅಪೋಸೆಂಟ್ಸ್ ಆರ್ A and B, ಶಿವರಾಜು and ಶ್ರೀನಿವಾಸ್. ಕ್ಲೈಮೆಂಟ್ ನಂಬರ್ 2 and 5.
2 and
ಹೌದು.
2 and 5.
ಹೌದು. And ಇನ್ನೊಂದು ನೋಡಿ page 154. That is IA 23. These are the only two applications and one section.
ನಿಮ್ಮ ಕೇಸಲ್ಲಿ ಕ್ಲೈಮೆಂಟ್ಸ್ 2 and 5 ಯಾರ್ಯಾರು?
2 and 5
ನಿಮ್ಮ ಕೇಸಲ್ಲಿ ಕ್ಲೈಮೆಂಟ್ಸ್ ಶಿವರಾಜು and ಶಿವಣ್ಣ. Who are the petitioners here? Jayalakshmi.
Jayalakshmi is number 8. Claimant number 8. Claimant number 8. 8 died and ABCM also. 8. Claimant number 8 ನಮ್ಮವರು.
ಅಲ್ಲ ಸರ್, ಪಿಟಿಷನರ್ ಜಯಲಕ್ಷ್ಮಿ, ರಮೇಶ್, ರಾಮಕೃಷ್ಣ, ಸುಮಿತ್ರ ಇವ್ರು ಯಾರು?
ಅವರೇನೆ, they are the 8 daughter and sons of late Shivaramegowda, who is respondent number claimant number 8, because he died.
Claimant number 8 ಮೇಲೆ ಆರ್ಡರ್ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಇದೆ.
No application.
My lord.
See, this application IA number 20
yes
is only in respect of Shivaraju and Shivanna.
That's what I am pointing out. But the order is against me. But the order against me. 8 also. Please see the order. Please see the order page. Page number 40 ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ. Page 40. The impugned order.
Yes, Bodhi.
IA number 21.
Claimant.
File, you
Hmm.
lost got it?
Yes, sir, I got it. Please read.
IA number 21 filed by the applicants number 1 and 2 under 151 CP directed to deposit 1 lakh etc. hereby allowed, and different 1 to 3 are hereby directed to deposit so and so, and claimant number 4 to 8 are hereby directed to deposit so and so. That is what regarding deposit. Next, my lord, on
Yes.
failure to show against all the claimants, the
Yes,
action will
claimant
be
number
taken
8
against
ಮೇಲೆ
all the
ಏನಿದೆ?
two. My lord.
We have not raised.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
No,
Claimant number 8 ಮೇಲೆ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
only 2 and 3. 1 and
2 and 5.
yes,
ಹೌದು,
Shivraju and Shivana.
correct.
2 and 5 in their case. In my case, only 2.
Only,
So this can be allowed.
IA 23,
So this can be
23
allowed.
ನೋಡಿ, IA 23 is page 154. ಅದರಲ್ಲಿ ಓನ್ಲಿ ಶಿವರಾಜು ಇದ್ದಾರೆ, claimant number 2, opponent.
Madam Barkul,
This may be added.
the petitioners have challenged the correctness of an order dated so and so, passed by so and so in LAC number 5 or 2016, in terms of which the reference court directed the predecessor of the petitioner to deposit, to redeposit the compensation received in respect of the acquisition of land in survey number 159 of Kurgalli village, full stop. Next para. ಅದು ಫಸ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ, then as it is copy ಮಾಡಿ. The learned counsel for the petitioners submitted that IA number 20 filed by the respondent number
20 and 23,
IA
both.
number 20.
23 also.
ಇಲ್ಲ 20 is filed by 3
ನಿಮ್ಮ ವಿರುದ್ಧ 20 ಮಾತ್ರ ಸರ್.
ಇಲ್ಲ
20
23
now file ಮಾಡಿ. 23 is filed by them.
23 is filed by whom?
Filed by us, mother.
ದಿವಾಕರ್.
ದಿವಾಕರ್.
ಪೇಜ್ ನಂಬರ್ 282 ನಲ್ಲಿ ಇದೆ.
154 ತಾವು ನೋಡಿ. 154.
IA ಮತ್ತೆ affidavit itself is there in page 282.
ನನ್ನದ್ರಲ್ಲಿ 154, ಅವ್ರದಲ್ಲೆಲ್ಲ, ನನ್ನದ್ರಲ್ಲಿ 154 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. 154.
ಮಧ್ಯದಲ್ಲಿ ಒಬ್ಬೊಬ್ಬರಾಗಿ ಮಾತಾಡ್ರಿ ದಯವಿಟ್ಟು. You might think it's a joke.
I'm sorry. I'll wait.
See, in your case, you are agreed by the order passed on IA number 20 or 23?
Both. ಯಾಕಂದ್ರೆ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಲಾಸ್ಟ್.
IA number ಸ್ವಲ್ಪ ನೋಡಿ. IA number 23 ನಲ್ಲಿ ಶಿವರಾಜು is the claimant from whom compensation is to be recovered.
ಕರೆಕ್ಟ್. ಎರಡರಲ್ಲಿಯೂ ನನ್ನ ಹೆಸರು ಇಲ್ಲ. ಕ್ಲೈಮೆಂಟ್ ನಂಬರ್ 8 ಗೆ ಅಗೇನ್ಸ್ಟ್ ಇಲ್ಲ ಅಪ್ಲಿಕೇಶನ್.
Therefore IA number 21 ನಲ್ಲಿ opponent is Shivlingegowda
21 ಅಲ್ಲ,
and 8 others. 20 ನಲ್ಲಿ it is
ಶಿವರಾಜು ಶಿವಣ್ಣ.
Shivraju and Shivanna.
ನಾವಲ್ಲ.
Shivraju and Shivanna. The learned counsel for the petitioner submitted that the application filed by the respondents 3, 4, 5 and 6, sorry 5, 6, 7 and 8, 5 and 6 are not in respect of the predecessor of the petitioner, but yet the reference court has passed an order directing the predecessor of the petitioners to redeposit the compensation.
Predecessor ಇಲ್ಲ. Petitioners themselves. ಯಾಕಂದ್ರೆ they have come on record.
Petitioners. He contends that the petitioners have not received the compensation in respect of the land in survey number 159 of Kurgalli village is concerned, and therefore the order passed by the trial court directing the petitioners to redeposit the compensation is liable to be set aside. Next paragraph. The learned counsel for the respondents 2 and 3, 3, 4, 5, 6 do not dispute that the application filed by them in IA number 20 and 21, 21 and 23. 20,
No, 23 only.
20 and 23.
20 and 23 do not relate to the petitioners.
No. 20 is filed by 3 and 4 son. ಅವ್ರು ಹಾಕಿದ್ದಲ್ಲ.
ಅಲ್ಲ, ನೀವು ಹಾಕಿದ್ರಲ್ಲ ಅವ್ರಿಲ್ಲ ಅಂತ.
ಹೌದು.
ಅದನ್ನೇ ಹೇಳ್ತಿರೋದ್ರಿ ನೀವ್ ಹಾಕಿರೋದು ಅವ್ರಿಲ್ಲ ಅದನ್ನೇ ಹೇಳ್ತಿರೋದು. Relate to the petitioners and that the petitioners have not received the compensation as held by the reference court. Full stop. In view of the aforesaid submission, comma, this petition is allowed and the impugned order passed by the reference court is set aside insofar as the petitioners are concerned. Yes.
So for IA 20 and 23, like an impleading application or other IA relay.
Adhe tondre ilvalla. That I am not disturbing. Yes. Insofar as IA number 20 and 23 is concerned. Yes.
Yes. Others I am not disputing. Let them come on record.
Yes. Next.
Administrating order, serial number 22, Shruti C.
My lord had asked me about the drawdown from, so if at 70 kilometer, it is 1289 cusecs.
They're threatening me with a big bundle of papers again.
No, this is just the writ petition.
Oh.
I'm just holding
Hope you don't file it.
My lord had asked for the drawdown. If it is at 70 kilometer, it is 1289. Then what is it at the remaining chainages? My lord would please see at page 297 of volume 2, 17105 writ petition.
After the remodeling.
The reach-wise cutoff statement is there. I've placed it on record. And I didn't realize, I'm sorry, it didn't flash when the court asked me, but the drawdown is here.
Volume 2 kodavekante 17105.
105.
Yes, please.
At page 297, my lord would see serial number 1, chainage in meters. So that's in km will be 70.360. Column 13, if my lord sees, it is 1289. Then this is the required discharge. Then my lord would see design discharge in column number 25 is 1430. Then 1430.
1430.
That is designed discharge. Now each serial number goes to the drawdown reach. As the water is drawn,
yes,
the quantum of water will reduce. Then my lord would please see on page 306.
No, this is not after modernization. This is for modernization.
For modernization.
So what is the?
This is how it has been. The remodel canal has been
Correct,
designed.
but after modernization, has
The actual discharge they have to give. Actual. So here, I'll just come to that point in actual discharge in a moment. My lord would just see serial number 172 on page 306. That is chainage is 166 kilometer. That is as per my statement, which is before distributory D26 anta irodu, 166. Illi my lord would see in column number 11, it is 264 cusecs is the drinking water requirement. Sorry, column number 13, total discharge is 565 cusecs. Then my lord would see the design discharge is 816 cusecs. That is what the remodel canal is designed for. Then my lord would see 173 is 166.420 chainage. Required discharge is 565 cusecs. That is column 13. Column 25 design discharge is 902. Because there's some cover duct or something over there. Then my lord would say 174, 166.444. The required discharge in column number 13 is 565 cusecs and the designed is 597. Then at 166.890, it says the discharge required is 388 cusecs. So now my lord would see in this slide, the documents that they placed on record yesterday, they are saying that they've taken my statement, which is at 166 cusecs, the quantum of water that's available. Now, in fact, before I come to that, if in volume 1, my lord would just see 2 documents. First, I'll show the government order of 2019. at page 170. Sorry, before that I'll show 169, which is the Kaveri award. Page 169. Serial number 12 is Hemavati. My lord has it?
Yes.
The total allocation for Hemavati is 43.67 TMC.
Yes.
Then my lord would please see page 170.
170.
170.
Yes.
It says Tumkurige Vottu 25.31 TMC. This includes TBC and NBC from what I'm given to understand. Now, my lord would please see the map at page 167. From that, my lord would see that at the on the far left hand side that Bagur Navil tunnel.
Yes.
Then Y alignment. From Y alignment, right side is Nagamangla, left side is Tumkur branch canal. Then my lord would see distributory 26. They're just above that 160 on the right side of the page, just above 165.60 kilometer.
Yes.
History 26. That my lord would see ends at water body, which is actually the Mangala Dam, sorry, the Markonahalli Dam, I think, which is, and if my lord traces that blue line that goes above that, that is the Shimsha River.
Yes.
Now, Turuvekere Taluk comes on the left side. Yesterday I had mistakenly submitted that CS-Pura village is in Turuvekere Taluk. It's actually not, it's in Gubbi Taluk, but Turuvekere Vidhan Sabha Kshetra.
Yes.
So whatever falls on the left side of the Shimsha River, that is the Turuvekere Taluk boundary. No doubt they've placed a 1999 DPR which says that there is allocation to Turuvekere, but this is their own map showing the alignment of TBC and Nagmangla branch canal. And admittedly, unless they're able to establish that after Shimsha River also Turuvekere boundary extends, the Turuvekere Taluk is only before it. So distributory 26 only passes for a certain extent through Gubbi Taluk and for the larger extent through Kunigal Taluk.
Yes.
Now, my lord, unless they're able to say that at 0 kilometer, the 25.31 TMC is actually available in any given year, the 3.04 allocation to Kunigal Taluk would depend upon 25.31 actually being discharged at 0 kilometer.
Yes.
In fact, what I'm given to understand is that in the last few years, the discharge has only been between 16 to 18 TMC.
Yes.
If that is averaged, it is 17 TMC. Now 17 TMC on the total allocation for Tumkur is 67.18%. So what the water management system of the government has to do is that when there is reduced receipt of water, then they have to manage it proportionately
No, madam,
across.
see, I'll tell you. Suppose if there's a reduced flow,
My lord.
the responsibility of the government is to ensure that water is provided for drinking first.
No. May I just?
That is the responsibility of the government.
No doubt about it. Absolutely no dispute.
Whether it is, if it is used for irrigation, irrigation can be cut down, but people have to survive. Suppose if in this year,
There is no
there's a
dispute
drought-like
with the
situation in this year. There's a drought-like situation this year. Suppose if there's a reduced flow of water, then from up to say 167 kilometer, if there is pilferage, people draw water for irrigation. I'm just giving you an example. It's only hypothetical, which could be true, because in a drought-like situation, it is quite possible that people in a desperate attempt to save their crops will pull out water from the canal. The net result would be at the tail end. At the tail end, there will be no water for drinking water to Kunigal and Magadi. If that is the situation, even if there's a remodeling of the TBC, in case of a situation where no water reaches the tail end because of various circumstances, is it unviable for the government to take an express pipeline from 70 kilometer to 167 kilometer only for the purpose of ensuring drinking water to the other villages in Kunigal and Magadi, within the allocated
There is
water.
absolutely no dispute with the proposition that the court is placing.
Hmm.
My submission on this is twofold. One is, if my lord just sees that government order at page 170, there is an allocation to Tippuru, Turvekere, Chiknaikahalli, Gubbi, Tumkuru, Kunigal, Channarayapatna, Nagamangala, Shira, Madugiri, Magdi, Arasikere, Kaduru, and Hosadurga. There is an allocation for all of this. So what happened, what the government must do, and what the government does in fact, is that this is a total 100% allocation. So depending on the discharge of water at the head chainage, it is proportionately reduced. Because if only 67% water is available, 67% to that extent, all proportionate percentages are reduced. That is water management in any gravity pipeline.
Correct, but in
No.
Magadi and Kunigal, you can't tell people to drink half of what they have been
No,
drinking.
my lord would just please appreciate this in another light, which is that the Hemavati Reservoir project was an irrigation project. Drinking water projects were super added to it. So water is now being prioritized for drinking water projects. And in fact, my lord would see, when they say that distributory 26 is drawing water, if they can place on record the notification of the command area for any of the distributaries, then I would be pleasantly surprised. For the reason, my lord, water is flowing in the distributaries only for the purpose of filling up of tanks.
Correct.
It's not actually neither has the command area been notified, nor is any water going through the pipelines into the command area.
Yes.
Now, but be that as it may, I just wanted to cycle back to one proposition, which is to say that their Sriranga DPR, when seen alongside the remodeling DPR, are identical in terms.
Could be.
There is there is absolutely no material that they've placed on record to show that there is, in terms of actual availability of water, that there is any kind of deficit except giving magical numbers and percentages.
Yes.
They've taken my numbers for 168 days. They've calculated the average flow of 202 cusecs on the basis of that 168 days, whereas that's not the way the calculation is done. For irrigation, calculation is done for 120 days, and for drinking water for 60 days. That is their own numbers. It's not my numbers. Now, my lord would only see one thing. There is no, in my respectful submission, Turvekere, in the actually executed distributory 26, unless they say that Turvekere Taluk also extends beyond the Shimsha River boundary, there is actually no allocation for Turvekere. It is only Gubbi Taluk, about 10 to 15%.
No, it is given.
Kunigal.
It is given. D26 goes to Gubbi, it goes to Turvekere also.
It is not how it has been executed. I've placed their own map on record. The execution, it is going only to Gubbi and Kunigal. They have not superimposed it on the Google map to show that it's actually going to Turvekere Taluk. They've given a 1999 document, and they themselves say on the basis of actual executable length, there have been many variations. For cusecs, this 597 cusecs. In fact, they also agree that the design discharge is so much. Now, if their point is that on the basis of availability of water, after adjusting for all the other taluks, because the fact of the matter is, if there is 100 cusecs of water that is given at zero kilometer chainage, and let's assume one taluk has 10 cusecs, another taluk has 10 cusecs, another taluk has 10 cusecs, and like that 10 taluks are getting water. Unless it is their proposition, which there is no meaningful material on record, to show that at the first taluk, their allocation out of, say, there's totally 1000 cusecs is what the Kaveri award anticipates. Suppose availability is only 100. Unless they're able to show that at taluk 1, it has taken 20 cusecs because of evaporation, pilferage,
that is a different thing, madam. That you can't see. You're not attacking the DPR.
No. My point is not the DPR. My point is the Kaveri award. The point is, suppose if my numbers are kind of mixed up, but let's assume there is 100% water availability under the Kaveri Taluk, that 100%, 10%, 10%, 10%, there is 10%, 10 allocation to 10 taluks. Now 100% doesn't come. It's only 70% that comes in that given year. Then unless they're able to say that a taluk 1, taluk 2, they're giving 10% and not 7%. Because if there's only 70% and only 7% to each of the taluks. So unless they're able to say no, what is happening is that despite the fact that there's only 70% water available, the first, second, third, fourth and fifth taluks are taking full 10%. And therefore 7 to 10 are not getting enough water.
Yes.
I'm going to cut off the 3% extra that has been given in those other taluks and taking it directly. That is a different proposition altogether. But that is not their claim.
And
They
that
are
is,
not saying, my lord, the fact is the canal after remodeling, what they are saying is that the canal does not have the capacity for the water to flow
Yes.
till here. Actually, they're confusing two things. They're not even saying that. They are confusing canal capacity with availability of water. So unless they're able to establish that other taluks are getting 100% of their allocation, whereas even in a 70% year, Magdi and Kunigal are not able to get any water because of the fact that 100% allocation has gone despite non-availability. That is not their proposition. Now, my lord would only see one other point, which is that my apologies, one second. They are now saying after one, if according to their numbers, after 167 they need 388 cusecs. Before D26 they want 159.442 cusecs. So totally it totals to 547.44 cusecs, including
Yes.
distributary 26. Now the canal capacity is 597 cusecs. Now, if they're saying that there is a water deficit here, then I'm just repeating my earlier proposition, which is that in a water deficit here, unless they're able to establish more water having, anyway, I'm just repeating that point. But there's just one other point that I wanted to make, which is yesterday the numbers I had given my lord, which is that at design discharge of 597 cusecs, I had said that in 45 days the flow is 3.094 TMC. But in fact, it's not that, it's 60 days. So the way it's calculated is 60 seconds into 60 minutes,
Yes.
into 24 hours, into 60 days, into 597, which is the capacity, divided by 10 lakh 10 lakhs. That is because 1 MCFT is equal to, 10 lakh CFT is equal to 1 MCFT. So it is divided by 10 lakhs. So it is totally 3094.848 MCFT, that is 3.09 TMC. So the allocation of water goes. Now, the point is, my lord, if more water is released into distributary 26 for any reason, according to their numbers, the discharge at D26 is 2.313 TMC. Obviously, the entire water is not going into distributary 26. It will flow to the rest of the canal. The fact that needs to be appreciated by the state in the submissions they are making, my lord, is that the last 40 kilometers of the canal from 195 to 228 has not been completed.
Yes.
So let's assume that even in a water sufficient or a water surplus year, they are releasing it through that portion. There is actually no place for the water to go.
Yes.
So what I'm given to understand happens in a surplus year is more water is sent to D26 to fill up Markonahalli and Mangala because of the fact that the demand only arises if the canal tail end is completed. So in the absence of that completion, unless they're able to show that XYZ taluks which are before 167 kilometer is getting more than their share of water, even in a water deficient year, they cannot make the proposition that the tail end is, Magdi and Kunigal is not receiving water.
Sriranga water filling scheme is at 193.
193, the fact is,
So 193, the civil works are all done.
my lord,
It's all,
in fact,
it's all complete.
the Sriranga water canal, whatever the civil works when they are done, it will receive its quantum of water because of the capacity of the canal.
Yes.
It will receive its quantum of
I'm
water.
only giving a flip side. Suppose if there's no water, if there's deficit water,
So unless they're able to show that
No,
somebody else has drawn more water.
if there's a less water or scarcity, then the responsibility of the government to ensure drinking water to Kunigal and Magdi is much more
My
than
lord, Not by snatching water from Gubi Taluk or from any other taluk. They can't
cat is
deny
out of the
water
bag.
there. They can't deny water there. No,
No.
my point is, if there's only 70% water, they should give 70% in Magdi and Kunigal and 70% in
That will
Gubi,
consider.
etc.
That will
But
consider.
the fact, their argument, I'm a land loser. I'm saying, why are you taking my land?
Your argument is initially started on the ground that the purpose of remodeling had already achieved.
The capacity is there.
The purpose of the express project.
My lord, if their argument is,
Now you cannot go back on water.
No. If their logic is that after remodeling, it does not have the capacity to give the allocation to Magdi and Kunigal, they are on a completely different footing altogether.
Yeah.
If their argument is that there is no availability of water, unless they're able to show excess supply elsewhere, they have no argument. They have no leg to stand on. Now, my only other point, my lord, is sorry, it was only with respect to the completion of the tail end, which is that if the tail end is not, so
Yes.
instead of, my lord, no, sorry, the last submission that I wanted to make is, right now what is happening is that for the water to reach the 193, 167 km mark or whatever, it takes 1 day. Now, with the express pipeline, it will reach in half day by reducing the quantum, etc., etc. That I will not go into for the moment. But to reduce the speed at which, the speed at which the water flows, they're spending 1,000 crores when 550 crores was already spent in order to increase the capacity at that exact cutoff. So at some level, it is beyond irrational, the project.
Yes. Yes.
There is the land acquisition matter, Manoj, where the landowners are seeking to challenge a certain portion of land, which Manoj, from 1 gunta to 5 guntas, where the pipeline is being below. All these Manoj are the reason we produce. So therefore, Manoj, your lordship will take the additional document. Just take 2 minutes. Just refer to the state's additional documents, Manoj, to show that is filed on 30th June. Manoj. I'll not
30th
June, Manoj. Just to that is water allocation dated 11th July 2019, Manoj. A serial number 6 and serial number 11, Manoj. Magdi and Kund.
Yes.
We are concerned with, Manoj. Then, Manoj, technical report, your lordships will get start. Your lordships know the sketch far better than all of us, Manoj, which is at page 41. Then, Manoj, 44 is the technical committee report, Manoj, in respect of the work for ensuring water supply to Sriranga tank filling scheme by providing gravity pipeline stating at CH 70 km 2 BC for drinking water needs to Magdi and Kunigal Taluk under Hemavati project, Manoj. Then if your lordship may kindly see, Manoj, page 46, technical committee report for ensuring water supply to Sriranga tank filling scheme by providing so gravity line stating starting from so and so for Magdi your lordships will get it at page 44. That is my technical committee report. Then at page 50, Malaj, is the remodeling and Tumkur branch canal. What was thought to be argued, all this application of mine with regard to this at page 52, note on gravity of pipeline sourcing water from 70 TBC of Hemavati canal, ensuring water to Sriranga drinking water scheme covering Kunigal and Magdi, Malas. What is important is at page 54, Malas, last table at B, Malas. Your lordship, table necessity for independent gravity pipeline taking off from kilometers 70 TBC, Malas. So the required discharge could not be realized beyond 167 kilometer of TBC due to various technical reasons. Hence, Achkat beyond so and so, and also major so and so. As per the final judgment of Kaveri award 25.31 TMC is allocated to Hemavati Canal Zone Tumkur, which covers the requirement for both TBC and NBC canal network. The canal network district-wise breakout for overall allocation of 25.31 TMC is as under TBC, NBC. Your Lordship, then B, my lords, further allocation, further breakup of various needs under TBC is as under. Therefore, my lords, your Lordship may kindly see, my lords, the area under irrigation has been reduced by virtue of which what was 17.88 has been divided into irrigation 10.65, drinking water, that is for Timku city, Tiptur, Gubbi, Koragere, and so and so, Madhugiri. Then comes my lord, serial number 3, drinking water scheme, DWS, and others, so and so, my lords. In the purview of Hemavati, what point, page 55, serial number 3, my lords. 10 years water details of TBC period, so and so reveal that the average.
Madam, we should have raised objection. If it is only water, if you're concerned only with the water, you should have raised objection when water was drawn from Tumkur, Hemavati canal to Madhugiri.
My
You
land
should have
was
raised
over-
objection when
My
water
land
was
was not
taken.
acquired, my lord, at
No,
that
no.
point.
You should have raised objection. If you're concerned with the way water is allocated, if you're concerned with the way water is allocated,
I am concerned with the fact that,
Ah.
I apologize, my lord was saying.
so Madhugiri lies within Pennar zone. Tira lies within Upper Bhadra.
My lord,
So when
drinking
water was
water-
taken from one basin to another, you never objected.
My lord, drinking water, I am not even today saying that Magdi and Kunigal should argument. And also, my lord, when it was taken to Madhuguri or elsewhere, I don't know exactly where, but my
Madhugiri is
land
my
was not under.
place. Madhugiri is my place.
I would certainly not object, my lord. I would certainly not object. No, my point, my submission is that my land was not under acquisition, my lord.
Principle and the policy of matter of fact emphasizes that the original riparian area shall get its due share of water when compared to the area that falls outside the basin. For that principle, Kunigal Taluk is deprived from the above since inception. The prime need of the hour is to address this, and upon consistent exploration by way of intensive survey, planning and designing, the solution that emerged is an independent gravity pipeline of taking off from 70 TB exclusive for meeting the needs of drinking water and irrigation needs of Kunigal and drinking water needs of Magdi Taluk. The gravity pipeline of taking from 70 km TBC is an independent network which is contemplated to get allocation share of water of Kunigal, drinking water needs plus part irrigation, and Magdi only drinking needs Taluk without, this is important, Malot, without causing adverse impact on the allocated share of other beneficiary Taluk on the upper reaches. The purpose is to regulate the requisite flow of specified time in it. That is all the purpose behind the concept of gravity pipeline. The sole intention is to compensate for the decision right of Kunigal Taluk so far since inception, thorough failing through the Kaveri Basin being original beneficiary. Ongoing modernization, all that has been considered. Therefore, Your Lordship may kindly say it is not
Briefest reply, my briefest. Only on that technical advisory report. If my lord would just see page 77.
Give it to the. Can Your Lordship permit me the sketch?
Whatever you
No,
want.
we had given it yesterday itself. Your Lordship pointed out it was not
77. Yes,
My lord
madam.
would say upon receiving 1,200 cusecs at kilometer 70, it is programmed to regulate water release, etc. And then in the second. Authorized use of water. Then my lord would see at issue 4, it is advised to install telemetry devices under SCADA. Of water, the technical advisory committee report has come up with in fact, water management is the business of the government.
Yes.
That is, they must avoid pilferage, they must install suitable monitoring mechanisms. There is in fact an on-off system already in vogue, which can be strengthened. Given that the main canal has the capacity, unless they're still able to contend. In fact, the learned Advocate General read out that portion. My Lord would please see just one last page I'll point out. My Lord would see at page 50, at 50 the state read. At page 51, my Lord would see the second but last paragraph. Is this, unless they're able to contend that because of the age of the canal, because of the fact that modernization work could not be carried out, or it is a failure, there is no canal carrying capacity to give water. No other argument is, according to me, available to them. Deeply obliged.
Monday could. Monday, Thursday. Resolved, huh? Right, resolved. Yes.
My Lord, in the national highways matter, would the court permit me to make my submissions tomorrow? I have not gotten the judgments. Tomorrow may I make?
No, whatever judgments that was handed over to you.
They were not handed over. I'll just collect them and I'll make my submissions tomorrow.
No,
if
I
my
have to
Lord
sign
permits.
the order, madam. It will go today itself.
All right, I'll
By
see what
evening,
I
you
can
can make a submission.
Seal number 4, my lord. Process need to be paid, conditional order to be passed. Pay the process. Seal number 4.
Right.
That's interim order to be executed.
Please inform the court officer.
Yes.
Yep.
ಇಲ್ಲ ಸರ್ ಸೋಮವಾರ ಫುಲ್ ಇದೆ ಬೋರ್ಡು 115 ಆಗಿದೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸಾಹೇಬರಿಗೆ 80 ಮೇಲೆ ಬರಂಗಿಲ್ಲ
Court officer?
My lords, serial number 41 in list 1. On the previous date, we had, the matter was adjourned whereby we had stated that we want to seek instructions of the party for the submission that was made by the opposite counsel. So we still haven't received any instructions from our clients. Kindly grant us a week's time, my lord.
The petition seeks time list on sounds. Yes, correct.
Grateful.
Three judgments which the opposite side has given me. One is the Allahabad High Court judgment, which is actually, the question is almost squarely arises in that matter. That has been challenged by the National Highways Authority in SLP civil number 8422 of 2024 and connected matters.
SLP number?
SLP civil number 8422 of 2024 and connected matters. This is on section 80. Now, if my lord would, I'll just submit on the other two judgments. One is from the Kerala High Court. Now, the Kerala High Court and this Honorable Court, High Court at the Dharwad bench, both pertain to section 72. Now, respectfully, section 72 is in pari materia with section 28 of the 1894 Act. Section 80 is in pari materia with section 30 of the 1894 Act. Section 34, sorry, of the 1894 Act. Now, I'm not fully well versed with this position of law. So if my lord wants to hear on this question of applicability of section 80, contentions would have to be.
Say that is subject to the outcome of SLP.
If my lord pleases, because the only thing in SLP, in the Dharwad High Court's Dharwad bench's judgment, SLP civil number 187 of 2026 was dismissed, but the question of law was left open by the Honorable Supreme Court on whether or not it applies. Now, from my limited understanding on a bare prima facie perusal of it, there's a difference between interest that's paid under section 28, which is after, like, for example, when the reference court or the arbitrator enhances the compensation. That interest, the Honorable Supreme Court has held, forms a part of the compensation. Whereas section 80 or section 34 interest, which is on the collector's award, that is not a part of the compensation per se. So if my lord would hear the question, then contentions would have to be advanced on that. But however, if the court feels it appropriate to leave it.
Please tell Mr. Sidramaya to come.
My
Maybe
lord.
I'll hear it again.
You'll hear on the question, my lord,
Yes,
because
yes.
then I would need, I mean, I don't know what Sudarshan would have to say, but we need to address the court on that. We would need some
Anyway,
time for
please tell
preparation.
Sudarshan and also bring Mr. Sidramaya.
My lord.
Yes.
The Lordship's kind, code
Yeah.
part 10, some GM police.
Total 10.
Total 10 matters for fresh serial number 1, Abhinay Y, Abhinay S, Namd.
Move to 10 matters for
copy. Yes, please.
But we had given a complaint on 13/7/2026. We are running a cricket academy there. The property was leased to us. We have spent about 68 lakhs on that. And now they are interfering. In fact, we filed a suit also, and there is an interim order in our favor. Now, not only the owners, other miscreants and all are coming and disturbing, and there are about 600 children who are getting coached there. And the last one which we gave was on 24/7/2026. That's Annexure D. In fact, similar matters, orders, even your lordships also would have passed.
No, why are they disturbed?
That they should consider our thing, if your lordships were to see.
No, what is the representation that was given?
That to take action and to give us protection. If your lordships were to turn to
Protection
Annexure
against
A, page
right.
20.
Protection against whom and against what?
There are unknown miscreants who are coming. Because though there is an injunction against the owner, my lord, but there will take. But here,
how
similar matters only. They are all.
How can we pass a blanket order without knowing what exactly is the dispute? What is this OS number?
That is the reason, my lord, if your lordship sees the order, what has been passed, if your lordship sees the operative portion passed by the learned single judgment.
Yeah.
The operative portion says, my lord, this issued response the director act on the complaints filed by the petitioner at Annexure A to A4. Let them act on the, my lord, the complaint that is given by us. They have not done anything on that. Others, my lord, we won't have come before your lordships, my lord.
Yes. Yes.
I'll take notice and get instructions, my lord.
Learned AG, is that to accept notice for response 1, 2, and 3 tomorrow?
Tomorrow.
This tomorrow. Yes, let it come tomorrow.
Can we direct it to also serve?
Let them alone at least, or your lordships could have disposed of with similar observation. Because this is,
You not even served an advance copy to him.
the order.
Whatever is there, you should have served it in the morning itself. You should have served the copy in the morning itself. You would have looked into, you would have got some instructions.
Because filed day before yesterday, it was.
Anyway,
all
it has
copy
come
was
up.
already given, I am told, my lord, at that time. But
Before
similar
filing
orders,
of-
my lord, my lord, there are
right.
4, 5 of the orders, my lord, which are similar.
Can this be disposed of on similar lines?
Similar.
Can it be taken up at 5 o'clock, my lord? I'll
Yes, 5 o'clock. Yes, next.
Please.
get some instructions.
For orders number serial number 2, HS Suhas, total number 10 matters.
This is a matter. The petition sugar factory has completed the crushing operation, that's paid more than 95% of its dues. Now by annexure A, Deputy Commissioner sought to virtually close the sugar factory by putting an embargo saying that you can't move the material and men. And then there is a agitation by some farmers. It is about now 8.33 crores is left over. But we need some more time to liquidate and to sell those things, including the ethanol. They have to produce and sell it. We have paid almost 95%.
ಏನ್ ಮಾಡೋದು ರೈತರಿಗೆ ಯಾರು
ಇಲ್ಲ
ಕೇಳ್ತಾರೆ?
ಅದು ತಪ್ಪಾಗಿದೆ ಪಾಪ ಇವ್ರ
Fact
ಹತ್ರ
is an interim
ಶುಗರ್
order-
ಇಲ್ಲ ಇವಾಗ ಮಾರಾಟಕ್ಕೆ because of the low production in the last sugar season
There's
and
an
high sugarcane price paid by the, and as per the government order they have to pay additional price also.
How much can you deposit?
Right, 8.33 crores is there. ಒಂದು
Can I make one submission?
one 6 weeks ಕೊಟ್ರೆ we'll
Interim
pay
order
it.
was already granted to them in March.
That's correct.
March, page 67, annexure end.
Page 67.
67. Is an interim order that's already granted by this court, directing them to, my lord, deposit 50%
No,
of
that
the
was
amount
paid.
within 8 weeks.
That was 37 crores was pending during that period. I have paid even that also. What is
No
left
proof
is
of
only
that payment.
8.33 crores as on today.
No, this order passed in 7145 is complied?
Yes, my lord, I have complied with it.
You'll
I have
pay-
only required to pay only
They've
8.33
not
crores
placed
as on
anything.
today.
They've not placed anything, my lord. to
No, no,
show
it
that
is
they've made
there.
that payment.
It is there.
ಎಲ್ಲಿದೆ ಬೇರೆ there ಅಂದ್ರೆ ಬೇರೆ?
I am sorry.
What is there to show that you
The
deposit?
fortnight report I have produced, my lord, along with the
No, what is
petition.
there to show?
Your lordship may kindly see, my lord. Annexure.
7145 of 26, what was challenged in that petition?
That was the, again, the
same-
notice,
same
notice,
demand.
my lord, by the deputy commissioner that I have not paid that amount. No, I have complied with that more than.
ಎಲ್ಲಿದೆ ಇದು? What is there to show that you paid 50%?
Therefore, during that time, in that petition, it was 37 crores. I have stated so. I have paid almost everything except 8.33.
Almost everything.
8.33 crores, my lord. More than 50.
Why can't you be specific? Whether you
No, I am
paid
specific only.
50% ಕಟ್ಟಿದ್ದೀರಾ?
ಕಟ್ಟಿದ್ದೀವಿ. That can be recorded, madam.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಹೇಳಿದಾರೆ ನೋಡಿ ಇವಾಗ.
Where do I get it?
Please, madam. Annexure, your lordship will get one more document I have produced along with petition. The fortnight report is there.
At least where have you said that as per that order you deposited the money? ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ petition ಅಲ್ಲಿ?
ಹೇಳಿದೆ.
ಓದಿ. Annexure N ಆದ್ಮೇಲೆ ಓದಿ.
ಅಲ್ಲ ಪಿಟಿಷನ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದೀನಿ.
Page 20.
I am reading that. Though the petitioner has made sincere efforts to discharge the whole obligation for the sugar season 25-26 was unable to generate revenue, clear the outstanding dues to the tune of so and so, so and so.
Yes.
Sincere efforts. ಎಲ್ಲಿ what is that?
ಇದನ್ನ ನೋಡಿದ್ರೆ may take your lordships to
Where have you said?
ಅಲ್ಲ 14 para 14
Para?
para 14.
14.
Yes. It is submitted that the petition has approached this honorable court in WP number so and so stating that the petition has paid substantial amount to the farmers to the tune of 130 crores. Petition was in balance of 37 crores. As on the date of filing the writ petition, that is on 27/2/26, challenging the notice dated 21/2/26. The matter was taken up by this honorable court by an order dated 4/3/26, having regard to the difficulty expressed by the petitioner, has stayed the proceedings in notice number so and so, wide annexure M, issued by the second respondent, subject to petition paying 50% of the outstanding dues within weeks. The copy of the interim order the WP number is pending consideration. Oh, the petition has made sincere efforts to discharge the whole obligations. The sugar season so and so to the tune of only as on today, my lord, 8.37 crores. Is
Unable to generate revenue and clear.
the balance of 8.3. ಇಲ್ಲ. Balance ಹೇಳಿದೀನಿ ನೋಡಿ. Outstanding dues to the tune of 8.374 crores.
What is there to show that you deposited 50% as per the order passed in WP number 7145?
But that's what I have produced in fact, we are required to submit a fortnightly. ಹೇಳಿದೀನಿ. ಒಂದೇ second. Page 82, make.
Page
82. This is the fortnightly report of 15/7/2026. Now your lordship may kindly see the column number 10, balance payable to farmers 8.33 lakhs. As on 15/7, the earlier fortnightly report where the dues were
out of 37 crores you paid.
Yes, madam.
29 lakhs, 29 crores.
Please. What remains is only 8.33 crores. I have no other option except to generate the funds by producing the ethanol from the molasses and other things, my lord. The deputy commissioner and others, they are now putting an embargo. I don't want to delay the farmers. It is my practical difficulty.
We wouldn't have issued this notice, my lord, in light of the interim order. I'll have to verify the amounts, whether they're paid or not.
You not
So
even
may
made
have
a
it tomorrow.
statement anywhere that you have paid.
Yes, madam.
No proof of payment.
Para 31 ಹೇಳಿದಾರೆ ನೋಡ್ರಿ.
ಹೇಳಿ.
Please read para 31.
Please. In pursuant to the orders of this court dated so and so, petition has discharged 28 crores out of the balance 37 crores. In terms of the interim order passed by the SAMP and complied with the orders passed by this court.
How much will you deposit now?
Immediately I have to generate. I need some time. Immediately 4 weeks time may be granted, my lord. I will deposit 3.5 crores by generating the funds. I'll pay them directly to the farmers. I need not deposit anybody.
You please deposit here. We do not know what you will do with the farmers.
Please.
AG has started to accept notice for respond number 1, 2 and 3, 1 to 4. The petitioner contends that pursuant to an order passed in WP number 7145 of 2026, pursuant to the order dated so-and-so, order dated 4/3/2026 in WP number 7145 of 2026, it has paid a sum of rupees 28 crores as against the dues of rupees
37 crores as on that day, madam.
37.29 ante andralla.
Houdu. 37
crores, and that the petitioner is bound to pay a sum of rupees 8.39 crores, and that the respondent number 3 has passed the impugned order. 3 no 1 na 2 na.
Illa 3 deputy commissioner.
3 has passed the impugned order seizing the factory of the petitioner. He submits that if reasonable time is given, the petitioner would deposit a further sum of rupees
3.5 crores.
3.5 crores within 4 weeks, and undertakes to pay the balance within
4 weeks thereafter.
4 weeks thereafter. In view of the aforesaid submission, the impugned order bracket annexure A is stayed.
Not only that, police protection may be
subject to the petitioner depositing 3.5 crores within 4 weeks from today.
And also fourth respondent may be directed to
the petitioner is restrained from alienating, encumbering or transferring or parting with possession of the sugar factory or any machineries, equipments installed therein. Full stop. The respondent number 4 is directed to provide need-based protection to the petitioner to ensure operations in the sugar factory, full stop. It is made clear that if the petitioner fails to deposit 3.5 crores within 4 weeks from today and the balance within 4 weeks thereafter, the respondent number 2 is at liberty to proceed against the petitioner in accordance with law.
Please, hand delivery may be.
Yes. Next.
Hand delivery may be. But the other writ petition may be connected with this.
Yeah. What is this maintainability,
It's a registered company in Andhra Pradesh. The sugar factory is located in Yadgiri. Earlier, there was no such objection. They can maintain
Maintainability of the writ petition is kept open to be considered at an appropriate stage. Yes.
Please. It may be clubbed along with WP number 744.
List this along with WP number
45 or
7145 of 2026.
Please. Great.
Veji. Just next. Adi Nanappa.
Serial number 3. Adi Naranappa.
Appear for the petitioner made application for including the pollution control board as a proposed respondent.
Bill is IE. Where is IE?
15,170 of 26.
15,715. Idian note IE.
15,176. Idian notice.
Idea. Right. Mr. Mahesh Kumar Chaudhary. Mahesh Chaudhary is directed to accept notice for the proposed respondent 6 in IA number 1 of 2026. Yes. Career. 24 Rajaditya Sadashivan.
12 matters, serial number 24 for further hearing.
Here for the respondent in the matter. Lord, may kindly recollect, Lord, in this matter.
Oh, this is that hotel, the hospital.
Hospital, my Lord.
What happened?
After Lord, it was agreed before this court. From February onwards, my Lord, the respondent also, I have also personally shared many drafts. Number of changes were Lord suggested by the petitioner. We have accommodated the changes and everything. Now, ultimately, my Lord, what had happened is first they said we will come and do it. Let there be a phase-wise dispersal of the money. We are ready to give the entire amount of money provided that we get the sale deed, and there are about 7-8 disputes which are closed. It is very simple. Ultimately, what happened?
Correct, but where is he?
But
Where, if he is not there, what can be done? You can't force the horse.
Not force, but we are willing to deposit in court also. We are only saying, give us a timeline to vacate. Then Lord, he does something very strange. He calls everyone and then gives a letter saying, I'm not interested in settlement.
Correct, but then argue the matter. That's it. Let it go. Then I'll release it.
No, please don't release it.
What is it? I've already forgotten what was argued, so there's no point in keeping it.
At least we can still make one last ditch effort. See if can be settled if they come.
But where is he, Rajaditya? When do you want it? There's no representation for the petitioner. Hence, list on so and so.
Interim order to be extended.
Interim order granted as extension to the next.
24.1.
Prakash MH.
Number 25, final hearing matters. Prakash MH.
I prefer respond number 1 matters.
There is no representation for the petitioner. Prakash MH. There is no representation for the petitioner. List on so and so. Manjunath Hiral.
14th August. Serial number 26, Raja.
Yes, I apologize, my lords. Humble submission. 24, a date is not fixed, my lords. Date?
Take whatever date you want. Rejoined for what, madam?
My lord,
Respondent filed objection on,
Correct, but is there a need for rejoinder? Just because they filed a statement, not necessary that you should file a rejoinder.
my lord, my senior instructed that they will file a rejoinder.
My lord, there are two writ petitions. The first one relates to BWS, BBMP. The second one is KLR. I don't know why both of them are, there's nothing in common.
The second one is BDA. First is,
BDA.
both of them are BDA ಅಂತ ಕ್ಲಾಸಿಫೈ ಆಗಿದೆಯಲ್ಲ.
ಒಂದರಲ್ಲಿ ನಮ್ದು ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ, ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಇಂದ ಡಿಸಿ ಹೋಗದೆ ಇಲ್ಲಿ ಬರ್ತಾರೆ ಡೈರೆಕ್ಟ್ ಅವ್ರ ರಿಟ್ ಪಿಟಿಷನ್, ದಟ್ ಈಸ್ 27.1 ನಲ್ಲಿ. In the other one there is something about sewage plant or something, I don't know, there's some other problem going on. This is concerned, we are only talking of 20 guntas which has been given a survey number 14/7. ಅವ್ರು ಏನ್ ಮಾಡಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಇಂದ ಡೈರೆಕ್ಟ್ ಆಗಿ ಇಲ್ಲಿ ಬರ್ತಾರೆ ವಿತೌಟ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸಿ. whole thing is
My lord, raise for 2 weeks time, my lord.
Monday ಇಲ್ಲ, take any Friday, Saturday, Friday. So, next Friday. Current counsel for the petitioner seeks time. Since the petition is filed in the year 2016, the request for adjournment is not justified. Nonetheless, list on Friday as a last chance. It is made clear no adjournment shall be granted on the next date. List on Friday.
7th. 28 and 29 are urgent. Serial number 30, H.N. Basuraju. Serial number 30.
H.N. Basuraj. H.N. Basuraj. There is no representation for the petitioner and the respondent for 1 to 3. List on forms. Girish Kumar. R. Girish Kumar.
Serial number 31,
Gautam Dev.
Girish Kumar.
Please kindly pass.
And counsel for the petition seeks time. List on forms.
Kindly pass. He's on his list.
Ashish Krupakar. It's already 3 o'clock, mister.
My lord, this matter was heard, my lord, with regard to stray sites and
My lords, kindly pass on, my lords.
Mister, pass over 3 ಗಂಟೆ ಆಯ್ತು, ಯಾವಾಗ pass over?
2 ನಿಮಿಷದಲ್ಲಿ ಬಂದ್ಬಿಡ್ತಾರೆ ಈಗ on his legs, my lords.
So what you should do is you should start arguing. If you think he will come within 2 minutes, you should start arguing.
No, I'm informed him, my lords. Just I informed him, he's on.
This list down date code he is not going to. Yes, Ashish.
Number 32, Ashish Kumar.
My writ of mandamus have sought against the first respondent, my lord. As against the R2 and 3, have not sought any relief. My lord, R1 has not yet filed their reply, my lord, to this.
What is the mandamus that you have sought for?
My lord, both the petitioner as well as R2 and 3 are neighbors to each other in a complex called Krishna Kutir Greenhouse. My lord, the
notice is served to the respondent.
Yes, they have paid the process immediately after notice, my lord.
Yes, BJ Janardana. You have any objection for consideration of this representation? Good. Petitioners have sought for writ in the nature of mandamus to direct the respondent number 1 to consider the representation dated 11/3/2019 and the subsequent representation dated 3/4/2021 and to demolish the illegal construction put up by the respondents 2 and 3. Full stop. The petitioners claim that they are the owners of villa number 30 in Krishna Kutir Greenhouse, Kannamangala, Bangalore 67. Full stop. 67, which is a gated community. They contend that they were shocked to notice that their neighbor, namely the respondent number 2 herein, started constructing a toilet in the setback area on the ground floor, which is adjacent to the petitioner's bedroom. The petitioners objected to the same, but the respondent number 2 did not pay heed and went ahead with the construction. Full stop. Petitioners allege that the respondent number 2 deviated to an extent of 300 square feet.
Deviations are not on the setbacks.
deviations that he is alleging are inside my compound. Whatever
Yes.
it's a pure easementary.
Allala, not at all, my lord. I'm sorry. They've already made an observation in the notice that they've given to them. Saying that ನೀವು setback area ಅಲ್ಲಿ toilet construct ಮಾಡಿದಿರ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ.
His allegation is that I have put up illegal construction on the top of my house.
What is this respond number 3 then?
2 and 3
are the, they are the husband and wife.
Full stop. He therefore submitted representation to the respondent number 1.
I'm for the respondent number 1.
To the respondent number 1.
We have sent a notice to them. We have sent a notice to them also.
The contents that the respondents have not
Found
taken
that.
any action on the representation and therefore submits that a direction be issued to the respondent number 1 to consider the representation. Next, for the learned counsel for the petitioners reiterated the above submissions. The learned counsel for the respondent number 2 and 3 submits that notice is already issued by the respondent number 1 and that the respondents 2 and 3 have replied to the notice. Full stop. If that be so, comma, it is appropriate that the direction is issued to the respondent number 1 to dispose of the representation in accordance with law after hearing the respondents 2 and 3. Full stop. In view of the above, this petition is allowed. The respondent number 1 is directed to consider the representations of the petitioners dated so and so and take action in accordance with law after hearing the respondents 2 and 3. This shall be completed within a period of 3 months from the date of receipt of a copy of this order.
Grateful, madam.
Serial number 33, B. Ramesh.
B. Ramesh. B.S. Karthikeyan.
Last occasion, your lordship has directed. Last occasion, your lordship has directed to
find out the humanitarian grounds ಮೇಲೆ ಏನಾದರೂ ಅವರಿಗೆ ವಾಪಸ್ ಕೊಡಕ್ಕೆ ಆಗತ್ತಾ ಅಂತ
ಏನು humanitarian grounds ಏನಕ್ಕೆ?
Millards, ಅದೇ auction
EMD amount.
They have paid the EMD amount of 4 lakh rupees, Millards. ಅದನ್ನ as per the statute, Millards, we have forfeited it. ತಾವು ಹೇಳಿದ್ರೆ ಏನಾದ್ರು ಕೊಡಕ್ಕಾಗತ್ತಾ ಅಂತ ವಿಚಾರಿಸಿದ್ವಿ, Millards. ಅದೇ it will open floodgates. We leave to my lords ಅಂತ.
My request ಏನಂದ್ರೆ ಫ್ಯೂಚರ್ ಆಕ್ಷನ್ ಗೆ ನಾನು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡೋದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೇಳ್ತಿದ್ದೀನಿ.
Can't help it, mister. ಕೆಲವೊಂದು ಕೇಸಸ್ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? If you have participated in the auction and if you
participated, ಎರಡು ಸೈಟ್ ಪರ್ಚೇಸ್ ಮಾಡಿ, ಎರಡು ಸೈಟ್ ಆಕ್ಷನ್ ಮಾಡಿ.
But one site you
one
did not
one side have successfully bid it, my lord.
ಇನ್ನೊಂದು ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ? What about the expenses they have incurred? ಅದನ್ನ ವಾಪಸ್ ಕೊಡೋದು ಯಾರು?
ಫ್ಯೂಚರ್ ಆಕ್ಷನ್ ಏನಾದ್ರು ಈ ಆಕ್ಷನ್ ಏನಾದ್ರು ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ
ಬರ್ಕೊಳ್ಳಿ.
That is what
the petitioner has sought for a writ in the nature of certiorari to quash the order bearing number so and so dated so and to issue a direction so and so issued by the issue a direction to the respondent number 1 to consider his representation dated 28/4/21 in terms of an order passed by this court in a case reported in LR 2015 Karnataka 4302. Next para. The petitioner contends that the respondent number 1 had issued an e-auction notification for disposal of grant sites, corner sites alva.
Corner sites.
Grant sites anta ide. What do you mean by grant sites?
Grant and corner sites. Grant and corner sites.
Alpa grant sites anta illide. Disposal of corner sites. As per rule 6 of the BDA bracket disposal of corner sites and commercial sites acts etc. rules 1984. Full stop. The petitioner was the successful bidder in respect of site number 763 and 799 at Saryam Vishweshwaraya layout in block number 6. Full stop. Petitioner contends that as per the terms of the auction, the petitioner had deposited a sum of ₹4 lakhs towards EMD. Full stop. He was required to deposit 25% of the total cost after deducting the EMD within 72 hours. And was bound to deposit the balance 75% within 45 days after receiving the letter of allotment. Full stop. Petitioner claims that he had deposited the auction price in respect of site number 799.
Yes, my lord.
And the said site was conveyed by the respondent number 1. As regards site number 763, he was unable to deposit 25% of the auction price and requested the respondent number 1 to grant an additional to grant further time of 20 days in order to pay 25% in respect of number 769 799 ಇದು 763 ಮಾಡಿ in respect of 799 in terms of his letter dated 8/4/21. Full stop. He contends that the said representation was not considered for reasons unknown, which prompted the petitioner to file one more representation dated 28/4/21. The petitioner claims that he was unable to arrange for the funds and deposit the amount as per the e-auction advice letter. Full stop. He contends that in similar circumstances, a coordinate bench of this court, in a judgment reported in ILR 2015 Karnataka 4302, had directed the authority to adjust the EMD for future e-auction proceedings. The petitioner claims that the respondent, without considering his request, had passed an order forfeiting a sum of rupees 4 lakhs. Full stop. The petitioner, being aggrieved by the same, is before this court. Next, the learned counsel for the petitioner contends that under Rule 6(4) of the BDA, Disposal of Corner Sites and Commercial Sites Rules 1984, the commissioner of the respondent is entitled to grant extension of time not exceeding 210 days for depositing the balance of the bid amount, subject to the condition that during such extended period, the purchaser shall pay the balance of the bid amount along with interest at 18% per annum up to 90 days and at 21% per annum up to 210 days with a penalty of rupees 100 in each case. Full stop. He therefore submits that the respondent number 1, without granting the benefit of the said rule, proceeded to unilaterally forfeit the EMD of rupees 4 lakhs deposited by the petitioner for participating in the e-auction proceedings. He contends that the petitioner had already had paid the auction price in respect of site number 263.
No, 763.
And due to COVID-19 situation, he was not in a position to gather enough money to pay 25% of the auction price in respect of site number 799. He therefore prays that the EMD of rupees 4 lakhs be directed to be adjusted in future auction as directed by this court in a judgment reported in ILR 2015 Karnataka 4302. Per contra, the learned counsel for the respondent submitted that the petitioner knew fully well the terms of auction. Full stop. The petitioner was a successful bidder in respect of site number 763 and 799. Full stop. The petitioner paid the auction price in respect of site number 763, but even after issuing an e-auction advice letter on 6/4/2021, did not pay 25% of the auction price within 72 hours as mentioned in the auction notification. He also did not pay the amount within 210 days that is relied upon by the petitioner, 210 days as stipulated under Rule 6 of the BDA bracket disposal of grant sites and commercial sites rules 1984. He therefore contends that the respondent was justified in forfeiting the EMD, and hence the petitioner cannot be granted the benefit of either reimbursement of the EMD or to adjust the EMD in future auctions. Full stop. He submits that the respondent had spent enormously for bringing the site bearing number 799 for auction, and due to the default on the part of the petitioner, the petitioner has to again take up the initiative to bring the property for auction, which involves effort and expense. Full stop. He therefore prays that no indulgence be shown to the petitioner in this writ petition. Next para. We consider submissions made by the learned counsel for the petitioner and the learned counsel for the respondents. Next para. It appears from the auction notification as well as the e-auction advice letter issued by the respondent number 1 to the petitioner dated 6/4/2021 that the petitioner was expected to deposit 25% of the auction amount, bid amount, within 72 days from the date of the e-auction advice letter. Full stop. The petitioner did not deposit 25% as directed. He also did not take any steps to deposit the 75% of the title value within 45 days. Full stop. The petitioner was put on notice that in the event of default to pay the 25% of the auction price and 75% of the title value, the EMD would be forfeited. Full stop. As rightly contained by the learned counsel for the respondent, the latter would have spent enormously towards bringing the property for sale, and therefore the respondent number 1 has lost an opportunity to sell the site bearing number 799. Full stop. If the petitioner was not interested to purchase the property, the auction would have been proceeded with taking into account the other willing purchasers. Full stop. The very fact that the petitioner has not been able to arrange for the required funds, does not entitle him to any relief at the hands of this court. Therefore, the petitioner lacks merit and is dismissed.
In the instant case, ಇದರಲ್ಲೂ 25% ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಇರುತ್ತೆ.
ಯಾವ್ದಲ್ಲಿ? I'm not ಕೊಡಿದ್. The judgment relied upon by the learned counsel for the petitioner is can be distinguished on facts. I have seen that judgment. Can be distinguished on facts. As in that case, as in that case, ಎಲ್ಲಿದೆ ಏನು ಕಾನೂನು ಏನಿದೆ?
At page last
correct, mister, but then what is it? Law says it can.
I may be permitted to participate in the next e-auction, my lord.
The judgment relied upon by the learned counsel for the petitioner,
that is what the order says,
does not lay down any law regarding the liability of the respondent to permit the petitioner to appropriate the EMD to adjust the EMD towards any future auctions. and is not in reference to the power of the respondent number 1 to forfeit the EMD for non-compliance of an essential term of the auction. Hence, there is no merit in this petition, it is dismissed. Yes, next.
Serial number 34.
Please.
Satish K. Request for a short passover.
What do you mean by short passover?
Senior ಬೇರೆ ಕೊಟ್ಟರು.
Or ಶುರು ಮಾಡ್ಲಿ ಅವರು. Please sit down and note on what all you would argue. ಏನಿದು PP Act?
Yes, Lord. Section 33 BDA Act, Lord, which is questioned by this petitioner, but which is in identical in the same layout. This court has quashed it, Lord. Matter went to Supreme Court. Supreme Court also affirmed it. Very layout, Lord. To which, Lord, my ex-vendor is a party.
I didn't get you. Please come again.
Lord, K. Periandan was the owner of the site, Lord, in the layout. Lord, the scheduled property is concerned.
ಯಾರು ಎಲೆ ವೆಂಕಟರಪ್ಪ ರೆಡ್ಡಿ ಅಂತಿದೆ.
Original owner.
ಅಲ್ಲಿಂದ
Venkat Reddy was the original owner. Then Lord, matter was acquired on 3/11/77. Then Lord, property was acquired. Property was acquired, Lord, by the Bengaluru Development Authority. Then Lord, the ex-vendor has approached this court when notice was issued under 33 of the BDA Act. Very vendor, kindly see annexure A page 31. He was no more. I purchased the property, my lord. Annexure A is the impugned order. My lord will find identical set of facts where my ex-vendor.
So you not even given me the facts. Please give me the facts first.
Yes, ma'am.
Periyan Dhawan.
Periyan Dhawan, who purchased the property
from
Lord. Periyan Dhawan purchased the property, my lord, from my lord Venkatappa Reddy.
Venkatappa Reddy.
On 13/12/1993. Periyan Dhawan gifted petition property to Geeta and Kannan. Then my lord, Geeta and Kannan gifted said property to K. Periyan Dhawan again in the year 2011. Then my lord, 12/10/2012, page 55, the Periyan Dhawan was issued with a note 33 notice. 33 notice. That was, my lord, questioned, my lord, by the Periyan Dhawan. Annexure F, page 55 is the order of this court.
55, huh?
Yes, 55. This court, my lord, quashed the 33 notice. Page 73.
Yes.
Then, my lord, by order dated 12th October 2012, Learned single judge under a F, my lord, quashed the 33 notice. Kindly see, my lord, that page 73.
Yes. What happened before the division bench?
Division bench brought the BDA filed appeal. Annexure G is the order passed by the division bench dismissing the affirming the order passed by a single judge, holding that 33 they have no power at all. Then matter went to Supreme Court, page 88. Against Periyan Dhawan judgment, my lord.
Yes.
Then Supreme Court affirmed it. Kindly see the Supreme Court. What Supreme Court says is, petitioner intend to proceed under the Karnataka Public Finance Act. In the event of their doing so, none of the observation made by the judgments in the present case will come in their way. And the observation matter.
Yes.
Again, 33 notice is issued. Annexure A, page 31 is the notice issued.
33 nalle madidara.
Kindly take page 31, my lord. My lord, subject. Provisional order under section 33(1) of so and so and so.
The provisional order really the 33 nalli torsu. Kodi BDA
33 provisional order illa. 33 they have treat and
it's a wrong provision, quoting a wrong provision. 33 ನಲ್ಲಿ ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಅಂತ. ಪ್ರಾವಿಷನಲ್ ಆರ್ಡರ್ ಮಾಡೋದಕ್ಕೆ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಇಲ್ಲ, ಪ್ರೊವಿಷನಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವರಿಲ್ಲ.
ಮತ್ತೆ?
What it says is, Lord, if any person forms an extension or layout, 33 says like this, Lord. If layout is formed, Lord, makes any street referred under section 32, puts up any building without otherwise than the conformity with the orders of the authority, under the said subsection, commissioner may, whether or not offender be prosecuted under act by notice. ಇದು ಈ ನೋಟಿಸ್ ಅನ್ನು ಹಿಂದೆ ಇಲ್ಲ, ನಿಮ್ಮ ಪವರ್ ಇಲ್ಲ ಅಂತ ಪಾಸ್ ಮಾಡಿ.
Correct, but this has to be construed as under PP Act.
PP Act, madam, subsequently, my lord, PP Act notice is also issued. It cannot be, my lord, because it is barred by limitation.
Yes.
My lord,
PP Act ಗೆ ಎಂತ limitation?
ಇದೆ. That is what Supreme Court says. I'll come to that. Next case, my lord, may take. Because PP Act ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ subsequent. ಇದು dead person.
ಎಲ್ಲಿದೆ PP Act ಅಲ್ಲಿ?
ಕೊಡ್ತಾರೆ. Next case.
ಎಲ್ಲಿದೆ?
Your lordship may take the subsequent writ petition.
There are three other writ petitions.
ಕೊಡಿ ಇದೆಲ್ಲಿ? ಯಾವ್ದು ತಗೋಬೇಕು ಸತೀಶ್? ಯಾವ್ದು ತಗೋಬೇಕು?
Your lordship may take the subsequent writ petition.
1827.
Subsequent ಅಂದ್ರೆ ಯಾವುದು?
1827.
18727 of 2021. There, my lord.
18727.
Yes. There.
But there, my lord, the annexure A, page 32 is the issue under section 4(1) of the Karnataka Public Premises Act, Eviction Act.
Yes.
This was questioned. This is questioned in this writ petition. This issue to Lord AP Sharada Mani. It's a different property, but 4(1) I know.
ಶಾರದಾ ಮನೆ ಕೊಟ್ಟಿರೋದು ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದಾರೆ? ರೇಖಾ
Chandran, he is the owner of that property subsequently. She is none other than daughter of the Sharda.
Daughter of Sharda.
Yes.
Yes.
This is a provisional notice. Subsequently, my lord,
you go and file your reply.
But subsequently, they issued final notice. Subsequent writ petition. There are other writ petition. 5(1) notice ಇದು ಆಗಿದೆ ಫೈನಲ್. ಅದನ್ನು ಕ್ವಶನ್ ಮಾಡಿದೆ. ತಾವು
ಯಾವುದರಲ್ಲಿ ನ್ಯೂಸ್?
There are other writ petitions. ಖಂಡಿಸಿದ್ದಲ್ಲ, I think last writ petition.
My lord, sir,
Last writ petition ತಗೊಳ್ಳಿ. 1818-146 ಅಲ್ಲಿ ಗುಪ್ತಾ.
18946. ಕಾಂತಿ ಗುಪ್ತಾ.
ಅದು ತಗೊಳ್ಳಿ. 1741 ಏನಪ್ಪ?
ಕಾಂತಿ ಗುಪ್ತಾಗೂ ಮತ್ತೆ ರೇಖಾ ಚಂದ್ರನ್ಗೆ ಏನ್ ಸಂಬಂಧ?
ಕಾಂತಿ ಗುಪ್ತಾ ಪರ್ಚೇಸ್ ಪ್ರಾಪರ್ಟಿ ಫ್ರಮ್ ಶಕ್ತಿವೇಲ್.
ಸರ್, ರೇಖಾ ಚಂದ್ರನ್ಗೂ ಕಾಂತಿ ಗುಪ್ತಾಗ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲ, ಕಾಂತಿ ಗುಪ್ತ ಈ ಪೆಟಿಷನ್ ಇದೆಯಲ್ಲ, ಯಾವ್ದು 18727 ಅದರಲ್ಲಿ ನೋಡ ರೇಖಾ ಚಂದ್ರನ್ ಡಾಟರ್ ಕ್ವಶನ್ ದಿ 4(1).
Yes, fair enough.
Lord, that is the prayer sought. Next petition.
34.2 is filed by Kanti Gupta.
Yes. Kanti Gupta. Different property on the same level, different property.
So she is also challenged 4(1).
4(1), yes.
What about Shakti Vadivel?
Adu, I think final.
Section 5.
Section 5.
Shakti Vadivel.
Yes. Ibru madi.
What is that?
Annexure A, page 32 is the final law 1741, my lord. Annexure A, page 32 is a 5(1), my lord, eviction final notice. This is questioned. Now, my lord, now, question before your lordship is now, whether not they can invoke, my lord, the 74, not now, annexure A order 5(1) on 19/1/2022.
1395 ಕೊಡ್ರಿ. 1395. 1395 ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು?
1395 ನಲ್ಲಿ 4(1) issue 2.
So this Shakti Vadivel is the son of Periandavan.
Periandavan. In turn, they sold it to Gupta, my lord. That is my lord, Kanti Gupta. Kanti Gupta is a party in the last 1741 only. Both the owner and the ex-vendor and as well as my lord.
For this Shakti Vadivel's petition can go.
ಅಲ್ಲ ಶಕ್ತಿ ಒಡೆಯರ್ದು ಶಕ್ತಿ ಇದೆಯಲ್ಲ ಅದು ಕೈಂಡ್ಲಿ ಟೇಕ್ ಪೇಜ್ 9 ಆಫ್ ದಿ ಲಾಸ್ಟ್ ರಿಟ್ ಪಿಟಿಷನ್ 1741 ಇಬ್ರು ಇದ್ದಾರೆ ಅಂದ್ರೆ ಶಕ್ತಿ ಒಡೆಯರ್ ಬಾಲಾಜಿ ಸೇಲ್ ಮಾಡಿದ್ರು ಬಾಲಾಜಿ ಆಲ್ಸೋ ಪಾರ್ಟಿ ಬೋತ್ ಹ್ಯಾವ್
then Shakti Vadivel ಕ್ಲೋಸ್ ಮಾಡಬಹುದಲ್ಲ ಪಿಟಿಷನ್ that can be closed
ಅದು it is issued in the name of dead person.
Fair enough, he has sold it to somebody else. So how can he, what is his locus standard to challenge?
It is his duty, my lord, since he has sold it, he may even prosecute them, my lord. That is why he joined. Because to pass over a better title, my lord, he has joined, nothing else. Nothing else.
They are here before the court, the purchases are before the court.
Yes, my lord.
So let them
both ex-vendor and purchaser.
So let them work out the remedy. 34.3 and 34.4 can go, isn't it, Satish? ಎರಡು ಕ್ಲೋಸ್ ಮಾಡಬಹುದಲ್ಲ
ಅಲ್ಲ ತಾವು 33 ನೋಟಿಸ್ ಅನ್ನ ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಮೇಡಮೇ ಕೈಂಡ್ಲಿ ಕ್ವಾಶ್ ಇಟ್ ಫಾರ್ಮಲಿ ಕ್ವಾಶ್ ಇಟ್ ಬಿಕಾಸ್ ಇನ್ ಯು ಆಫ್ ದಿ
ಕೊಡಿದೆ ಅದು ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಬಾಲಾಜಿ
ಯಾರು ಫಸ್ಟ್ ಪೆಟಿಷನ್
1223
ಶ್ರೀ ಬಾಲಾಜಿ
22
33 will not, though there is no provisional order, but 33 notice is issued.
Against a dead person. Periandavan died. Annexure K page 131.
If Malad may kindly take the first petition, 12223, Annexure A, page 31, 33 notice issued to Malad, Periandavan. He died, Malad, page 131, death certificate. In name of dead person.
Yes.
But since BDA may demolish anta original owner appears the court. I mean owner appears the court.
Yes, Mr. Who appears for the BDA here?
My lords, 34.2, my lords.
So please come to section serial number 34.
My lords, with respect
No, 34. This notice is issued under section 33(1)
yes, my lords.
of the BDA Act.
My lords, with respect to that, I don't have papers. With respect
Yeah?
34.2 only I have given the Vakala.
Papers.
34.2 ದಷ್ಟೇ ಇದೆ.
ಎಲ್ಲಿ ಮೋನೇಶ್ ಕುಮಾರ್ ಎಲ್ಲಿ? Sorry.
34.
Poonam Patil. Poonam Patil.
I'm representing Poonam Patil. Sick passover, she'll come.
Passover. ಇಷ್ಟೊತ್ತಲ್ಲ.
She'll come in.
BB Krishna. K Krishna. 34.1. ಇವ್ರಿಗ. He has appeared?
Not me, my lords.
ನೀವು ಯಾವ ಕೇಸಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತಿರಪ್ಪ?
34.2, my lords.
ಲಿಂಬಿಕಾಯ್.
Yes, my lords.
MS ವೇಣುಗೋಪಾಲ್, ಪೂನಂ ಪಾಟೀಲ್.
Lords, here with respect to 34.2, my lords, section 4 sub clause 1 has been issued. My lords, it's a premature rate which has been filed before this.
Yes. 34.2 ಹೇಳಿ ಏನು ಹೇಳ್ತೀರಿ?
But if your lordship examines, my lord, the last 1741.
Sir, 34.2 ಬಗ್ಗೆ ಹೇಳಿ sir. This is filed by Kanti Gupta.
4-1 notice, eviction notice is not issued.
You file your reply.
Lord, Kandiji, Lord, the very notice is issued on what date? 14/6/2012. I mean 22. Lord, the notice Kandiji.
4/10/2021.
21. Lord, acquisition has taken place long back.
Sir, ಅದೆಲ್ಲ ನೀವು ಹೇಳಿ sir. Reply ಕೊಡಿ sir.
ಅಲ್ಲ, Supreme Court says not in the Unauthorized Occupation Act, Limitation Act is applicable.
You please raise that also as a
Since
ground.
my lord is deciding one question in the last petition, 1741. But if your lordship, since examine the final notice 5-1, but probably my lord this will also cover.
Yes.
If my lord 5-1 is bad, my lord, this is also bad.
Please go and file your objections. Barkul.
Lord, that may not arise. That may not, because in later.
ಹೇಳಿ argument ಮಾಡಿ, that may not apply.
But according to me, my lord, the very notice issued annexure A is brought 31 in 2021. It is barred by limitation.
Please point out.
Yes. Lord, kindly see the acquisition when it has happened.
1977.
Not 77 acquisition. 21, my lord. Merely the Supreme Court gives liberty whether limitation act would be applicable. If limitation act applies properly, I have to reply. Kindly see the judgment on the very question.
Yes, please.
It's a recovery of rent under the Central Act, under the unauthorized occupation 1971. Supreme Court says limitation would apply.
Put it. Please read.
Yes. But it's a reported judgment, my lord. It is a reported judgment. Put it. But effect of statute limitation held bars the remedy without touching the right. My lord, kindly directly come to my lord, para 2, my lord, of the order. Page 2 ದಲ್ಲಿ para 2 ದಲ್ಲಿ 7 ಅನ್ನ ಕಲ್ಡ್ ಔಟ್ ಮಾಡ್ತಾರೆ. ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ರಿಕವರಿ ಬಿಯಾಂಡ್ 3 years ಮಾಡ್ತಾರ ಅಲ್ಲಿ.
ಓದಿ.
Yes. Lord, the only condition raised before so and so appearing for the appellant, para 2, Lord, High Court was wrong in holding that amount in question could not be recovered under section 7 because time for instituting a suit to recover the sum had expired. Admittedly, any suit instituted on the date when the state officer made his order in section 7(1) would have been barred by time. Mr. Hardy argued that Limitation Act only barred the remedy by way of suit, did not extinguish right under section 7 of the public premises eviction under the Succession Act, providing different special mode of recovery was therefore available to recover rent and arrears beyond 3 years. Section 7 as stood at the relevant time reads as under.
This is regarding rent.
Rent, yes, 3 years. Recovery person is concerned 12 years on limitation.
ಎಲ್ಲಿದೆ?
Under
not limitation. Don't go to limitation.
Then my lord,
no go. Sir, there is a statutory power.
Correct.
Under the BD Act itself to recover possession in accordance with law.
Yes.
That is under the PP Act.
Yes.
You file a suit for declaration of title, that's a different thing. But in a proceeding initiated by them, you cannot upset it on the ground that you have perfected your title by adverse possession.
Lord, that is what the limitation 3 years ಕೊಟ್ಟಿದ್ರು ಆ ಕೇಸಲ್ಲಿ. 3 years beyond ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ ಗೊತ್ತೇನೆ. I will read whether the limitation act would apply or not ಅಂತ ಹೇಳ್ತಾರೆ Supreme Court. Not that, Lord, it's a specific 71 Act, Central Act. Recovery beyond 3 years ಮಾಡಿದ್ರಲ್ಲಿ ಪರ್ಮಿಸಬಲ್ ಅಲ್ಲ ಹೌದು ಅಂತ ಹೇಳ್ತಾರೆ. ಓದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೇಳ್ತಾರೆ. Lord, if any person appears to fails to pay arrears of rent or installments thereof under section 1, damages or installment thereof payable under subsection within time specified in the order relating thereto, the state officer may issue certificate for the amount due to the collector, which shall proceed to recover the same as an arrears of land revenue. As would appear from the terms of section, it provides summary procedure for recovery of arrears of rent. It was argued that section 7 did not put time limit for taking steps under that section. As the limitation prescribed for a suit to recover the amount did not apply to proceeding under this section, the High Court was in error in upholding the respondent's objection in support of his contention that debt remained due.
Please raise all these contentions before the authority.
Right.
Please raise this contention.
But my lord, 76 Supreme Court on the point says it would apply. But I will read that completely. Then your lordship, Lord, I leave it to the court. What it says is this, Lord. Lord, I will read the further. In support of the contention that debt remained due to barred by limitation, which had a relies upon a number of authorities, both Indian and English, we do not consider it necessary to refer this decision because proposition is not disputed. The statute of limitation bars remedy without touching the right. Section 20 of Indian Limitation Act 1908, which was in force at a relevant time, however, provided that right to any property was extinguished on the expiry period prescribed by the Act for instituting a suit for possession of the property.
Yes.
But on the facts of this case, no question of a suit for possession of any property arises, and section 28 has no application. It is not questioned later whose suit is barred by limitation. if there's any other legal remedy permitting him to enforce his claim, would be free to avail of it. The question of every case is whether particular statute permits such course. Does Section 7 of Public Premises Eviction of Another Act 1950 create a right to release the arrears of rent without any limitation under time? Section 7, a state officer may order any person who is in arrears of rent payable in front of any premises to pay same within such time as such installments as it may specify in the order. Before, however, the order is made, a notice must issue calling upon defaulter to show cause why such order should not be made. If he raised any objection, a state officer must consider the same and the evidence produced in support of it. Thus, the state officer has to determine upon the hearing the objection amount of rent arrears which is
ಅದೇ
payable.
ನಾನು ಹೇಳ್ತಿರೋದು. Go file your objections, let the estate officer decide all these contentions. You raise all the contentions, including limitation. everything.
Supreme Court says, Lord, it's limitation act would apply. Now, kindly take for a moment, Lord.
I will not give any declaration. Petitioner has called in
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ
question.
ತಾವು ಓದ್ಬಿಡ್ತೇನೆ.
Here, take your time.
I will not take more time. I will not take more time. Thus, a state officer determine upon hearing the objection amount rent of arrears which is payable. The word payable is somewhat indefinite in import, and its meaning must be gathered from the person in arrears raises a dispute as to amount. A state officer in determining the amount payable cannot ignore the existing laws. If the recovery of any amount is barred by law limitation, it is difficult to hold that a state officer could still insist that said amount was payable. When duty is cast on the authority to determine the arrears of rent, determination must be in accordance with law. Section 7 only provides special procedure. Limitation illa alli prescribe madima. Special procedure for realization of the rent arrears and does not constitute a source or foundation of a right to claim a debt otherwise time barred. Construing the expression any money due, Section 186 of Indian Companies Act so and so becomes held in so and so case. That this means money is due and recoverable in a suit by the company are observed. It is a section which creates special procedure for obtaining a payment of monies. It is not a section which purports to create a foundation upon which the base claim for payment. It creates no new rights. We are clear word payable Section 7 in the context which occurs means legally recoverable, admittedly suit to recover arrears instituted on the day the order under which the Section 7 was made would have been barred by limitation. The amount in question was therefore irrecoverable. But my submission to your lordship is now provisional notice is issued. Lord, Section 4. Section 4. Provisional. Last is final notice, 1741. 1741. Allah. To whom it is 1742? Final notice also to issue to Biryani. 4-1 is issued to me.
The petitioner has called in question a statutory notice bearing number so and so dated 4/10/2021 issued by the respondent under section 4(1) of the Karnataka Public Premises Eviction of Unauthorized Occupants Act 1974. The petitioner claims that one Anjaneya Reddy was the owner of the property bearing server number 27/11 situated at OMBR layout. Server number 27/11 of Banaswadi village, measuring 2 acre 11 guntas. A preliminary notification dated 3/11/1977 was issued for acquiring the aforesaid property along with other survey numbers, along with land in other survey numbers for the purpose of forming OMBR layout. This was followed by a final notification dated 13/11/1980 Petitioner claims that the possession of the aforesaid land was not taken by the respondent. A notification was then issued by the state government, by the government of Karnataka, under Section 4 of the KMC Act 1976, declaring OMBR area would come within the peripheral jurisdiction of Bangalore Mahanagar Palike. Therefore, the said property was transferred to Bangalore Mahanagar Palike in the year 1995. Full stop. Petitioner claims that Anjaneya Reddy sold site number 11 formed in the above survey number to Srimati S. Kala Devi and P.D. Mohan in terms of a sale deed dated 7/12/1994, who paid betterment charges to the Corporation of the City of Bangalore in the year 2003 and obtained a plan sanctioned for constructing a building thereon. Thereafter, Srimati Kala Devi sold a portion of the aforesaid property to one S. Babu Reddy in terms of a sale deed dated 25/11/2004. He also obtained a plan for constructing a building on the aforesaid property. The said Babu Reddy sold the property purchased by him to Sri B. Raja Reddy in terms of a sale deed dated 14/5/2008. Petitioner purportedly purchased the petition property, which comprised of two-floor building, from B. Raja Reddy in terms of a sale deed dated 14/6/2012. Full stop. She contends that the respondent had issued a notice dated 24/9/2011 under Section 33 of the BD Act 1976 to the owners of some of the properties in the same layout and to recover possession. Some owners had approached this court in WP number 38306-308 challenging the notice. This court, in terms of an order dated 12/10/2012, allowed the writ petition and held that the petitioners therein were in settled possession and that the respondent cannot take possession of the land of the properties without following the due process of law as provided under Section 33A of the BD Act, or by filing an appropriate suit. This was upheld by the division bench of this court in writ appeal 793-795 of 2013. Full stop. The division bench observed that it is open for the respondent to take action in accordance with law. The respondent then filed SLP Civil 21300-302 of 2015, which was dismissed. However, on a submission made by the respondent that it intended to proceed against the unauthorized occupants under the KPP Eviction of Unauthorized Occupants Act 1974, liberty was reserved. And it was held that anything contained in the orders passed by the High Court will not affect the right of the respondent to recover possession. Full stop. The petitioner claims that she too approached this court in WP number 52539 of 2012, which was disposed of in terms of an order dated 12/10/2012. Petitioner contends that the respondent has now issued a show cause notice under Section 4(1) of the KPP Eviction of Unauthorized Occupants Act 1974. Being agreed by the same, the petition is before this court. Next, the learned senior counsel for the petitioner submitted that the acquisition of the land in question was initiated in the year 1970.
3/11/77. And final notification is 13/11/80.
Under Section 17 of the BD Act, followed by a final notification dated 13/11/1980. He therefore contends that the proceedings initiated by the respondent is in the year 2021 to recover possession under the provisions of the KPP, Eviction of Unauthorized Occupants Act is barred by the law of limitation. In support of this contention, he relied upon the judgment of the Apex Court in New Delhi Municipal Committee versus Kalu Ram and another 1976, Part 3, SEC page 407. Full stop. Anything else? Is that the only full stop? Next further. Per contra,
Then, my lord,
the
plan everything is taken, my lord, it is not illegal.
Huh?
It is not illegal construction. Plan was taken, my lord, everything is according BBMP granted plan.
we are not on that. Per contra, the learned counsel for the respondent submitted that the respondent has taken possession of the land in survey number so and so 27 of Banaswadi on 9/2/1983, and the acquisition is complete in all respects. He contends that a notification in this regard is issued under section 16(2) on 5/3/1983. Full stop. He contends that the petitioners are unauthorized occupants who are residing. Petitioner is an unauthorized occupant who is occupying land belonging to the respondent, and therefore the respondent is entitled to take out proceedings under the KPP Act 1974. He contends that this action was taken pursuant to the liberty granted to the respondent by the Honorable Supreme Court. So besides this, he contends that the right to evict the petitioner from property belonging to the respondent is a statutory right incorporated under section 33(a)(2) of the BD Act, and therefore the respondent is entitled to initiate proceedings. Full stop. He contends that if the petitioner has any defense, including the contention that the proceedings are barred by limitation, the petitioner is bound to raise that before the respondent, and the respondent would take a suitable decision in accordance with law. He therefore contends that the petitioner cannot approach this court challenging the provisional order, as it is provisional in all respects, and the right, if any, to challenge the right, if any, to approach this court would arise only after a final order under section 5 of the KPP Act 1974 is passed. Next para. The petitioner contends that she has purchased the property from one B. Raja Reddy. Raja Reddy contends that the property in question was purchased by one Mr. B. Raja Reddy in terms of a sale deed dated 14/5/2008, and that he sold it to the petitioner in the year 2012. Full stop. The sale deed executed in favor of the petitioner would show that what was conveyed to the petitioner was, what was conveyed? Buildinga with buildinga.
Yes, my lord.
Yes, Lord. Building.
What was conveyed was the property along with the building thereon. Of a building of two-storied building thereon. Full stop. The respondent claims that the possession of the property in survey number 27 of Banaswadi was taken over on 9/2/1983, and a notification of section 16(2) was issued on 5/3/1983. Full stop. If that be so, the respondent was justified in initiating proceedings under section 33(a)(2) of the BD Act by issuing the provisional notice under the show cause notice under section 4(1) of the KPP Act 1974. Full stop. The contention of the learned senior counsel for the petitioner that the proceedings are barred by the law of limitation is definitely a ground that the petitioner is entitled to raise before the respondent, and the respondent is bound to answer the said contention. However, the show cause notice issued by the respondent cannot be upset on this ground, Therefore, this court is of the opinion that the petitioner is bound to appear before the respondent and file objections and raise all contentions available in law. Full stop. Hence, the writ petition stands disposed of, upholding the notice issued by the respondent. It is open for the petitioner to file objections, and the respondent shall consider the objections objectively and pass appropriate orders. In order to enable the early consideration of the objections, the petitioners have to appear before the respondent on 2026 at 3 p.m. along with the objections to the show cause notice. The respondent shall conclude the proceedings within a period of 3 months from the date of filing the objection. Yes. Next, in your
with your lordship's kind leave, my lord. Sorry for interjecting, my lord. Lord,
wait,
please.
Yes, next. ಇನ್ನೊಂದು ಯಾವುದು? 4-1. Rekha Chandran, same order. Rekha Chandran is also same order.
Apart from 34, my lords, all are under provision of section 4.
Rekha Chandran, then Shakti Vadivel,
Rekha Chandran, Shakti Vadivel, and
Satish.
Yes, my lords.
Lord, 18727 of 2021. Lord, show cause notice is issued in the name of my Lord AP Saradmani, Lord, who is dead. But notice may have to go, my Lord. And
Now that you have a notice, you go and appear.
Notice is issued in
To
the
a
name
dead
of
person. Correct.
Therefore,
Now that you know, go and file your objections.
Not be, my Lord. My mother, she is my mother. But, your lordship may kindly take 18727.
Go and file your objections, Satish. It's your mother. It's not a stranger.
Mother.
Same order. Serum 4 bar. 34.1 same order.
Fresh
Next.
notice putre.
No, ಇದೆಲ್ಲ ಸುಮ್ಮನೆ ಡಿಲೇ ಮಾಡ್ತಿದ್ರಿ. Yes, next. What about this?
Dead person ಆಗಿದೆ.
64. Sir, dead person ಆದ್ರೆ ಏನು sir? It is your mother.
Maybe.
You phone file.
Honest in law. Honest in law.
Sir, you are claiming.
But he may be given.
It is only a notice, sir. It's not even an order. It is not even an order. It is only a notice.
Returned with the consequence of evicting me, my lord.
ನೋಡಿ, ನೋಟಿಸ್ಗೂ ಆರ್ಡರ್ಗೂ ನಿಮಗೆ ವ್ಯತ್ಯಾಸ ಗೊತ್ತಿದೆ. If it was an order, I would accept. It is only a notice. Now that you come to know, please go and file your objections. 34.1 same order. Then what about 34.3? Satish? 1395.
1395
ಕೊಡ್ರಿ ಇದು.
ಅದು ಅಷ್ಟೇ ಕೆ ಪೆರಿಯನ್ ಡೆಡ್ ಪರ್ಸನ್ ಮೇಲೆ 41
1395.
ಅದು ಸೇಮ್
ಅದು ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹಾಕೊಳ್ಳಿ. The learned senior counsel for the petitioner submitted that the notice impugned is issued to a dead person and is therefore non-est in the eye of law. ಅದೊಂದು ಹಾಕೊಂಬಿಡಿ. What about 1741?
ಅದು 5.
1741 ಅಲ್ಲೂ ಸೇಮ್.
ಹಾಗಾದ್ರೆ ಡೆಡ್ ಪರ್ಸನ್ 5. ಫೈನಲ್ ಎವಿಕ್ಷನ್ ನೋಟಿಸ್. No other proceeding. Straight away they will evict.
Yes, ಇದು section 5 ಹೇಳಿ. Whether any file objections were filed?
Not it is issued to a dead person. Question of filing
No, did you file any objections?
No, my lord, because dead person it is issued.
Then we'll set aside and we'll fix one date.
Son has filed the writ petition. Son has filed the writ
petition. But then he has not filed objections. So therefore you redo it. Idರಲ್ಲಿ 1741 ನಲ್ಲಿ the learned senior counsel submits that he further submits that the notice impugned was the provisional notice was issued to the father of the petitioner was dead, and therefore the petitioner did not have effective notice of the proceedings. He therefore contends that the impugned order passed by the respondent under section 5(1) of the KPP Act is liable to be set aside. petition next to final order. Petition is allowed. The impugned order passed by the respondent under section 5(1) of the KPP Act in respect of the property bearing municipal number 14, 4th Main, OMBR layout, Banaspadi village. PID number 88-280-15 is set aside. The petitioner shall appear before the respondent on 20th August 2025 along with the objections. Full stop. The respondent shall consider the objections in accordance with law after hearing the petitioner.
It's my apologies. Section 5, my lords, provides that notice be issued to any person who is within occupation of a premises.
It's okay, but then
Need not be the owner himself.
you have recognized him to be the owner,
Not
Periyandavan.
denying that they are not in occupation. So notice served should be sufficient, my lords. Their
He
content.
is dead by that time, he is already dead.
But it also provides that whoever is occupying it, my lords.
Correct. Periyandavan dead. By
Yes.
the time you issued a notice, he was already dead. So where is the question of he occupying it?
They are not denying that son is staying there, he is
That's
subsequently
okay.
sold.
We'll take out fresh proceedings. Yes, next. What about this first one?
12223 is 33 notice, my lord.
34,
Yeah, 1, 2, 2, 3. 1, 2, 2, 3. 1, 2, 2, 3, we will issue a fresh notice under a
33 notice. BD Act.
34, it has to be allowed.
It has to be allowed with liberty for us to issue a fresh notice under the PP Act.
34 ಅಲ್ಲಿ petition is
33 again fresh notice ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. Only
Under Karnataka.
they can invoke, my lord.
public premises.
Yes.
34 ಅಲ್ಲಿ petition is allowed. The impugned notice hearing number so and so issued by dated so and so issued by so and so is quashed. However, liberty is reserved to the petitioner to take out proceedings under the Karnataka Public Premises (Eviction of Unauthorized Occupants Act 1974) in accordance with law.
Liberty to respond.
Subject to limitation. My lord may say.
All contentions you can raise.
My lord may say all conditions up to.
ಆಯ್ತು. Yes, ಮುಗಿತಲ್ಲ? Thank you.
ಆಯ್ತು.
Thank you. Next.
Allow it.
Lords, my apologies, my lords, I wasn't there.
Yes, Mr.
ನಾವು
Kannur.
ಒಂದು question decide ಮಾಡ್ಬೋದು.
I think that the government advocate has got his
Don't ask me to decide. I'll cut both of your legs. ದಯವಿಟ್ಟು ಮಾಡಬೇಡಿ. Yes, Mr. Kannur. ಏನು ಹೇಳಿ?
Yeah, I think the government advocate has probably received the instructions.
Lord, two counter complaints are filed against each other. We'll investigate both, my lord, and
No, but
look into
let them not take law into their hands.
We'll do
Ensure that.
We'll look into that. We'll look into that. They have an interim order in their favor.
Yes.
ಆಯ್ತು. No, ensure
that's
that.
That's an ex parte interim
No,
order.
ensure that nobody takes law into their hands.
Yes.
Especially the kids. There's kids involved, my lords. That's the only urgent.
They are all the ones who are going for coaching there.
The petitioner has sought for a writ in the nature of mandamus to direct the respondent number 4 Sakala, respond number 4.
Please, my lord.
To consider his complaint dated 13/7/2026 and representation dated 24/7/26 and take suitable action in accordance with law. He has also sought for a writ in the nature of mandamus directing the respondent number 2 to 4 to provide adequate, effective and continuous police protection to the petitioner, his staff and the minor children. You need the entire police force for you.
No.
Deputed.
No. What kind of relief you're asking, Mr. Petitioner, his staff, minor children.
No, my lords, minor children train in that.
There's a limit to asking, Mister. Be conscious about what you're asking.
Please.
Provide adequate protection at the scheduled property and to ensure compliance of the order dated 24/7/2026 passed by the second additional civil judge Bengaluru Rural in OS number 747 of 2026. Full stop. Next, petitioner claims that it is running a cricket academy in survey number 13 and 14 of Thanisandra
Main Road,
Agrahara Badavane, Thanisandra Agrahara Badavane, Thirumenahalli, Tanisandra Main Road, Bangalore 64. Full stop. It contends that after entering into an agreement or with the landowners, it had invested a sum of rupees 68,50,000 for establishing the academy, which caters to hundreds of children who attend coaching daily. Full stop. Petitioner claims that the landowners were driven by a desire to take over the infrastructure, business and goodwill built by the petitioner and started interfering with the running of the academy, which compelled the petitioner to file OS number 747 of 2006-26. The 26 before the second additional civil judge, Bangalore Rural. Petitioner claims that the civil court passed an ex parte order of interim injunction restraining the defendants from interfering with the running of the academy in the aforesaid property. Immediately thereafter, the petitioner submitted written representations to the respondent number 4 on 24/7/26, enclosing therewith a copy of the order dated 24/7/26 passed in OS number 747 of 2026. Petitioner contends that even after the aforesaid representation was filed, the respondent number 4 did not take any action, but the harassment of the petitioner and the staff and the disruption of the coaching activities continued unabated. Petitioner therefore is before this court seeking for a direction to the respondents to consider the representations and register FIRs if need be and take suitable action against the owners of the land, full stop, and ensure protection to all those who attend the academy. So the learned counsel for the learned AGA for the respondent submits after securing instructions from the respondents that there are complaints and counter complaints lodged by the owners of the property, and that the respondent number 4 would look into the matter and take necessary action. He contends that the order passed by the civil court is an ex parte interim order, and therefore the respondents will be careful while considering the representation of the petitioner. Full stop. I have considered submission made by the learned senior counsel for the petitioner and the learned AGA for the respondent. Next para. When the petitioner had submitted a representation apprehending danger at the hands of a third party, the respondent number 4 is bound to act quickly and with alacrity so as to prevent any further damage or injury. Full stop. If the petitioner has requested the respondent number 4 by a representation dated so and so, the respondents are bound to swing into action and give necessary protection or investigate the allegations, investigate the complaint and take suitable remedial action. So they cannot sit over the representation of the petitioner unendingly and thereby expose the petitioner to further harassment at the hands of the perpetrators. In that way of the matter, the respondents are directed to consider the representation of the petitioner in accordance with law and take suitable action to ensure the maintenance of law and order. This shall be complied within a period of
Immediately.
this shall be complied immediately. Yes, next.
Obliged. Obliged.
All interim orders will be extended at the all interim orders of total 10 will be extended. Nobody need to wait. Yalla interim order extended. Next, career. Mr. Jagadish KJ.
35 lakhs. File miss ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Yeah?
File miss ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Press
Two
part.
days
ಮಿಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
2 days accomplish.
Press part time melody. ವಕಾಲತ್ತಾಗಿ instructions.
Learn counsel for the petitioner seeks time list on. So ಇದನ್ನ process ಕಟ್ಬೇಕಂತ ಕಟ್ಟಿ ಯಾರಿಗೋ? Saravana?
I have taken process, my lords. Morning itself.
Learn counsel for the petitioner submits that process and other requisites are deposited to issue notice to the respondent number 3.
And
Office director to check, verify and proceed to issue notice.
serial number 4 may be tagged along with this one.
ಯಾವುದು?
Serial number 4.
Saravana is
Please, my lords. Connected, man.
list WP number 2110 of 2022 along with these petitions.
In this 35.1 interim order need to be extended.
35.1 interim was extended.
35 also.
ಎಲ್ಲದರಲ್ಲಿ yes next.
Grateful.
14th August. Serial number 36 urgent, serial number 37. Bapat Sampath Vinayak Rao.
Last time ಬಂದಿಲ್ಲ ಅಲ್ಲ? ಹ? ಬಾಪಟ್ ಸಂಪತ್.
Sir, I have given NOC Wakalat on behalf of petitioner. They had appointed new counsel who's not.
What is there to show that you have given NOC?
Just gave them Wakalat.
There is no representation for the petitioner, hence the petition is dismissed for non-prosecution. Yes.
Serial number 38. Bhunendra B.B. Raju. Serial number
There is
38.
no representation for petitioner. On the last date also, there is no appearance, hence the petition. BP Raju? BP Raju is not in the country, no, you know. Idara? BP Raju?
My lord would pass it over, I'll just.
It's already 4 o'clock. Learn counsel for the petitioner is absent. List on so and so. Yes, next.
14th August. Serial number
Pramod.
39 urgent, serial number 40. Venkatesh Prahlad Kulkarni.
I appear for the petition.
Ah.
But the petitioner is a housing cooperative society.
Hmm.
My lord,
Respondent numbers.
it has sought for approval.
Seek a short accommodation.
But it's only a mandamus and my lord, there is a direction not to register the
For a
same.
mandamus, you have filed such a big petition, thick
It is
petition.
the interim application for impleading it was filed.
But for what is this? You have filed such a,
That is a impleading application.
hmm.
My petition is this, my lord, the 70% sites have been released.
Hmm.
30% are yet to be released.
Ah.
I have submitted the representation via annexure B. That has not been considered. And thereafter, my lord, direction has been issued.
Weeks time again.
And if that is the relief sought, it is very innocuous. ಏನಿದೆ ರಿಲೀಫ್ ಏನು ಜಾಸ್ತಿ ಏನು ಕೇಳಿರವಲ್ಲ, they only asked you to release the sites.
My lord, there is a one more annexure. The direction is not to
ಯಾವತ್ತು?
register the site.
When will you get ready? Tomorrow?
A week's
Tomorrow. Learn counsel for the respondent seeks time list on so and so.
My lord, one submission. I filed IA number 2 of 22 for impleading, my lords. I may be permitted to
Who are
withdraw.
you?
I may be permitted to withdraw, my lords. I'm one of the landowners.
For
IA
the
2 of
IA?
22, my lord.
IA?
2 of 22.
They are in
IA 2 of
unauthorized possession.
IA 2 of 22, the learned counsel for the applicant in IA 2 of 22 submits that that the proposed response are not desirous to pursue the application. In that view of the matter, IA 2 of 22 is rejected.
My lord, this withdrawn. rejected.
Is dismissed as withdrawn.
My lord, because your lordship's own judgment in an earlier round of proceedings, lordship's past judgment where I was allowed to retain the house. In view of
Here it
that, there is
is.
nothing to contest.
Yes, next, correct.
My lord, that relief was given in the earlier writ appeal also. Again, they have come and they are.
No, it was in a
ಆಯ್ತು ಏನ್ ಮಾಡಕತ್ತ ಅದೇ
I
ಹೇಳಿಲ್ವಾ?
have no locus, man.
Hanging on to the last straw.
Please.
Yes, next.
Serial number 43, Anil Kumar R.
R. Anil Kumar. Murugesh Charati. Ah.
This is land measuring 2 acres 30 guntas.
Ah.
In serial number 8 of Manganhalli village was acquired with VDA. In view of acquisition, my lord, I was given a site measuring 26,353 square feet at the ratio of 40%. Then as per annexure B, some complaint has been lodged by Aam Aadmi Party as per annexure K. Pursuant to that, my lord, the second respondent has issued a notice. He has jurisdiction, my lord, to issue such a notice, my lord. Therefore, my lord, and before lordship to questioning, the notice.
Where is the notice?
Annexure A at page 16, my lord. I can understand madam, BDA initiate proceedings.
ಏನಂತ ಕೊಟ್ಟೆ ಓದಿ ಏನಂತ?
ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ಮಂಗನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿನ 10 ಎಕರೆ ಜಮೀನು ಶ್ರೀ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆಗೆ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿದ್ದು, ಸದರಿ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ 2 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನಿಗೆ ನೀವು ಅಕ್ರಮವಾಗಿ ಭೂ ಪರಿಹಾರ ಪಡೆಯಲಾಗಿದೆ ಎಂದು ದೂರು ಶ್ರೀ ನಾಗಯ್ಯರವರು ಮಾನ್ಯ ಆಯುಕ್ತರಿಗೆ ಪತ್ರ ಬರೆದಿರುವುದರಿಂದ ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿನ ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಭೂ ಮಾಲೀಕರ ಹಾಗೂ ನೈಜತೆಯ ಬಗ್ಗೆ ವಿಚಾರಣೆಯನ್ನು ಕೈಗೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ನೀವು ಭೂ ಪರಿಹಾರ ಪಡೆಯಲು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಹಾಜರುಪಡಿಸುವ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ವಿಚಾರಣೆಗಾಗಿ 26/9/22ರಂದು ಬೆಳಿಗ್ಗೆ.
ಶಂಕರಪ್ಪನ್ ಪಾರ್ಟಿ ಮಾಡಿದಿರಾ?
ಶಂಕರಪ್ಪನ್ ಮಾಡಿಲ್ಲ.
ಶಂಕರಪ್ಪ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ವಾ?
ಆಮ್ ಆದ್ಮಿ ಪಾರ್ಟಿ ಅನೆಕ್ಷರ್ ಕೆ ಮೇಲೆ
Annexure?
This is the notice issued by an advocate Nagaya. My client Sudarshan, son of Shivapath, page 17. The BDA initiate, okay, my lord. Here the vigilance parties, Lakshmi Kind is the second respondent. Police Inspector Vigilance and STF Bangalore Development Authority. It is a deputation.
Yes, mister, what is your government?
Looking.
Assuming that this is compensation, developed land given in lieu of monetary compensation, how can you go into it? And who is this man who has issued this notice?
Second respondent.
How is he concerned with the property?
Annexure A.
Police Inspector Vigilant.
I have produced the sale deeds also, my lord, in my favor. Lakshmi Kind is the notification, my name is also there. Page 62, my lord, notification. Last nale, Shankarappa, son of Lingappa, that is the petitioner. Page 62, my lord, final notification of BDA. Last nale, ಮೂರನೇ ವ್ಯಕ್ತಿ Shankarappa bin Lingappa, petitioner. This is the final notification issued by the BDA.
Police Inspector BDA. No, not yet.
Yaru? Police Inspector?
BDA, Police Inspector
Police
Vigilance
Inspector
and
Vigilance and STF Bengaluru Abhiವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಕೇಂದ್ರ ಬೆಂಗಳೂರು.
Respondent number 2.
ಅವ್ರು ನೋಡ್ಬೋದಲ್ಲ?
ಅಲ್ಲ, I can understand ಮೇಲೆ if there is a reference by BDA. ಇದು ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ for extreme.
But you look at the complaint, please come to the complaint.
Annexure K ಮೇಲೆ.
ಓದಿ ಏನ್ ಹೇಳ್ತಾರೆ?
The gist of the complaint, my lord, it is at page 73, para 5. It is stated that you, addressee number 1, have issued preliminary notification to it for formation of Nadaprabhu Kempegowda layout by issuing final notification dated so and so. The final notification dated issued only in respect of 10 acres, stating total extent is survey number 8 of Manganahalli village, measuring 40 acres, 39 gutas, out of which area required for formation of Sri Nadaprabhu Kempegowda layout is required only 10 acres. The final notification issued only to the extent of 10 acres, excluding 30 acres, 39 gutas, as it was developed with township, as stated supra. It is rightly mentioned in the final notification for 10 acres as government Gomal, but there is no necessity to mention the names of Lingappa, son of late Lingappa, Munikrishnappa, son of late Lingappa, Shankarappa, son of late Lingappa, Kumar, son of late Lingappa, Shantamma, wife of late Hanumanta, H. Ramanna, son of Hanumaya, Seenappa, son of Lingamarappa, Govindappa, son of Chikka Hanumaya, Narsimaya, son of Sulappa, Gangama, wife of late Venkatappa, Yellappa, son of Sulappa, Lakshmamma, daughter of late Venkatappa, Shankarappa, son of late Nagappa, D.Y. Gauramma, wife of D.S. Jairam, Vanagangamma, wife of Shankarappa, and Manjamma, wife of Tirumalaya, who are grantees and who have already sold their lands via sites where township is in existence as on the date of issuance of the pre-notification and final notification by you addressee number 1 by changing the survey sketch number of times according to your convenience to pass collusive award, colluding with strangers land grabbers. The final notification did not contain the name of either Galappa or you addressee number 4 and 5, but you addressee number 2, 3, 4 and 5 colluded together, receiving the application from you addressee number 4 and 5 to seek title compensation for acquisition of 1 acre 10 guntas of land granted in favor of Galappa as per the order passed by you addressee number dated 1/7/1978, which had already been sold by Galappa by of sites as stated supra and passed award in the name of you addressee 4 and 5 and awarded title compensation. Allotted so and so square feet developed site in lieu of 1 acre 8 and of guntas of land in survey number 8 of Manganahali village in LAC number so and so. The said consent award passed colluding you addressee 1 to 5 to gain monetary and to cause monetary loss to Bangalore Development Authority. The award passed by you addressee number 3 in the name of addressee 4 and 5 in respect of land already sold by Galappa way back to the year 2006 in respect of government land measuring 10 acres. Sri Puttaya is also granted 1 acre of land in survey number 8, block number 22. Puttaya has executed a will in favor of Jaya Narasimhagowda on 12/4/2012. Long ago, revenue layout was formed, sold sites, purchasers have built their houses and township in existence as per the aerial sketches prepared by Bangalore Development Authority at the time of issuance of the pre-notification and final notification for the acquisition of land by Bangalore Development Authority. But K.S. Jayanarasimha Gowda has fraudulently claimed on the basis of the alleged will executed by Puttaya and received title compensation from Bangalore Development Authority. The award passed in favor of Jayanarasimha Gowda in case number so and so, to which neither Puttaya nor Jayanarasimha Gowda are not entitled for compensation from Bangalore Development Authority. And such compensation paid by passing collusive award colluded with revenue officials and Bangalore Development Authority officials and claimant you addressee number 8. Balappa is also grantee of 1 acre of land in survey number 8, block number 25. Balappa sold revenue sites long ago. Township came in existence as per the aerial sketch prepared by Bangalore Development Authority in the year 2009. As against that, Balappa, you addressee number 9 has sold 20 guntas in favor of Shankarappa, you addressee number 7, who claimed compensation and received title compensation from Bangalore Development Authority. The Revenue and Bangalore Development Authority officials have prepared the sketch from time to time according to their convenience and passed the award and issued developed sites in favor of Shankarappa, you addressee number 7. The award is passed by Bangalore Development Authority officials colluding with beneficiary Shankarappa, you addressee number 7, and caused monetary loss to the Bangalore Development Authority. Sri Renuka son of Siddegowda is also grantee of 1 acre land in survey number 8, block 26. Renuka, you addressee number 10 has formed revenue layout and sold sites and townships exist as per the aerial sketch prepared by Bangalore Development Authority while issuing the notification for acquisition. As against Shankarappa, you addressee number 7, the alleged purchaser of land from Renuka claimed title compensation from Bangalore Development Authority and received title compensation from Bangalore Development Authority, caused monetary loss to the Bangalore Development Authority as the award for Renuka's land passed in favor of Shankarappa is a collusive award passed on forged fabricated collusive documents at the behest of revenue officials, Bangalore Development Authority officials colluding with Shankarappa. Sri Chelubaya, you addressee number 11, son of Narasimhaya, is also grantee of the land in survey number 8, measuring 30 guntas in block number 21. Chelubaya, you addressee number 11, has formed revenue layout and sold revenue sites long ago and township in existence. Shankarappa, you addressee number 7, claiming to be the purchaser of 30 guntas from Chelubaya, illegally has claimed and received title compensation from Bangalore Development Authority illegally. The said award is passed by the Bangalore Development Authority officials colluding with the beneficiary Shankarappa and caused monetary loss to the Bangalore Development Authority. Venkatama, you addressee number 12 is also grantee of 1 acre land in survey number 8, block number 24. Srimati Venkatama has formed revenue layout and sold revenue sites long ago. Shankarappa, you addressee number 7, claiming to be the purchaser of 20 guntas of land from Venkatama, you addressee number 12 has claimed and received title compensation from Bangalore Development Authority. The said award is passed by Bangalore Development Authority officials colluding with the beneficiary Shankarappa and others caused monetary loss to the Bangalore Development Authority. Under these circumstances, the following questions to arise. From whom the possession of the aforesaid land to which land award is passed by you address number 3 in favor of you address number 4 to 12 is taken, whether vacant possession in government land measuring 10 acres is taken by passing the award in favor of you address number 412. Whether possession is taken from the site purchased from you addressee 4 to 12 who have built their houses by demolishing their houses in the middle of the township. Whether title award passed in name of you addressee 4 to 12 is dispersed to the purchasers of the sites from you addressee 4 to 12. Whether the award is passed without taking possession from addressee 4 to 12 and award of title compensation to make monetary benefit by illegal means colluding you all. When award is passed by you, addressee number 3 giving title compensation to you addressee 4 to 12, taking vacant possession of the land which belong to the vacant land of the government Gomal measuring 10 acres was shown in the notification, which is the subject matter of final notification. How do you all substantiate how and why passing of the collusive award in the name of you addressee 4 to 12 we have no right, title and interest in lands granted in favor of you addressee 4 to 12 in serial number 8 of Manganhalli village, which you already sold by websites. You addressee number 2 has passed the award in the name of addressee number 4 to 12, may be at the instance of land brokers wandering in the Bangalore Development Authority compounded who will have to be roped in this scandal during the course of investigation of the case by the police department. This is the person who
You
has
have come into, you have acquired this 2 acre 30 guntas after the notification.
No, before
2009.
No, Lakshmi Kandis is the sale deeds.
Oh, sir, 2005 or 2009.
Yes, ma'am.
When was the notification?
2008 notification.
Notification ಆದ್ಮೇಲೆ ತಕೊಂಡಿದ್ದೀರಾ? You purchased the property after the notification.
The notification will at page
Lecture D 32.
10 2000. 2010 final notification.
Yeah, final notification 2010.
10.
Preliminary notification is 2008. Nadaprabhu Kempegowda layout ಯಾವಾಗ madam?
Please, 2008 notification ಆಗಿದೆ.
ಇದರಲ್ಲಿ final notification it is not forthcoming.
2010.
Final notification 2010 man.
The preliminary
page 60.
Preliminary notification ಯಾವಾಗ?
2008.
ಹಾಕಿಲ್ಲ ಅದು. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ just verify.
Sanction 2010 sir. 16 to 2010, so it should be before that.
ಇದು ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರೋದು 2010 ನಲ್ಲಿ.
Section 18 scheme sanction ಆಗಿ 2010 ಫೆಬ್ರವರಿ ನಲ್ಲಿ.
ಹೌದು. 9 ನಲ್ಲಿ ನಮ್ಮ ಸೇಲ್ ಡೀಡ್.
Final notification is 18 February 2010.
Final notification ಗೊತ್ತಾಯ್ತು madam, preliminary notification ಯಾವಾಗ?
It's written in page number 61 on the top. The preliminary notification for the layout called Nadaprabhu Kempegowda layout has been published in the Karnataka
22/5/2008.
So ಎರಡು ಸೇಲ್ ಡೀಡ್ before 2008 after 2008 ಎರಡು ಸೇಲ್ ಡೀಡ್.
After 2008 before final notification.
1.25 ಎಕರೆ ಆದ್ಮೇಲೆ 1 ಎಕರೆ ಮುಂಚೆ. And who are these people? Renuka, Cheluvayya, Chikkarangappa, Venkatamma, ಇವರೆಲ್ಲ ಯಾರು?
ಅಂದ್ರೆ there is a grant in favor of various persons.
ಎಲ್ಲಿದೆ?
I have
Oh, where is this grant? ಎಲ್ಲಿದೆ ಇವ್ರ ಹೆಸರಿಗೆ? ರೇಣುಕಾ ಹೆಸರಿಗೆ ಎಲ್ಲಿದೆ? ಸಿದ್ದೇಗೌಡ ಹೆಸರಿಗೆ ಎಲ್ಲಿದೆ? ಚೆಲುವಯ್ಯ, ಚಿಕ್ಕರಂಗಪ್ಪ, ವೆಂಕಟಮ್ಮ, ಯಲ್ಲೇಗೌಡ ಇವರಿಗೆಲ್ಲ ಗ್ರಾಂಟ್ ಎಲ್ಲಿದೆ? They have not produced all the documents.
I have not produced those documents.
ಮತ್ತೆ ಹೇಳ್ಬೇಕಲ್ವ, at least to justify it. See, he refers to some official memorandum dated 1/7/1975.
ಗ್ರಾಂಟ್ ಆಗಿರೋದು.
ಗ್ರಾಂಟ್ ಆಗಿರೋ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾನಲ್ಲಿ.
ಹೌದು.
ಅದು ಎಲ್ಲಿದೆ? ಅದ್ರಲ್ಲಿ ನಿಮ್ಮವ್ರು ಬರ್ತಾರಾ? ಸೇಲ್ ಡೀಡಲ್ಲೂ ಇಲ್ಲ, ಹೆಂಗ್ ಬಂತು ಅವ್ರಿಗೆ ಅಂತ.
ಅದಿದೆ
1978 ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ.
ಆದಾಗಿ ಜಮೀನು ಅಂದ್ರೆ ಇದೇ ಬೆಂಗಳೂರು ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ.
ತೋರ್ಸಿ ಅದೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. The learned counsel for the petition is directed to place on record the the orders of grant in favor of his vendor. This list on date, yes, next.
2 weeks.
1144.
Sundaresh HC. HT Basuraj.
I verified the document, my lord. Annexure F, I have verified the documents in the file, my lord.
Last occasion, there is a-
On the last occasion, my lord, the lordship have directed me to verify the annexure F in the original file, my lord. Accordingly, I have verified the document, my lord. It is in the file, my lord.
You know,
But annexure
what
F.
is in the, I don't remember the facts. I don't know, suddenly you start from middle. First in the year, case.
That the site was allotted in favor of the petitioner's mother under SC category, 2030 site. At the time of allotment letter, issuing the allotment letter, she was not in residence. She shifted her residence. Then whether the allotment letter was not communicated to her. Then when the paper publication was issued by the BDA to collect the allotment letter. Then whether the petitioner made a representation to collect the allotment letter. Thereafter, when the intimation has been issued by the BDA, directed to furnish necessary document. Then madam, I have furnished all necessary document as per annexure F. Then thereafter, no steps has been taken for issuing of allotment letter. That's why madam, your lordship has last occasion directed whether the F was furnished to the.
If it is in the file, my lord, but it is not her signature.
It is in the file. ಇದಾದ್ಮೇಲೆ ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಅದಾದ್ಮೇಲೆ ಮೈ ಹ್ಯಾಂಡ್ ಓವರ್
ಕೊಡಿ. ಅಲ್ಲ ನೀವೇ ಹೇಳಿ ಸರ್, ಏನ್
ಅಲ್ಲಿ ನಾನು ಇಟ್ಕೊಂಡಿದ್ದೀನಿ
ಕೊಡಿ.
ನೋಟ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೈಂಡ್ಲಿ ಪೇಜ್ 2 ಪೇಜ್ 2 ನೋಟ್ ಶೀಟ್ ಹ್ಯಾಂಡ್ ರಿಟನ್ಸ್ ನಿವೇಶನ ಸಂಖ್ಯೆ 675 ಬನಶಂಕರ 5ನೇ ಅಂತ ಒಟ್ರಪಾಳ್ಯ ಪೆದ್ದಕ್ಕ ಸದರಿ
ಹಂಚಿಕೆಯನ್ನು ಡಾಕ್ಟರ್ ಅಂಬೇಡ್ಕರ್ ಜನ್ಮ
ಸದರಿ ಹಂಚಿಕೆಯನ್ನು ಡಾಕ್ಟರ್ ಅಂಬೇಡ್ಕರ್ ಜನ್ಮ ಶತಾಬ್ದಿ ಅಂಗವಾಗಿ
ತರಾವು ಸಂಖ್ಯೆ
101 ದಿನಾಂಕ 3/7/1999 ಹಂಚಿಕೆ ಮಾಡಿ 99ರಂದು ಹಂಚಿಕೆ ಮಾಡಿ ಹಂಚಿಕೆದಾರರಿಗೆ ಹಂಚಿಕೆ ಪತ್ರ ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಆದರೆ ವ್ಯಕ್ತಿ ವಿಳಾಸದಲ್ಲಿ ಲಭ್ಯವಿಲ್ಲದಿರುವುದಿಲ್ಲವೆಂದು ಎಂಬ ಕಾರಣ ನೀಡಿ ಅಂಚೆ ಇಲಾಖೆಯವರು ಹಂಚಿಕೆ
ಪತ್ರವುಳ್ಳ
ಅಂಚೆ ಲಕೋಟೆಯನ್ನು ಸದರಿ ವಿಳಾಸಕ್ಕೆ ಹಿಂತಿರುಗಿಸಿರುತ್ತಾರೆ. ಈ ಸಂಬಂಧವಾಗಿ ದಿನಾಂಕ 2/11/2001 ದಿ ಟೈಮ್ಸ್ ಆಫ್ ಇಂಡಿಯಾ ಪತ್ರಿಕೆಯಲ್ಲಿ ಪುಟ ಸಂಖ್ಯೆ 20ರಂತೆ ಪ್ರಕಟಣೆ ನೀಡಲಾಗಿರುತ್ತದೆ. ನಂತರ ಹಂಚಿಕೆದಾರರು ವಿಳಾಸ ಬದಲಾವಣೆಯಾಗಿದ್ದರಿಂದ ನಮಗೆ ಹಂಚಿಕೆ ಪತ್ರ ತಲುಪಿರುವುದಿಲ್ಲ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯ ಮೂಲಕ ನಮಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯ ಮೂಲಕ ನಮಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ತಿಳಿದಿರುತ್ತದೆ. ಆದುದರಿಂದ ನಮಗೆ ಹಂಚಿಕೆ ಪತ್ರ ನೀಡಬೇಕೆಂದು ಪುಟ 10ರಂತೆ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಹಂಚಿಕೆದಾರರ ಮನವಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸದರಿ ವಿಭಾಗದಿಂದ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸುವಂತೆ ದಿನಾಂಕ 8/12/2000 ಪುಟ ಸಂಖ್ಯೆ 11ರಂತೆ ಇಂಬರಹ ನೀಡಲಾಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಈ ಸಂಬಂಧವಾಗಿ ಹಂಚಿಕೆದಾರರು ದಿನಾಂಕ 11/4/2000 ಕೆಲವು ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಿ ಪುಟ ಸಂಖ್ಯೆ 17ರಂತೆ ಸಲ್ಲಿಸಲಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದರೆ ಹಂಚಿಕೆದಾರರು ಈ ತನಕ ಖುದ್ದಾಗಿ ಕಚೇರಿಗೆ ಹಾಜರಾಗಿರುವುದು ಕಂಡು ಬರುತ್ತಿಲ್ಲ. ಮುಂದುವರೆಸು. ಆದುದರಿಂದ ಈಗ ತಾವು ಒಪ್ಪಿದಲ್ಲಿ ಹಂಚಿಕೆ ಪತ್ರ ನೀಡಲು ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಂಚಿಕೆದಾರರಿಗೆ ಕಂದಾಯ ಅಧಿಕಾರಿ ದಕ್ಷಿಣ ವಿಭಾಗದವರಿಂದ ಮಾಜರ್ ವರದಿ ಪಡೆಯಲು ತಮ್ಮ ಆದೇಶ ಕೋರಲಾಗಿದೆ ಅಂತ ಬರೀತಾರೆ.
This happens in 2005.
2000
ಅಲ್ಲ, ಅವ್ರು ಕೊಟ್ಟಿರೋದು 2001. ನೀವು 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಎದ್ದೇಳ್ತೀರ ನೀವು.
ಅಲ್ಲ, ನಾವು ಅದು ಇಲ್ಲ ನಾವು ಅದು 2000ದಲ್ಲಿ ಆಗಿರುತ್ತೆ.
ಕರೆಕ್ಟ್ ರೀ. ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ತಂದು ಕೊಟ್ಟರು 2001 ಅಲ್ಲಿ.
ಹೌದು ಇದು
ನೀವು 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಈ ತರ
ಫೈನಲಿ
ನೋಟಿಂಗ್ ಮಾಡ್ತೀವಿ.
ನೋಟಿಂಗ್ ಅದಾದ್ಮೇಲೆ ಅವ್ರು ಪೆಟಿಷನ್ ಮಾಡ್ತಾರೆ 2016 ತನಕ ಸುಮ್ಮನೆ ಇರ್ತಾರೆ ಸರ್. 2016
ಯಾವಾಗ ಅಲಾಟ್ ಮಾಡ್ತೀರಾ?
ಇದರಲ್ಲಿ
When will you allot?
please I have to file a detailed statement of objection.
File whatever you want, but the records show
Please.
that it is not rejected.
It is not rejected, correct?
If it is not rejected,
File my statement of objections.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
1 week.
Non-counsel for the respondent seeks time to file statement of objections. List on so and so. Ravi Shankar, VB Ravi Shankar.
10 days time.
Hold ಒಂದು ವಾರ ತಗೊಳ್ಳಿ, ಫೈಲ್ ಬಂದಿದೆಯಲ್ಲ ಇನ್ನೇನು.
Please.
Serial number 45.
ಆರ್ ವಿನಯ್ ಕುಮಾರ್, ವಿಷ್ಣುಮೂರ್ತಿ, VB ರವಿಶಂಕರ್ ಬರ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಒಕ್ಕಲ್ತನ ಹಾಕಿದೀನಿ.
ಯಾರಿಗೆ?
NOC 7849 ನಲ್ಲಿ ಹಾಕಿದೀನಿ.
ಅಲ್ಲ 7849 ಅಲ್ಲಿ
ಅದರಲ್ಲಿ ಹಾಕಿದೀನಿ. ಎರಡರಲ್ಲಿ ಹಾಕಿದೀನಿ.
ಹೇಳಿ.
ಪುಟ್ ಅಪ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ.
ಹೇಳಿ ವಿಷ್ಣುಮೂರ್ತಿ ಹೇಳಿ.
Please your lordship that last time I said is your lordship that in page number 19 last time 203 204 ಗೆ clarification ಕೇಳಿರ್ತಾವು. Your lordship that
first petition ಏನು 7849
62 your lordship in page number 19 ಅಲ್ಲಿ first order ಆಗ್ತದೆ petition.
Page number
19 your lordship annex C. Pertaining to site number 62 that the respondents were hereby directed not to demolish the structure standing on the land.
Last time ಏನೋ ಒಂದು ಹೇಳಿದ್ರಲ್ಲ.
203 ಅದು annexure J ಬಗ್ಗೆ ಹೇಳಿದೆ. It is only for reference ಕೊಟ್ಟಿರೋದು ಅದು ಇದರಲ್ಲಿ. ಅದು ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟದಲ್ಲ, 62 ಗೆ ಸಂಬಂಧಪಟ್ಟದಲ್ಲ ಅದು ಆಕ್ಚುಲಿ. ಇನ್ ಪೇಜ್ ನಂಬರ್ 40 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಸರ್. ಅದು 203 204 ಅದು ಬೇರೆಯವರಿಗೆ ಅಲರ್ಟ್ ಆಗೋಗಿದೆ. ಅದು ಇಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಕಷ್ಟ. ಅದು
ಇದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಒಂದು ಆಯ್ತಲ್ಲ, ಏನೋ ಒಂದು
ಅದೇ ಸ್ವಾಮಿ. ಇನ್ ಪೇಜ್ ನಂಬರ್ 40
he was acceptable for 39D my lords. Consideration of BDA in under 39D my lordships were dictating the order my lords. At page number 40 my lordships in annexure J. Annexure J. At page number 40 my lords. My lordships were to see it is with reference to site bearing number 203. So ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗಿಲ್ಲ.
ಇದಕ್ಕೆಲ್ಲ
ಸೈಟ್ ನಂಬರ್ 203
and 204.
So ಅದು ಓಲ್ಡ್ ನಂಬರ್ ಅಂತ ಆಯ್ತು, ಆಮೇಲೆ ಅಲ್ಲ ಅಂತ ಆಯ್ತು. So this particular annexure J would not inure to his benefit my lords. As regards the other citations that he is referring to my lords would my lords inure to his benefit.
So was there any survey conducted?
There was survey ಇರಬಹುದು my lords. ಮಜರ್ ಆಗಿರುತ್ತೆ my lords, ಆಗಿರುತ್ತೆ.
ಮತ್ತೆ ಅದೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ವಾ?
ಆಯ್ತು, ಮಾಡ್ತೀನಿ.
203 204
but now you are demolished the building.
I'll take instructions my lords. ಅದ್ರ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇಲ್ಲ, ಬಟ್ ಅಲ್ಲಿ ಪ್ಲೇನ್ ಲ್ಯಾಂಡ್ ಮುಂಚೆಯಿಂದನೇ ಇದೆ ಅನ್ನೋದು ನಮಗೆ
ಫೋಟೋಸ್ ಹಾಕಿದಲ್ಲ demolition.
They are all old photos.
I don't know. You want to produce some material? What is the master done? What is the inspection?
ಸರಿ,
ಯಾವತ್ತು ಹೇಳ್ತೀರಾ?
8th my lords, if I may request.
One counsel for the respondent seeks time. List on
10th please.
Kiran BS.
Office directed to put my name your lordship in 7849.
Serial number 45 ಅಲ್ಲಿ office directed to show the name of Mr. Vishnumurthy as a counsel for the petitioner after deleting the name of Mr. VB Ravi Shankar and R Vinay Kumar.
46 please.
Kiran BS.
In this case, my lord, but I'm seeking to the direction to the issuance of a sale deed. The site was allotted in my favor in 5/9/1969 by the lease cum sale agreement. Thereafter, a conditional sale deed was issued in the name of my father in 1973. All the condition precedents have been satisfied.
Who appears for the
representations remain.
Basuraj HT ಈಗಿದ್ರಲ್ಲ.
Serial number 46 Basavaraj HT.
I appear for respondent 2 my lord. ನನ್ನ ಮೇಲೆ ಏನು ರಿಲೀಫ್ ಕೇಳಲಿಲ್ಲ ಸ್ವಾಮಿ, ನನ್ನ ಮೇಲೆ ರಿಲೀಫ್ ಕೇಳಲಿಲ್ಲ.
There is no representation for the respondent number 1. List tomorrow.
Serial number 47 Timaya KH.
KH Timaya.
And in fact, I have furnished the details at annexure 37. Page annexure H, page 37.
Annexure?
Annexure H, page 37.
37, huh?
Page 37. Details of the applicant
Wherein I have also declared this site which is held by my,
ಮೈಕ್ ಉಪಯೋಗಿಸಿ ಜೋರಾಗಿ ಮಾತಾಡಿ. ಹಾ.
Lord, in fact, I have also declared that there is a site not held by my wife. And in fact, not considering this, not declaration given by me.
What are the facts?
My lord, this is a matter, my lord, where, this is a matter, my lords, where the petitioner's wife had made the first attempt. The petitioner had mentioned that first attempt in his application, because of which, my lord, we had cancelled the allotments made. And my lords wanted to refund the money which he has paid. Wherein, my lord, then I requested that I be given some time to see the original file, my lord. I could not locate the my lord's original file because it's been sent to Kaveri Bhavan for some reason. My request, my lord, to have it either on Tuesday or Wednesday, my lord.
Yes, you have any other site?
Not in fact, except this site, not the petitioner, he has not any.
Petitioner or petitioner's wife?
Not.
Either petitioner or petitioner's
In fact,
wife,
your Lakshmi
do they have any site?
Not say, he has a site, not it is standing in the name of wife. Not not allotment rules 10 subclass 3 is concerned. Not allotment rules subclass 3 is concerned. Not the site, not allotted by the BDA or by the cooperative society. In that event, my lord, I am not entitled to make an application.
No, you cannot have a site even if it's a private purchase.
In fact, it is settled. In fact, the judgment has been delivered this honorable court. Lord, I would like to rely on the judgment of this court.
BDA ಇಂದನೇ ಅಲಾಟ್ ಆಗಬೇಕು ಅಂತ ಏನಿಲ್ಲ.
BDA ಅದೇ that was in fact the judgment of this Lord.
ಕೊಡಿ.
Not 2012.
Yes, please read.
BL head note KML.
Head note ಹೋಗ್ಬಿಡಿ, facts ಹೋಗಿ.
Not fact, my lord, you would get it. Factual. The Bangalore Development Authority allotment rules 10 subclass 3 1310 cancellation of allotment site forfeiture of site value deposited. Validity person is eligible to apply for the allotment of site is already own site or house allotted to him by statutory authorities like BDA, trust board, housing board or housing cooperative societies mentioned in the rules 10.3 of the rules. The ownership of site house acquired by the private purchaser or under the gift exchange or any other manner recognized by the law, such as inheritance, succession, bequest, settlement, held word not render person ineligible to apply for allotment of site. Order of authority for cancellation of the allotment and forfeiture of the site and value deposited on the ground of that application at suppressed material fact of his ownership or of the site gifted and the hence eligible to make the application held is arbitrary and without authority of law, and law hence it is to be set aside. Not LD, if an applicant comes into ownership of a site or has been allotted a site in any apart from the what has been expressly stated in sub-rule 3 of 1210, it would not be a bar for make an application. Neither it would be make such an applicant eligible for seeking for allotment of site from the BDA. The object of this sub-rule is to ensure that a person is not a beneficiary of allotment from agencies which are stated herein twice. Therefore, any allotment made by any of the authority statutory bodies referred to in sub-rule 3 of any house building cooperative society would entitle such person to once again seek an allotment of site from BDA. The object is to ensure that no person who has already been in ownership of site or has been allotted to a site is not again enriched by allotment of site from the BDA. The object of said rules is to ensure that when large is distributed by a state through a statutory authorities or by the house building cooperative society, no person would receive a double site benefit. Therefore, the said rules is only in the context of the distribution
The
allotment.
purpose of the BDA Act is to provide sites for the
In fact,
siteless.
BDA Act also say, not sub-rule 10 subclass, not allotment rules 10 subclass 3, not kindly turn.
Now, first of all, please tell us, do you have a site or not?
Not I have a site.
Other than this?
Other than, it's a revenue site.
Other than this, you have a house, you have a site.
Other than this means allotted site.
ಯಾವ್ದಾರಾಗ್ಲಿ.
ಅಲ್ಲ, ಒಂದು ಸೈಟ್ ಇದೆ. That I have declared in the further details. In fact, I have also stated.
Therefore, you stand in the queue. You stand in the queue. Your wife let her stand in the queue. You can't piggy ride on the application filed by your wife.
Kindly appreciate. I have filed an application. Not even if I furnish long details also. Not the threshold itself, they should rejected my application.
Yes.
Not what they did was, not they they gave the allotment letter.
Mistake need not be perpetuated, Timaya. ಈಗ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ. ನಿಮ್ಮ ಹೆಂಡತಿ ಮಾಡಿರೋ ಅಪ್ಲಿಕೇಶನ್ ನ ಕೋಟ್ ಮಾಡಿ ನಿಮ್ದು ಸೆಕೆಂಡ್ ಅಟೆಂಪ್ಟ್ ಅಂದ್ರಿ. ಸೆಕೆಂಡ್ ಅಟೆಂಪ್ಟ್ ಅಂದ್ಕೊಂಡು ಕೊಟ್ಬಿಟ್ರು ನಿಮ್ಗೆ. ಇವಾಗ ಅದೇ ಸರಿ ಅಂತ ನೀವು ವಾದ ಮಾಡಕ್ಕಾಗುತ್ತಾ?
ನಾನು ಅದು ಸರಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. If I am wrong, at the first initial stage itself, they
Who knows?
ದುಡ್ಡೆಲ್ಲ ಕಟ್ಟಿಸ್ಕೊಂಡ್ರು. Not in fact.
You are dealing with a government organization.
Not in fact, you will also kindly appreciate. No, I am not dissented to make an application, not seeking allotment of the sites. Not provided that if there is no such allotment made in favor of the petitioner or his wife by the authorities, BDL or not the cooperative societies. Not in fact, I have purchased my wife has purchased not revenue site. Not she made an application at the first instance. When she made an application, she was not having this site. Subsequently, she has purchased it. Now, therefore, she did not opt to file an application for allotment site. Subsequently, my husband has filed the application. Not that.
Now that you know the law.
Not I know, not in fact.
So therefore, you ask your client to file one more application.
That is it.
ಶಿವರಾಮ್ ಕಾರಂತ ಇನ್ವೈಟ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ now, so far as forfeiture is concerned, not this court has taken a view.
Forfeiture will ask them to refund.
That is my submission is, you will also kindly appreciate. Not I would also read one more the judgment of the division bench, where in fact the allotment is in the year 2018. I have paid the entire amount within the statutory period. Not till up to 21 I have completed the entire amount. Now there is a shortfall of rupees 22 rupees. Now they wrote a letter to me to make the deficit. I have deposited the 22 rupees. Not even at that point of time, they did not notify that your application is for the first time, therefore you are dissented for the allotment of site.
Yes.
Not
a mistake is a mistake.
I should I would only make my submission. I will also kindly appreciate now. Now belatedly, not that too after when they asked me to not present before the sub-registrar for execution of the lease consulting, and I was present before the sub-registrar office. They did not intimate for the reason why they refused to execute the lease consulting. Now subsequently, after 3 years, they write a letter saying that since your application is the first time, you are not entitled for the allotment. Now there is a delay and latches on the. In fact, it's a delay is there on their part. Not in fact, this court has taken a view. Not the division bench of this court, in respect of the very
told.
I had note a Bangalore Board of Authority allotment site rule 1984-10-3, subclass 39, allotment of site. Obtained by the ineligible applicant by suppression of act. Order of authority for cancellation, delay in passing order effect. Finding of authority that husband and wife separately applied for allotment of site and got separate site allotted to them in breach of statutory condition, that in respect of family, only one application can be made for allotment of site. Though no period of limitation is prescribed for the initiating action for cancellation of allotment obtained illegally. Action initiated after lapse of 8 years from the date of allotment after construction of house by allottee which person with permission. The authority cannot be sustained in law. Now, Lord, I would, in so far as delay and latches is concerned, Lord, your lordship would get it.
Acts ಮೇಲೆಲ್ಲ ವ್ಯತ್ಯಾಸ ಇದೆ ಇದರೆಲ್ಲ ಇಬ್ರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ಹೆಂಡತಿಗೆ ಗ್ರಾಂಟ್ ಆಯ್ತು ಮನೆ ಕಟ್ಬಿಟ್ಲು then wife allotment cancel ಆಯ್ತು she came and said I am not in good terms with my husband ಅವ್ರು ಹಾಕಿದ್ರು ನಾನು ಹಾಕಿದ್ರು ಗೊತ್ತಿರ್ಲಿಲ್ಲ on that ground the court has said there is no
in fact you will also kindly appreciate not before they could allot my application allot the site in favor of me. Now obviously they could have scrutinized my application. Now they were notified that look here, your application is for the first time, therefore you have misquoted your wife.
Was there not a duty cast on you? ನಿಮ್ಮ ಮೇಲೆ ಜವಾಬ್ದಾರಿ ಇರ್ಲಿಲ್ವಾ?
ನಾನು ಅದಾದ್ಮೇಲೆ ನಾನು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಇದು ನನ್ನ ಹೆಂಡತಿ ಅಪ್ಲಿಕೇಶನ್ ಫಸ್ಟ್ ಅಟೆಂಪ್ಟ್, ಇದು ನನ್ನ ಸೆಕೆಂಡ್ ಅಟೆಂಪ್ಟ್ ಅಂತ ಹೇಳಿದೀರಾ?
ಪ್ರಾವಿಷನ್ ಇಲ್ಲ ಆ ರೀತಿ ಬರೀಲಿಕ್ಕೆ.
ಇಲ್ಲ, ನೀವು ಕಾರ್ಡ್ ಅಲ್ಲಿ ಬರೀಬೇಕಾಗಿತ್ತು.
ಕಾಲಮ್ ಫಿಲ್ ಅಪ್ ಮಾಡೋದು. There is no such provision provided in that application. Our mistake, I should not be made scapegoat. Not I have borrowed the money, I have deposited the entire amount in good faith that I will get this.
Ask them to refund it. Refund along with interest. ಅಷ್ಟೇ ಆಗೋದು. ತಪ್ಪನ್ನ we should not give a.
It's a deliberate mistake, Lord. I would make.
Correct to see if you had filed an application that this is my first attempt, you would not have got a site. You quoted the attempt made by your wife.
You will ask me kindly appreciation. In fact, I made my preliminary argument was before the Sonapa court. The last occasion was that. Now, since there was not much application filed by the SC/ST under category 1, they did allow the application. They allowed the allotment of site in respect of category 1. Therefore, subsequently they issued the allotment letter.
ತೋರ್ಸಿ ಅದಕ್ಕೇನು ಮೆಟೀರಿಯಲ್ ತೋರ್ಸಿ.
ಅದಕ್ಕೋಸ್ಕರನೇ ಅಮೌಂಟ್ ಕಟ್ಟಿಸ್ಕೊಂಡ್ರು. ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಇದ್ದಿದ್ರೆ they would not have asked me to deposit the amount. In fact, as and when I made the deposit, I wrote a letter to the BDA.
If you have something like that, you please produce material.
ಅಲ್ಲ, ನಾನು every time the amount deposit ಮಾಡಿದಾಗ ಲೆಟರ್ ಬರೀತೇನೆ. ಲೆಟರ್ ಬರ್ದಾಗ ಕೂಡ in fact I have produced those letter also. You also kindly look at ನಾನು ದುಡ್ಡು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾಗ ಅನೆಕ್ಷರ್ ಎಲ್ ಅಲ್ಲಿ 3/3/2021 ನಾಡಪ್ಪ ಕೆಂಪೇಗೌಡ.
I asked you whether you had a site.
And I have said,
not because to disentitle you, but because to ensure that you have some place to live. By denying the benefit of this allotment, the roof over your head.
10(3) ನಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ, in fact, you will kindly appreciate now.
Correct. ಏನ್ ಮಾಡಕ್ಕೆ? Mistake is a mistake. You can't benefit from a mistake. You can't benefit from a mistake. Next ಬೇಕಿರುತ್ತೆ apply ಮಾಡಿ. The client is here. Dr. Mogappa.
Dr. Vijay Kumar. G.
He is late. My father's.
Dr. G. Kumar. ಏನ್ ಮಾಡೋದು? How to help you? There's no way to help you. There's no way to help you.
Initially first instance we ಕಟ್ಟಾಗ ಇದು ಮಾಡ್ಬೋದು.
ಕರೆಕ್ಟ್. ಬಟ್ ನೀವು ಹೇಳಿಲ್ವಲ್ಲ, ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ ಅವರು ಸುಮ್ಮನೆ ಇದ್ರು. ನೀವು ಸುಮ್ಮನೆ ಇದ್ರಿ, ಅವರು ಸುಮ್ಮನೆ ಇದ್ರು. ಅವ್ರು ದುಡ್ಡು ಬರ್ತಿದೆ ಅಂತ ಒಳಗೆ ಈಸ್ಕೊಂಡು ಒಳಗೆ ಹಾಕೊಂಡ್ರು. ನೀವು ದುಡ್ಡು ಕಟ್ತಾ ಇದ್ರಿ ಅಂತ ನೀವು ಕಟ್ಟಿದ್ರಿ. ಏನ್ ಮಾಡಕ್ಕ? ಮಿಸ್ಟೇಕ್ ಅಲ್ವಾ ಸರ್? ಏನ್ ಮಾಡ? ವಾಟ್ ಟು ಡೂ? There are poor people than you. There are poorer people than you. Take back your money along with interest. Huh?
That's the only possible.
That is the only thing possible. There is no other way to help you.
Our direction ಕೊಟ್ರೆ ಅವರ. In fact, they have allotted the site has not been cancelled. In fact,
correct. But then it is treated as his first attempt. First attempt ಗೆ ಸೈಟ್ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ? ಕೊಡ್ತಾರಾ? ನಾ 3 ಅಟೆಂಪ್ಟ್ ಮಾಡಿದ್ರೆ ನಂಗೆ ಸಿಕ್ಕೇ ಇಲ್ಲ ನನಗೆ. This is my third attempt I have made. I have not got a site.
ಈಗ ಕೊಡ್ತಾರ ಸಮೇತ. ಈಗ ಕೊಡ್ತಾರ ತಮ್ಗೆ.
ಇವಾಗ I can't apply. That is the position. What to do? Yes, return the money with interest, mister.
Not in exceptional cases.
How much interest? ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀರಾ? What is the amount paid?
23 ಲಕ್ಷ.
Pay it along with interest.
In exceptional cases where
12% interest.
9%.
Right, 12. ಮತ್ತೆ ನೀವು ತಗೋತಿರಲ್ಲ.
ಕಮರ್ಷಿಯಲ್ ರೇಟ್ ಆಗುತ್ತೆ. ಕಮರ್ಷಿಯಲ್ ರೇಟ್ ಆಗುತ್ತೆ.
Commercial rate is 15 or 18%.
Commercial loans ಎಲ್ಲ 12, 13. ಅದು open market loan.
Correct, but look, if
I
you had
understand.
invested the money in then, you would have bought a site somewhere.
I am not going to argue the matter.
Give
I'm just
12%
wanting to
interest.
request your lordship to show some reduction in the interest amount.
No, no,
ಅಲ್ಲ ಅದಕ್ಕೆ ಏನಕ್ಕೆ ಅಂತಂದ್ರೆ
no, no.
No, may-
you don't want
No, may I make one submission?
Oh, correct, 2000, ಯಾವಾಗ ಅಲಾಟ್ ಆಗಿರೋದು?
2018 ಮಲ್ಲ.
18.
18.
ಮತ್ತೆ ಇವಾಗ if you, after 5 long years, if you raise some
ಅದು ಅದ್ರ
ದುಡ್ಡೆಲ್ಲ ಇಸ್ಕೊಂಡ್ಮೇಲೆ ಸಡನ್ ಆಗಿ ಇಲ್ಲ ಬರಲ್ಲ ಅಂತಂದ್ರೆ
ಇಂಟ್ರೆಸ್ಟ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಸುಮ್ಮನೆ ಫರ್ದರ್ ಲಿಟಿಗೇಷನ್ ಆಗ್ಬೋದು.
ಫರ್ದರ್ ಲಿಟಿಗೇಷನ್ ಏನಾಗಲ್ಲ. You challenge the, if you want to challenge, you can challenge the interest portion.
ಬೇಡ ಅಂತ ಅದಕ್ಕೆ ಅಷ್ಟೇ. ಅದು ಏನಾಗುತ್ತೆ ಇದಾಗ ಇಂಟ್ರೆಸ್ಟ್ ನಾರ್ಮಲ್ ಆಗಿದ್ರೆ ಕೊಡ್ತಾರೆ, ಜಾಸ್ತಿ ಇಂಟ್ರೆಸ್ಟ್ ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ ಮತ್ತೆ ಲಿಟಿಗೇಟ್ ಆಗುತ್ತೆ. ಐ ಆಮ್ ಸೀಯಿಂಗ್ ದಿಸ್ ಜೆಂಟಲ್ಮನ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇನ್ ಫ್ರಂಟ್ ಆಫ್ ದಿ ಲಾರ್ಡ್ಶಿಪ್ಸ್. I don't know argue the matter on merits. Just that nominal interest are payment agate.
Nominal
ಜಾಸ್ತಿ ಅಂದ್ರೆ FM section ಅಲ್ಲಿ if they feel that it is slightly higher, they will request for
you challenge it, ಬರ್ಕೊಳ್ಳಿ.
ಆ ತರ ಅಲ್ಲ,
ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಬರ್ಕೊಳ್ಳಿ.
ಆಗಬಾರ್ದು ಅಂತ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
12% interest. The petitioner
Make one last end or not.
Court
order ಇದ್ರೆ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ, ಕೊಡ್ತಾರೆ, ಸೈಟ್ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಅಲ್ಲ. Even for the first attempt also there are instances, but I could not lay my hand. There are instances where
there are instances, I don't say no, but then this is not a case where it was granted on that ground. It is granted on the ground that this is second attempt.
Even in the act also it provides.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಮೇಲೆ ಮಾಡಿಲ್ಲ. ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಮೇಲೆ ಯಾವ ತರ ಮಾಡಿಲ್ಲ. ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ದು ಅಟೆಂಪ್ಟ್ ಕೌಂಟ್, ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ದು ಅಟೆಂಪ್ಟ್ ಕೌಂಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಇದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ people will start selling their attempts. ಇದು ನಿಮ್ದು ಎಸ್ ಅಂದ್ರೆ ಅಟೆಂಪ್ಟ್ ನ ಸೇಲ್ ಮಾಡಕ್ ಶುರು ಮಾಡ್ತಾರೆ.
ಇದರಲ್ಲಿ ಇನ್ಫ್ಯಾಕ್ಟ್ BDA Act also rules also provides not the age also can be taken into consideration for allotment of site in the first instance.
Yes, yes. ಏನ್ ನೋಡಿಪ್ಪ, ತಿರ್ಗಿ ನಾನು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ತಿರ್ಗಿ ಅದು ಇನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನಕ ಹೋಗುತ್ತೆ. If you want to take the chance, you can take. ಇಲ್ಲ ಒಂದು ಅಲರ್ಟ್ ಮಾಡಂಗಿರ ಮಾಡ್ರಿ ಎಂತದು
ಇದು ಏನಾಗುತ್ತೆ, this will give a new way for people in BDA to exploit. I hope I am able to tell what I want to say is there in my mind.
Switch off the mic and tell.
ಆಗ್ತಾ ಇಲ್ಲ, ಅದು ಆಫ್. ಆ ಇಂಟ್ರೆಸ್ಟ್ ಹೇಳೋಣ ಅನ್ಕೊಂಡೆ, ಸ್ವಿಚ್ ಆಫ್ ಆಗ್ತಾ ಇಲ್ಲ ಇದು.
ವಾಟ್ ಈಸ್ ಎ ವೈಫ್? ಏನ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್? ಮತ್ತೆ ಬರ್ಕೊಳ್ಳಿ. ಸಾರಿ. Find out, find out, ಬರ್ಕೊಳ್ಳಿ. Learn counsel for the respondent seeks time. Learn counsel for the respondent seeks time. List on when? Tuesday, Thursday. Yeshu Baba.
Yeshu Baba or Misra.
My lords may have the matter on any date after tomorrow.
Learn counsel for the petition seeks time. List on after 2 weeks. Submit, yes. How many cases have you filed?
I'm filing with list of other cases.
You please give the list.
49.
Third.
Along with this, the other.
List along with how many cases are there?
5.
4
or 5. Not 5.
List tomorrow. List tomorrow along with so and so cases. Yes, Kumbar. Mr. Kumbar.
Kumbar Vasan. 050. Seeking seeking direction.
Mandamus for what?
Mandamus for bigger
I have been alerted site has been registered. Subsequently, the respondent number 3 submitted a modified plan.
Fencing put up around the area, which is
Modified plan has been passed by this honorable court. According to the,
Yes.
May I say, madam, the petitioners were allotted sites for a society as BD approved layout. Particularly modified plan is taken. Modified panel our sites nalla park matte CA anta torsodru. That modified plan has been struck down by this honorable court in a writ petition, which has been upheld. Now the modified plan is gone, their sites stands restored. But the BDA continues to hold it as CA and parks. Therefore, he is taking a mandamus to correct that position. My lord. That is the case. My lord, from November 25, my lords, no, the entire area as a planning authority has been handed over to the GBA, and including the current litigations also are required to be continued by GBA under section 81 of the amended section 81 of the Town and Country Planning Act. GBA needs to be made a party, my lord.
No, but there is no litigation as such.
This area now we have handed over to the entire area as a planning authority. We have handed over to GBA, my lord. If they can make GBA a party, my lord.
You're correct, but NIM plans first seri
my plan is modified plan is struck down, my lord.
Correct, it is struck down, but then in your records, when you're transferring it to GBA, you should have mentioned that this remodified plan is struck down.
That we have done, but this continues.
Please point out that you have intimated the GBA that this modified plan is struck down and therefore the earlier plan has to be acted upon the source.
What we have done, my lord, is that what I had been to BDA for this reason yesterday. I had a word with the TPM. They say that the entire documents, my lord, is now being handed over to GBA.
Fair enough.
I was unable to even access the file, my lord.
Fair enough. You just get instructions that you have informed the GBA that the modified plan need not be given effect to. It is the old plan that has to be given effect to.
Then they were unable to locate the file also, my lord. ಎಲ್ಲದನ್ನ ಕಟ್ಬಿಟ್ಟು ಕಳಿಸ್ತಾ ಇದ್ದೀವಿ GBA. We were unable to even look for the file, sir ಅಂತಂದ್ರು. ಅದಕ್ಕೋಸ್ಕರ ಹೋಗಿದ್ದೆ BDA ನಾನು. ಹೋಗಿ ಮಾತಾಡ್ಕೊಂಡು ಬಂದೆ.
ಏನ್ ಮಾಡೋದು?
I'll once have ordered the engineering section also, my lord, to see if they have any records.
Then why don't you at least implement GBA? GBA or they'll say we are yet to sort out the files. ಇವಾಗ bundle ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. We are yet to sort out the files. We'll see. We'll look into. We'll do that.
May I submit this, my lord? I understand what my lord is saying, but if GBA is impleted, a comprehensive order can then be given by your lordship so that you will not face any further litigation. There are 5 petitions in all. I will also obtain information.
Please implement yaar GBA na?
GBA.
my submission, my respectful submission to Lordship. With regard to allotment side, that is all not in dispute.
ನಾವು ಹೇಳ್ತಿರೋದು ನಿಮ್ಗೆ ಅರ್ಥ ಆಯ್ತಾ? GBAಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ. GBAನ ಇಂಪ್ಲೀಡ್ ಮಾಡಿದ್ರೆ ಇಫೆಕ್ಟಿವ್ ಆಗಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬೋದು ನಿಮಗೆ ಅಂತ.
ಅವ್ರ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿರೋದಕ್ಕೆ ಪ್ರೂಫ್ ಇಸ್ ನಾಟ್, ಇಟ್ ಇಸ್ ಓರಲ್ ಸಬ್ಮಿಷನ್ ಬೈ ಮೈ ಲ್ಯಾಂಡ್ ಫ್ರೆಂಡ್. ಈಗ ಅವರು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದಾರ ಅಂತ ಹೇಳೋದಕ್ಕೆ there is ಸಾಕ್ಷಿ ಇಲ್ಲ, ಪ್ರೂಫ್ ಇಲ್ಲ.
ಆಯ್ತು, ಸಾಕ್ಷಿ ತರ್ಸೋಣ. Want Sakshi, will ask him to get it.
Government notification, I'll produce it, my lord. I'll also obtain instructions from the engineering section.
Learn counsel for the respond number 1 and 2 is directed to secure information whether the lands that are the subject matter of this petition is handed over to the Greater Bangalore Authority. Is list on yavat?
On 10 days time,
whatever date you want. Yes. Chandraya. Chandraya.
Respondent.
Quashing of? What is Annexure A, madam? Who has executed this cancellation? In whose favor?
This is a BDA executed sale deed in 2005 only.
My lord, site was allotted to the petitioner, my lord, and the sale deed was executed. Thereafter, my lord, the petitioner made a representation to the BDA stating that there is a dispute in the site, so allot alternative site. On the base of the representation, my lord, alternative site was allotted. Then the sale deed also executed. By that time, it was after verifying my lord inquiry, it was the petitioner when make the application for the BDA for alternative site, the suit was already dismissed. Therefore, my lord, the BDA has, my lord, the cancelled the alternative site allotment by executing the.
Yeah. But what about the earlier site that was allotted?
ಆ ಸೈಟ್ಗೆ ಇದು ಆಲ್ಟರ್ನೇಟಿವ್
ಆ
ಕೊಟ್ಟಿದೆ.
ಸೈಟ್ ಏನಾಯ್ತು? ಅದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರೆ ಇಲ್ವಾ?
ಅದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇದು ಆಲ್ಟರ್ನೇಟಿವ್ ಕೊಟ್ಟದ್ದು.
ಮತ್ತೆ ಇವಾಗ ಅದು ಇಲ್ಲ ಇದು ಇಲ್ಲ.
Unilateral cancellation.
Madam Barkoli, the petitioners called in question called in question the deed of cancellation dated so and so
15th June 2009
by the respondent registered as document number so and so on 15/6/2009 in the office of the sub registrar Bengaluru Development Authority BDA. She has also sought for it in the nature of prohibition, restraining the respondents from interfering with her possession in the house constructed in site number 4BC 833, which was conveyed to her in terms of the sale deed dated 24/8/2005.
Notice was given to first owner lordship. They are allotted for the MI Puttana Shetty lordship, first owner. From him, he executed sale deed for me lordship on 31/8/2005 only. That's also a registered sale deed.
Yes. But petitioner claims that
I made representation to BDO.
respondent number 1 had allotted a site bearing number 4BC-833 in favor of one Mr. M.I. Pattanna Shetty.
As an alternative site.
Thereafter, the petitioner purchased the said site from Mr. Pattan Shetty in terms of a sale deed dated 31/8/2005. She paid the property tax and obtained her and got her name entered in the records maintained by the Brihat Bengaluru Mahanagar Palike. She also obtained a permission and plan to construct a building thereon, and also raised a loan after mortgaging the aforesaid property with Karnataka State Cooperative Apex Bank. Full stop. She contends that when she tried to raise a loan, education loan for her daughter on the security of the aforesaid property, she found that the respondent number 2 had executed a deed of cancellation dated 15/6/2009, cancelling the sale deed dated 24/8/2005 executed in favor of Mr. Pattan Shetty. Full stop. She therefore submitted a representation to the respondent number 1 on 5/8/2022. She did not receive any communication regarding the cancellation deed dated 15/6/2009. The petitioner is therefore before this court challenging the deed of cancellation. The learned counsel for the petitioner submitted that the respondent number 1 respondent number 2 has no right to unilaterally cancel the sale deed executed in favor of the vendor of the petitioner. She contends that if the respondent number 2 is interested to terminate to restore the is interested to cancel the sale deed, it has to file necessary proceedings before the civil court as provided under section 31(1) and 2 of the Specific Relief Act. Full stop. In this regard, she relied upon the judgment of the coordinate bench of this court in case Raja versus BDA.
Yes.
Full stop. She contends that since the impugned deed of cancellation is without her notice to her and without her knowledge and is done unilaterally, the same is liable to be quashed. Full stop. The learned counsel for the respondent submitted.
He made the application for the vendor of the petitioner made application, my lord, they saying that the site in question is under litigation. But that is a false.
Submitted that the respondent number 1 was perforced to cancel the allotment in favor of Pattanna Shetty, as he had filed an application stating that the allotment made in his favor was under dispute. Full stop. He therefore submits that the respondent number 2.
That suit, before filing the application, that suit was dismissed. There was no litigation either.
Yeah, yes. He therefore contends that the impugned deed of cancellation cannot be upset at the instance of the petitioner. Next para. I will consider submissions made by the learned counsel for the petitioner and the learned counsel for the respondent. Next para. The respondent number 1 and 2 having conveyed the property bearing site number 4 BC 833 to PMI Pattanashetty relinquished all their right in respect of the said property. They did not have any subsisting interest in the said property to unilaterally cancel the sale deed by executing a deed of cancellation dated 15/6/2009. The respondent number 1 and 2 were clearly unaware of the fact that Mr. M.I. Pattanashetty had already alienated the property to the petitioner on 31/8/2005. Full stop. Even otherwise, if the respondent number 2 desired to cancel the sale deed executed in favor of Mr. M.I. Pattanashetty, he could have done so in the manner prescribed under section 31 of the Specific Relief Act and could not have usurped the power to unilaterally cancel the said sale deed. Full stop. This is also the law declared by the coordinate bench of this court in K. Raja versus BDI, referred supra. In that view of the matter, the impugned deed of cancellation dated 15/6/2009, registered by the respondent number 2 as executed by the respondent number 2 and registered as document number so and so and stored in CD number so and so at the office of the Sub-Registrar Bangalore Development Authority is quashed. The respondent number 1 and 2 are directed not to disturb the possession of the petitioner in the site bearing number 4 BC 833 at which area, madam? Where is this site?
HRBR.
At HRBR layout, Bangalore. Yes, Sidramaya. Hi.
May I have your lordships kindly, my lord?
Yes, sir.
Item 56, my lord. Your lordships may recall this is the case in which your lordships had directed the commissioner BDA to file an affidavit undertaking that they will not change the nature of the property. That affidavit was filed. Thereafter, my lord, the work is still going on. Big boulders are there and these JCBs are working on site. I filed IA number 2, my lord. Your lordships may direct that IA to be listed.
My lord, for BDM, my lord. Tuesday, my lord.
No, but then if you're going on with the work despite the commissioner filing an affidavit.
Senior counsel Gurudas Kannur is appearing for behalf of BDM. Senior counsel Gurudas.
Let anybody appear, mister, but once you filed an affidavit before the court that you will not undertake any work, how can you do it?
10 days ago, I filed an affidavit with photographs.
If that is the case, then we'll have to haul up the commissioner. Yeah.
We'll take instructions from it. We'll verify and make a
we'll take serious action against the commissioner if it happens.
If it is found, Lord, your lordship's orders are violated, then Lord, your lordship can take.
Your affidavit, if it is violated, then you will have to take action against the concerned official. Please let us know by tomorrow. Let the commissioner get instructions as to who is doing the work there. Arcol seal number 56. The learned senior counsel for the petitioner submits that despite the commissioner of BDA filing an affidavit that no work would be undertaken in the property in question, large boulders are being brought into the property and work is still going on. Full stop. The learned counsel for the respondent number 1 is directed to inform the commissioner of BDA to get information as to who is carrying on the activities in the property of the petitioner and take necessary action and ensure that the affidavit filed by him before this court is honored in all respects. List tomorrow.
Kindly direct IA to be listed, my lord, tomorrow. IA2 of
71, my lord.
List, officer director to list IA2 of 26.
Serial number 55, my lord.
interim order may kindly be continued.
Interim order is extended. Huh? What
Serial number
lordship judgment?
67, my lords.
Huh? Yeah, BS Sachin. Please get your other side. Get your other side. If your other side says yes, I'll close it. Yes.
Serial number 55, my lord. Sixth time is coming, it is not reaching.
Sixth time, what to do, sir?
71, my lord.
Actually, this is the only thing I have purchased 2 sites through e-auction. I have paid full
50?
amount. 55 serial number. Arts Saniteshwar. So I have paid the full amount. When I
You want sale deed is not executed.
no sale executed, everything is over. So they have, see, even in the encumbrance certificate, my name is appeared. When I applied for Khata, that is coming third party names. So they have given endorsement. These are all the names, Mr. Rahul Dev and Sudhir are coming under that. So I want a number, direction may be given to GT to issue the Khata in my favor.
But then you should make those persons as parties. Should they not be heard?
No, I don't know. The only BDI they have given the letter in their letter.
PDI, Ajay Kumar.
In their letters, 5 times they have taken. Time objections are failed now.
Older matters are there. There are older matters which are awaiting consideration. What to do? ಹಳೆ ಕೇಸ್ಗಳು ಇದೆಯಲ್ಲ ಯಾವತ್ತು next week ತಗೊಳ್ಳಿ. Due to want of time, the petition could not be taken up. List on so and so.
Serial number 71 matter.
One after the other.
Serial number 71, my lord. ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ I have purchased the DDs. They have not giving the numbers. I mean, account numbers.
ಎಲ್ಲಿ ಕೊಡ್ಬೇಕು, ಯಾರು ಕೊಡ್ಬೇಕಾಯ್ತು? Who is your opponent?
ಅದೇ BDS, my lord.
ಮತ್ತೆ BDI ಕರ್ಕೊಂಬನ್ನಿ ಹೋಗಿ. Who is your opponent ಅಂದ್ರೆ BDI ಅಂದ್ರೆ ನಾನು ಏನು? Who is the lawyer for the opponent?
Miss Lata was appearing. Miss Lata.
Serial number
71, my lord. ಅದು DD ಪರ್ಚೇಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ, 1 ತಿಂಗಳಾಗಿದೆ.
ಮುರುಗೇಶ್ ಚರಾಟಿ. ಅದೇನೋ ಅಕೌಂಟ್ ಹೆಡ್ ಅಂತ ಕೊಡ್ರಿ. Tomorrow, he says time is running out.
1 ತಿಂಗಳಾಗಿದೆ ಆಗ್ಲೇ.
There's some division bench order. He has to deposit pursuant to the order of the division bench, but you are not giving the account head in which he has to deposit. Head account number ಯಾವ ಅಕೌಂಟ್ ಈಗ ಯಾವ ಹೆಡ್ ತಗೋತಾರೆ ಅಂತ
ತಗೊಂತಾ ಇಲ್ಲ ಅವರು.
ಯಾವ ಹೆಡ್ ತಗೋತಾರೆ?
ಕೆನರಾ ಬ್ಯಾಂಕ್ ನವರು ತಗೊಂತಾ ಇಲ್ಲ. ಅಕೌಂಟ್ ನಂಬರ್ ಕೊಡಿ ಅಂತಾರೆ.
ನಾಳೆ ಹಾಕಿ ಯಾವ ಅಕೌಂಟ್ಗೆ ಅಂತ ಸೋಮವಾರ ಹಾಕಿ. Yes, next.
Serial number 68.
My lord, serial number 52, my lord.
60. I appear for the petition on 68.3, my lords, where I have sought for a Khata to be issued in my favor.
Take a date, Mr. Whatever date
Monday
you want.
may
Monday, no. Any Thursday, Friday you can take.
My lord, date may be fixed, my lord. Serial number 72, my lord.
Yes, sir. Siddaramaiah.
Kindly have it next Thursday.
Sir, we'll give a date to all cases, and date will not be after 4 weeks. It will be in a week or 2.
Very well.
All cases, date will be given. If you want to collect the dates, wait for some time.
My lords, interim orders, my lords, in
all interim orders will be extended. Please don't mention. All interim orders will be extended. Don't mention. This next query, yes.
One submission. Serial number 61. Previous council has filed a memo of retirement on 23/10/2025.
Yaro?
Dore Raj. Current affair. We are filing the.
What is your name?
Sharat Kumar Shetty.
Mr. Sharat Kumar Shetty submits that he has entered appearance for the petitioner. Office director to check and verify, and if he has entered appearance, to show his name in the cause list after deleting the name of Mr. Dore Raj B.H. Yes, next.
Oblige. Kindly date
Very-
will be fixed. Your.
English ಅಲ್ಲಿ ಹೇಳಿದೆ.
Oblige.
Award bench of the Sambal court has also.
Good deal. This acquisition is under the National Highways Act.
National Highways Act.
Ah.
Just pass on this order, ma'am.
Award bench has also taken the same lead.
May I just pass?
Hmm.
Sir, Sir. My lord, arising out of the Karnataka High Court matter, the Honorable Supreme Court was pleased to dismiss the SLP. However, the question.
No, what was the issue in Dharwad? What was the issue?
Whether the 60.
As the executing court traveled beyond the award, the executive court may consider as not
Court officer.
May I just
Just a moment.
summarize?
Just a moment.
An order copy is there.
15.12.
Hard copy.
Hard copy is there.
15.7 to
Copy has been
15.12. The issues
Kodi.
were.
Yes, please.
Yeah, my lord. In there, the executive court had made section 72 applicable. So that question came in writ proceedings. So this honorable court was pleased to hold that by virtue of the judgment in Tarsan Singh's case, 72, section 72 is in fact applicable and the executing court had not committed any error. This was carried by National Highways Authority to NSLP.
So ultimately, the effect of the judgment was under section 72 it is applicable 9%,
For 1 year, 15%.
15% thereafter. Yes.
Now this question was carried by the National Highways in SLP. There in the fact is after an arbitral award has been passed. Now, in this case, from what I understand of the facts, the petitioners have approached this court directly from the SLO award. So, in respect of the SLO award,
No. Here also arbitration award has been passed.
No, arbitration.
Yes.
So, have you gone in section 325?
No, not.
In fact, that was the challenge that Mr. Sudarshan had made, saying that they have not exercised their remedy before the arbitrator.
Deputy Commissioner has passed the arbitration
So,
award.
13 Act, could National Highways Act could.
Here, the relief they've sought for is in respect of section 80.
Now, please come to section 72.
Section 72.
Collector may be directed to pay interest on excess compensation.
That is the reference code. If the sum which in the opinion of the authority concerned, the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation. Now the reference code has been substituted by the authority in 2000.
Yes.
So then 9% plus 15%. Section 80, if my lord would see, arises directly from a delay in payment of the collector's award.
Section
80.
So please read the proviso to section 72 for a moment.
That is the 15%.
Please read it.
Yes, sir. That says, provided that the award of the authority concerned may also direct that where such excess or any part thereof is paid to the authority after the date or expiry of the period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of such excess or part thereof, which is not paid to the authority before the date of such expiry.
Yes.
Then my lord would see section 80. Payment of interest. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited. Provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of compensation of part thereof which has not been paid or deposited.
So everything is almost similar. See, says 9% from the date of possession and 12% after 1 year, 15% after 1 year. So whether it is the authority or the reference code, interest rate of interest is the same.
My lord, the issue here is that this is the reason I'm suggesting submitting, my lord, because the Allahabad High Court judgment arises directly out of section 80. There, the way the court has made it applicable is to say that interest being part of compensation. from very, very preliminary understanding of the issue, because I'm not arguing section 80 yet. Section 72 is, as I had submitted in the morning, is seized before the division bench in a series of appeals against the arbitral awards that we have filed. In the question of section 80, interest awarded under section 80 is not a part of compensation. In fact, the reading all the judgment of the Kerala High Court says.
What else is it? What else is it?
It's interest on delayed payment. In fact, under the Income Tax Act, it has been found that because of the section 72 interest would be exempted from tax because it's considered to be a part of compensation. But section 80, being interest on delayed payment, is not considered to be a part of compensation.
Yes.
So there are some judgments of the Honorable Supreme Court on this point, but I mean, this is a preliminary submission. I've not verified this position of law.
Anyway, arbitrator ಹೋಗಿದ್ದೀರಾ? Have you gone to?
Arbitrator ಹೋಗಿದ್ದಾರೆ, but they have not challenged the award.
No, Deputy
They
Commissioner.
have not challenged the award before the district court.
Anyway, then
Arbitrator has
that is the
passed-
case, they are entitled to interest in under
Please, my lord.
72.
But under section 72, because now if there is an arbitral award in play, my lord, then they really speaking ought to have maintained an appeal under section 37. The writ court's jurisdiction is not attracted. I had argued this in division.
Please, my lord.
So then the question would be, no, please listen. Question would be, the arbitrator, the authority has applied 1.5 multiplicand.
Once they've exercised the remedy under section 3G5 under section 30,
That has to
only
be-
section 34 they can go. My lord, this very
No,
same
no, in the
question
face of a notification, please listen to me. In the face of a notification issued by the state government, which says that multiplicand on market value shall be 1.5 in respect of properties which lie within 5 kilometers and 2 in respect of properties which lie beyond 5 kilometers.
My lord, as
In
long
the face of that notification, neither the authority nor the reference court can take a decision that this multiplicand can be more than 1.5.
My lord, my respectful submission is this. If in fact one factor of 2 had to be awarded under the in compliance with that notification, both the arbitral court, the arbitral tribunal and the section 34 court and the section 37 court have in fact the power to fix the factor, refix the factor. We have seen any number of cases in which they've done it. In fact, I had argued this very same proposition of law, saying that under section 3G5, if I have not challenged the award, I can come in a writ proceeding. And my lord sitting in division had dismissed my appeals.
Yes.
Saying that writ petition is not maintainable, I should have gone before the section 34 court
District
and then
court.
before the section 37 court. My lord sitting in division bench had, your lordship had passed that order dismissing my writ appeals. The
Yes.
fact is, if they have not challenged it, insofar as the notification is not under challenge before your lordship, the notification passed by the state government is not in challenge. What is in challenge is an award passed by the arbitral tribunal, for which only an appeal under
I
section
remember
34
the matter that you argued before the division bench
Sir.
in Kalburgi
Gulbarga, yes,
was
sir.
on a different
My lord,
context.
no, there also, here, in fact, I
no.
don't know what the date, my lord, the fact
No,
is,
no.
they have in fact, it is not even efficacious alternate remedy, because of the fact that the provisions of the Arbitration and Conciliation Act apply under section 3G subsection 6. Neither the arbitral tribunal nor the section 34 court nor the 37 court is not without the power to refix the factor.
Yes.
If they had challenged the notification passed by the state government, saying that the fixation of 1.5 factor is wrong.
That is not wrong.
That is not their case.
That is
In
not
that
wrong.
case, my lord, they can't scuttle, because then what will happen is, wherever somebody is dissatisfied with the arbitral tribunal's award, if
approach this
this court had in fact in division said, I can't open the door because of,
Yes,
even
Mr. 37 ಏನು ಹೇಳ್ತೀರಾ?
34
My lord, the honorable.
34.
Yes, 34 also. We have taken, honorable Supreme Court has taken a view that under Article 227 of the Constitution of India, this honorable court, where there is an error, my lord, in 9.3, page number 128, may kindly peruse.
In this judgment? In this judgment?
Not in this case, my petition.
Referring you to the writ petition.
My writ petition. I have produced several judgments of the honorable Supreme Court and other courts. This honorable court under Article 227 can rightly interfere where there is a discrimination and where there is a finding in error of facts, without referring the parties to alternative remedy. They have produced several judgments of this
With
honorable
the
court.
greatest respect, I traversed all the Delhi High Court judgments, all the.
No,
other High
I have
Court
produced the
judgments, saying
Supreme
that it is
Court.
maintainable,
I
I
have-
don't have to go to the.
I have produced the Supreme Court judgment number 116 in 9.3.
My lords, the
Supreme
moment
Court judgment alone, you read my.
moment that appellate remedy as provided for 3G5 has been invoked, that cannot be abated. That cannot be set and abated. So that the further remedy as available under section 3G subsection 6 of section 3G has to be invoked, my lords.
No. See, if you
So they
invoke-
can't straight away knock the doors of this honorable court is what my respectful submission is.
Section 34.
Please, my lords.
There are certain guidelines under which power can be exercised.
Please, my lords.
Discrimination is not a ground.
No, refixation.
Discrimination is not a ground.
Very much. It is
No.
redetermination of compensation which includes.
No.
My lord.
Discrimination is not a
My lord,
ground. madam.
absolutely not. There are any number of arbitral awards in which factor has been refixed by the
Yes.
arbitral tribunal.
Yes.
It is not a question of discrimination. If they are able to establish before the arbitral tribunal that or before the section 34 court, that factor, in fact, 34 section, subsection 2 of section 34, this is a ground for interference by the district
Yes.
court. It would be patent illegality on the face of how many cases have we seen, my lord? in
You
which
are right, madam, but then there's this,
My
when
lord,
there's discrimination.
discrimination is now. I was not suited. I was
You're
told
right.
I had-
Honorable Supreme
You
Court
are
has,
not suited on a different ground.
I understand, my lord, Honorable Supreme Court has taken 3 guidelines to interfere under Article 227. One is
As a matter of-
erroneous on account of non-consideration of material evidence. Second is being conclusions which are contrary to the evidence. Based on inferences, there
all
are.
section 34 grounds.
ನಾಳೆ ಹೇಳಿ
The
ಹೋಗಿ.
matter of fact, my lords.
Let's see tomorrow, you please argue to your heart's content.
As a matter of fact, under prayer A, that arbitral award came to be challenged in this writ petition. That was later on subsequently withdrawn by the petitioner. That one particular prayer was given up. Now subsequently, the factor, the multiplicity of factor, what as now canvassed before this honorable court is, despite the withdrawal of that particular prayer, now that has been indirectly urged by the prayer particular C, my lords.
But see, ultimately, I don't know when, I'll send him back to the section 34 petition.
Please, my lords.
He will definitely get it. He will definitely get it and there will be additional burden on you.
It is out of 120 days. He's not.
But if that,
If he's trying to overcome
not either.
limitation by coming in writ proceedings, I was not suited for that reason, my lord, because I was told that I was trying to overcome
No,
limitation.
if he is before the court, if he is in a wrong forum, there's one judgment of Justice Sujata Manohar, which exempts that also.
My lord, I couldn't, no,
Even that also is exempted.
no, my lord, it's not wrong forum. The fact is, section 3G subsection 6 says, subject to the provisions of the NH Act, the provisions of the Arbitration and Conciliation Act of 1996 would apply. There is no doubt that section 3G5, it's an arbitral tribunal.
Yes.
If this court were to open the doors, because in fact, my lord, actually, if my lord, if I'm given to understand correctly, my lord was in the manner in which the court directed me in those proceedings. The court, if 3G5 can be directly impugned before this honorable court. In fact, I placed on record other judgments of other high courts where there was qualified intervention. But this court was categorical. Both the single bench and the division bench were categorical in saying that if 3G5 can be, an award can be directly challenged before this court, then it would give a complete go by. It would in fact cause.
I'll answer your contention. I'll answer your contention.
My lord, my only point is the arbitral tribunal is possessed of the power to refix the factor if discrimination is shown. Because a lot of the refixation of compensation cases is by saying that intavurge ishtu kottidare namge kottilla anta. Arbitral tribunal has considered the material and enhanced the compensation. As a matter of course, many matters.
An alternative remedy is not a bar for exercise, jurisdiction article 226.
I am so sorry. My heart is
efficacious
bleeding
remedy, but
because I had
alternative, but also equally efficacious.
It was through fraudulent compensation, but this court
ನಾಳೆ
said.
ನೋಡಿ ಹೇಳಿ.
My lords, may I just request it to be taken up on Monday. Tomorrow I have got some inconvenience.
My lord, serial number 72. my lord.
ನಾಳೆಗೆ ಹಾಕಿ.
Instead of
ಬಡದಾಗ್ತದೆ.
be taken up on Monday.
ನಾಳೆಗೆ.
My lord, serial
Further
number
hearing.
72.
One submission, the serial
Council
number
is there.
9 may be taken up on Monday instead of tomorrow.
No,
my lords.
tomorrow.
Tomorrow I've got some inconvenience. I'm not going to be in town, my lords.
I don't have any.
My lord, serial number 72.
It's
Council
an
is
earnest
there.
request.
You are two of you.
No, my lord, but
It's an
please
earnest,
have it on Monday.
it's an earnest request, my lords. It's an earnest request. I don't think so, Mr.
No, it will
Siddaramaiah
come tomorrow.
will have
It will
any.
come tomorrow. I have to close it.
Monday, my
Once I
lords, only
dictate
one
it,
day,
it should be
because I've got
closed.
some genuine.
Serial number 72. Council is in the present.
Lords, in accordance with law, my lords,
Huh?
in accordance with law, mandamus.
ಏನದು?
Lords, they have sought
Consideration
for
of
alternate site, my lords, as 72.
72.
Sought for an
They
alternate.
sought
site.
for alternate site.
Yes, my lords. Application is made on in 2002, my lords.
Lords, application of 2002, my lords, will consider in accordance. with law.
Petitioner has sought for writ in the nature of mandamus to direct the respondent to expeditiously consider his claim and allot an alternate site. Consider her claim and allot an alternate site in the same layout.
My lords, petitioner's mother.
By considering the representation submitted by her mother dated 7/7/2025.
My lords, application is filed in 2002, my lords. Later on, her mother expired in 2005, my lords.
Yeah, and also fix the value of the alternate site at the same rate as on the date of the application, that is 14/12/2002. The petitioner claims that her mother had filed an application seeking allotment of a site.
Page number
Please wait, I can read in English.
Sorry.
Then please allow me to read. The petitioner contends that her mother had purchased a revenue site in terms of a sale deed dated 1/3/1996. A revenue site at Ramasandra village in terms of a sale deed dated 1/3/1996. Full stop. She contends that the site where the land where the site was formed was acquired by the state government for formation of Sir M. Visvesvaraya layout in terms of a preliminary notification dated 14/12/2001 and 31/10/2002. Full stop. Following the judgment of a coordinate bench of this court in Junjamma, the mother of the petitioner filed an application before the respondent number 1 on 14/12/2002, registering herself for allotment of an alternate land site. Full stop. She contends that an application in the prescribed form is also filed on the said day. Full stop. She contends that her mother expired on 27/12/2005, and thereafter she repeatedly followed the issue up with the respondents, which did not evoke any response from the respondents. She therefore submitted an application on 27/2/2014, requesting the respondent for allotment of an alternate site. She also alternate site. Petitioner contends that the said representation is not considered, and therefore she is before this court. The learned counsel for the petitioner reiterated the above submissions. The learned counsel for the respondents submitted that the application of the petitioner would be application filed by the mother of the petitioner would be considered, and the representation filed by the petitioner on 7/7/2025 would also be considered. And if the petitioner is entitled for allotment of an alternate site, the same would be done at the rate prevalent at the time of filing the application, that is 14/12/2002. In view of the above submission, this petition is allowed. The respondents are directed to consider the application filed by the mother of the petitioner dated 14/12/2002. And if the petitioner is entitled to allotment of an alternate site, the respondents shall take a decision on the application dated 14/12/2002 and pass appropriate orders. It is needless to mention that while determining the price of allotment of the alternate site, the respondent shall take into account the allotment rates as on the date of the application, that is 14/12/2002, and act in accordance with law.
That cital value of 2002 may be kept open. Because
No, we have held that it's the date of the application. We are held in a series of petitions.
Serial number 15. Serial number 9 may be taken up for Monday, my lords. I'm not going to be in town tomorrow. That's a genuine
Monday. Yes.
Grateful, my lords.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್ ಡೇಟ್ ವೆಬ್ಸೈಟ್ ಹಾಕಿದ್ದೀವಿ